और ये क्या हाल है? इधर तो आ जाओ, तो मिले ही नहीं मिले हमसे। और क्या हाल है? अरे भाई हो बात, और फिर क्या हाल है?
क्या बोल दिया फोटो दी, लेकिन वो तार भी लगाई। शुरू हो रहा है, इसके लिए हम आपको आपसे दिल की गहराइयों से क्षमा याचना करते हैं। मैनी साहब साड़ी भी सुन लो। फ्रेंड्स, आज हम जीएसटी मूट ट्रिब्यूनल के साथ साथ 15 अगस्त को सेलिब्रेट कर रहे हैं। हमारा देश 79th इंडिपेंडेंस डे मनाने जा रहा है, तो हम भी अपना थोड़ा सा हिस्सा इसके अंदर दे रहे हैं। देश को आज़ाद हुए 79 से हो चुके हैं, तो आज़ादी हमें मिल गई है, लेकिन आज़ादी हमें करप्शन से नहीं मिली। एसवी हमेशा यही कहते हैं कि करप्शन को छोड़ दो, और हम उनका तहे दिल से उनकी बात को मानते हैं कि हमने इस चीज़ को बिल्कुल छोड़ दिया है। तो आइए हम सब प्रण लेते हैं कि करप्शन को नो करेंगे, और अपनी जितनी भी हमारी लिटिगेशंस हैं हम उनको मेरिट्स के बेस पे आगे रिप्रेजेंट किया करेंगे। फ्रेंड्स, आज हमारे बीच में गेस्ट ऑफ ऑनर के रूप में अजय सिन्हा जी, नेशनल प्रेसिडेंट ऑफ एसोसिएशन ऑफ टैक्स लॉयर एंड प्रेसिडेंट ऑफ गाजियाबाद टैक्स बार एसोसिएशन हमारे बीच में हैं। मैं उनसे रिक्वेस्ट करता हूं कि वो आएँ डाइस पे। अब मैं रिक्वेस्ट करूंगा जनरल सेक्रेटरी ऑफ एसोसिएशन ऑफ टैक्स लॉयर श्री रजनीकांत वर्मा जी से, वो भी हमारे बीच में हैं, कि वो आए मंच पे। मैं डॉक्टर राकेश कुमार जी से रिक्वेस्ट करूंगा, आए मंच पे। एसवी सर, आपके बिना ये मंच अधूरा है, प्लीज आइए। सर प्लीज, प्लीज सर, मैं यहाँ आपकी बात नहीं मानता बस। आई रिक्वेस्ट कुमार जी भट्ट टू कम ऑन द डायस। अब मैं एक ऐसी शख्सियत को मंच पे बुलाना चाहूँगा जो हमारी ग्राफिक डिजाइनर हैं, हमारी लिटिल चार्मिंग गर्ल निष्ठा गर्ग। ये रही। अरे मत लगे, ये मेरे साथ बैठेगी। इससे पहले हम आज की कार्यवाही शुरू करें, हम सब नेशनल एंथम के लिए खड़े होंगे और मैं सभी लेडीज़ से रिक्वेस्ट करूंगा कि वो फ्रंट रो में आ जाएं। सभी लेडीज प्लीज फ्रंट रो में।
राजमणि ने माफिया चला रखा है ना सब लेडीज का। निश्चय जी आप ही जाएंगे आगे, लेडीज तो आप भी। वंडरफुल। किसने शुरू किया था लेडीज बंद करो उसको बंद करो?
नहीं वो लीड है सर, लीड है, लीड लगा दो।
आवाज आ जाएगी।
हाँ चलो
2 मिनट 2 मिनट। चलिए जल्दी आ जाइए मैडम। स्टार्ट करें, कर दो। अपने आप गाएंगे ना सारे, अगर नहीं चलेगा तो यहाँ से चलेगा ये। डबल क्लिक करो उसको। नायक जय हे भारत भाग्य विधाता पंजाब
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत विधाता जय हे जय हे जय हे जय 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 जय
जय हिंद। जय हिंद।
भारत माता की
जय
भारत माता की
जय
भारत माता की
जय।
वंदे मातरम वंदे मातरम।
थैंक यू ऑल ऑफ यू, थैंक यू वेरी मच। अरे गुप्ता जी वो तुलसी प्लांट बोलो। तुलसी प्लांट बोलो ना। खोल दी, एक देना पकड़ाना। एसवी, आई रिक्वेस्ट एसवी सर टू प्रेजेंट ए तुलसी प्लांट टू अजय सिन्हा जी। विकास फोटो फुल, विकास फोटो। युगल फोटो खींच लो। I request BB Diwan sir to present a tulsi plant to SV sir.
वो पहले वाला तो बिल्कुल आगे लेके दिया नहीं था आपने।
आप लेके नहीं जाते? I request Rajmani Jindal ji to present a tulsi plant to Rakesh ji. I request Khurana ji to present a tulsi plant to हमारे रजनीकांत वर्मा जी. नहीं अभी दो और चाहिए, एक फिर रिपीट कर लेना. I request Rashmi Jain ji to present a tulsi plant to Nishta Garg. अरे मुझे को रिपीट कर लो यार. Gupta ji, I request Gupta ji to present a tulsi plant to Kumarchi Bhatt.
ऊपर ही आ जाता हूँ.
वो कहते फोटो साफ नहीं आती. आज की कार्यवाही में की शुरुआत में मैं बीबी दीवान जी से रिक्वेस्ट करूंगा, वो आएंगे और आज के प्रोग्राम के बारे में आप लोगों के सामने कुछ बातें रखेंगे. बीबी दीवान सर.
Good morning, friends. It is my honor to welcome you all for the 4th GST Moot Tribunal that our group is conducting, and the topic is the most litigation prone and most vexed area of infrastructure, real estate, builders, and the substantive law and rules along with notifications associated with such topics. My colleague Mr. Kumarji Bhatt shall dwell at length on such issues in his opening remarks. On this group, all of us are dedicated to the welfare of younger professionals without any interpretations between advocates, चार्टर्ड अकाउंटेंट्स और कॉस्ट अकाउंटेंट्स. साथियों, इसके अंदर मैं थोड़ा सा एक अपनी भावना के दो शब्द बोलूँगा कि पिछले दौरान कुछ अगर आपने ग्रुप के अंदर देखा होगा तो हमारे कुछ यंग प्रोफेशनल्स जो दिल्ली से बाहर गए, उन्होंने हाई कोर्ट या किसी अन्य कोर्ट के अंदर उन्होंने जब अपील्स को आर्गू करके आए और वो बड़े खुशी से उन्होंने मैसेज डाला कि हमने ये आज केस जीत कर आए हैं. और ये उसी ग्रुप की देन है, हमारे वाले ग्रुप की देन है कि जिसके अंदर उनको जहाँ से उनको प्रेरणा मिली, जहाँ से वो, तो आज हमें यही लगता है कि हमारी ये चीज़ जो ग्रुप की का जो सिद्धांत था वो पूरा हो रहा. द ग्रुप इज ओपनिंग अप न्यू एवेन्यूज ऑफ प्रैक्टिस फॉर यंग प्रोफेशनल्स. वी ट्रेन दी ब्रिलियंट young minds. We use their knowledge or to know more from them and that guide their energies into professional channels. This is the basic philosophy of this group and this shall remain so. अब इसी के अंदर एक और बात आती है थोड़ी सी कि मैं एक इंटरव्यू देख रहा था कैलाश खेर जी का, आपकी अदालत में था, तो उसकी कुछ लाइनें मुझे बहुत अपने ग्रुप के प्रति मदद लगी. उसने कहा थी कि हम सिंगर जो है ना, कोई सिंगर नहीं बनाता. तो उसने मतलब जो बताया कि हम पूरे वर्ष के अंदर एक इवेंट करते हैं या उसके बर्थडे के ऊपर उसकी जो लाइफ के बारे में मुझे भी नहीं पता था। मैंने वो इंटरव्यू देखा तो जब मुझे पता लगा कि कैसे वो सुसाइड करने जा रहा था, मरने जा रहा था, हम उसको चर्चा नहीं करेंगे। सिर्फ 4 लाइनें में उसकी मुझे इम्प्रेस कर गई कि कोई सिंगर किसी को सिंगर नहीं बनाता, और हम एक बड़ा इवेंट्स करते हैं, उसके अंदर सबको बुलाते हैं और उसके अंदर से फिर सॉर्टिंग करते हैं कि क्या है, तो हम उसको जब पूरा बना देते हैं और एक समय के ऊपर हम उसको आसमान में एक आज़ाद पंछी की तरह छोड़ देते हैं। और यही चीज़ आज मेरे बॉस, मैं क्या कहूँ, मैं मतलब भगवान ने मुझे पैदा ही, शायद मैंने अपनी आधी ज़िंदगी उनके साथ बिता दी है, तो आज ये उनका सपना पूरा होने जा रहा है। आज कहते हैं ना, इनका 56 इंच का चौड़ा जो आज ये पूरा हो जा रहा है, जिस उद्देश्य से, जिस भावनाओं से, हाँ 56 से ऊपर कह रहा मैंने, 56, तो वो चीज़ जो है आज इस पेड़ को वो फलते फूलता देख रहे हैं। और ये जो पिछले यंग प्रोफेशनल अभी करके आए हैं और आगे करने जा रहे हैं, एक उन सब के अंदर एक नई चेतना पैदा हुई है पढ़ने की, सीखने की। तो एक उस चीज़ को हम कहते हैं कि हमारा ग्रुप बहुत ऊंचाइयों की ओर चढ़ रहा है और चढ़ेगा। और इसका रीजन कहते हैं कि वी आर ब्लेस्ड विद 2 सीनियर मेंटर्स ऑफ द ग्रुप, आदरणीय श्री हरिश्चंद्र भाटिया जी एंड श्री सुशील वर्मा जी, both advocates. Their guidance and patting on our back help us to do better. And our core team, led by Advocate Narendra Ahuja ji, CA C.K. Gupta ji, Ma'am C.A. Rashmi Jain ji, Ma'am Rajmani Jindal ji, spare no stone unturned to give the best in all what they do. Our honorable judges, actually they should be real-time High Court judges with their intense questioning from both sides and giving their very balanced judgments. Friends, I once again, you are all welcome to the temple of learning, endless learning, and we hope you have already become a part and parcel of this innovative group. Thank you so much.
थैंक यू दीवान साहब। इस ग्रुप के बारे में मैं इतना ही कहूँगा कि इस ग्रुप को स्टार्ट किए हुए 3.5 साल से ऊपर हो चुके हैं, और 3.5 साल से 2 शख्स ऐसे हैं जिन्होंने एक भी क्लास मिस नहीं की, मैं और असवी सर। नहीं, आपने मिस की है सर। तो इस जर्नी के बारे में सिर्फ इतना कहूँगा कि 3.5 आज जाम। चलिए आइए सर।
नहीं है, मतलब कुछ जेड भी था और कुछ वो भी था।
हाँ, एक चेयर बैठी निश्चय बैठो। कुमार जी, अरे नहीं ना, हमारे मेंटर एस.सी. भाटिया जी हमारे बीच आ चुके हैं, और एक हमारे और लेट कमर आए हैं डॉक्टर राहुल कक्कड़ जी। और मैं राहुल कक्कड़ जी से रिक्वेस्ट करूंगा कि हमारे मेंटर एस.सी. भाटिया जी को एक तुलसी प्लांट भेंट करें। अरे यहीं जुड़ा के थैंक यू राहुल जी, थैंक यू वेरी मच। फ्रेंड्स, आज हम लेट हैं तो मैं आज हमारा प्रोग्राम थोड़ा लेट शुरू हुआ है तो मैं ज़्यादा कुछ नहीं बोलूँगा और सीधा अपने कुमार जी भट्ट को आमंत्रित करता हूँ कि वो आएँ। जैसा कि दीवान साहब ने बोला है कि वो आज के इवेंट्स के बारे में या जीएसटी मूट ट्रिब्यूनल के बारे में आपको कुछ बताएंगे। कुमार जी भट्ट, प्लीज कम।
अच्छा, ठीक है। First of all, my salutations to Goddess Saraswati and my gurus. Dear participants and thousands on YouTube live channel. On behalf of Delhi GST Professionals Group, Delhi, India, I feel honored to welcome you all on this momentous occasion for the group when it is conducting its 4th GST Moot Tribunal continuously and with such a huge success. We feel grateful to all of you to take your time off your hectic schedules and in participating this Moot Tribunal physically. About the learnings from this Moot Tribunal, this concept has given younger professionals to self-actualize their talent and shun their inhibitions in appearing before higher forms like tribunals. And this group's Moot Tribunal is a real-like high court for working with full bench of senior members as tribunal judges. The passion, ethos, and philosophy of this group is to encourage young professionals and give them a chance to intellectually develop their talent, adopt litigation as their practice area rather than compliance and filing returns. All orders are prepared by our team, from show cause notices to possible replies, adjudication orders, appeals and appellate orders. This means for each of the arguing counsels, 5 sets of detailed documents were prepared, and these final appeals are available on our website for all of you in India to download in Word form free of charge. Such is the passion of our arguing counsels who give their permission for this great service to all of us. People from all over India come here, and we have over 35 participants who have come from out of Delhi, and above all, this group does not differentiate between advocates and CAs. And altogether offer their pro bono services to professionals with tan, man and dhan. Speaking for today's topic, this moot is dedicated to infrastructure sector, projects and real estate. Though such topic is very vast, still the core team has chosen most critical subjects to debate: joint development agreements and implications, sale of immobile property and its ramifications. What is immobile property and its interplay with functionality test advocated in Safari Retreats case by the Apex Court. Dear friends, this functionality test has been reapproved and confirmed by the Honorable Supreme Court recently in Bharti Airtel Limited. Transfer of FSA and TDR and its taxability. Works contract services and pure services, including Article 243G and Article 243W of the Constitution of India. Concept of composite supply and mixed supply and tax planning angles. Tax evasion, areas of builders, and above all, pre-GST and post-GST contracts and other interpretations. Dear friends, works contract has always remained a litigating subject. It has a checkered history since 1950. In first of the Gannon-Dankerle case, 58, the Supreme Court had held that works contracts are indivisible in nature. Then the constitutional amendment came. Then amendment was again challenged in the second Builders Association case. Then came second Gannon-Dankerle case, and then came the Service Tax Act also but still then imposition of service tax on service proportion became a point of contention. Despite amendments and clarification of disputes persisted, and then came the era of GST in 2017. Dear friends, what to say about our arguing counsels? 2 in-depth sessions conducted for them, each finer point of law explained to them, and they understand it thoroughly. And the revenue side is represented by our senior member, Sushil Verma ji, our mentor. The judges are the finest members and human beings you will come across, and above all, we are blessed by our senior most advocate of India, Mr. Harish Chand Bhatia ji. The core team led by Narendra Ahuja, Chandresh Gupta and Rashmi Jain ji, 1 advocate and 2 CAs, welcome you, and I am more than sure all of you are going back enriched, intrigued and satisfied with the deliberations you are going to witness today. Thank you once again. We are humbled and grateful to you all. Thanks to our professional hosts for the food and arrangements they have made for us. In the next moot shall be on valuation of supply and place of supply. The topics hardly any association has ever discussed or debated yet. Thank you so much from the bottom of my heart to all those who have come in large numbers to attend this moot court. Please be seated patiently and enjoy the real court experience. Jai Hind, Jai Bharat.
What an energy. थैंक यू कुमार जी, आपकी एनर्जी बहुत फ्रेंड्स, अब मैं निष्ठा गर्ग को आमंत्रित करूंगा, वो आए और अपनी भावनाओं को प्रकट करें हमारे ग्रुप के प्रति। निष्ठा गर्ग।
Good morning to all of you. I am privileged to speak before this professional meeting. My gratitude to the core team. Thank you, everyone. I could not have imagined that I will get glued to these wonderful teachers and can't detach myself from them. I may not understand much of the law that's discussed here, but the love, passion, and life skills that we learn here, I could not have visualized even in my dreams. Over the last few months, I see myself change considerably, and the peace, serenity I learned here is indeed God-sent blessings. On this National Day of Independence, I have been given full freedom to do my job for this group. And what to say about SV sir, he is my guiding light. I only wish I could have met him many years earlier. Narendra sir and Rashmi ma'am, your love, care and security makes me feel freely to do my work. God bless India and God bless us all. Jai Hind, Jai Bharat. Thank you, everyone.
Thank you, Nishtha. Thank you very much for such a wonderful deliberation. Now, without wasting time, I request रजनीकांत वर्मा जी, प्लीज कम। 2 शब्द सर। आज आज़ादी का समय सर, 2 शब्द आज़ादी के लिए कहिए।
प्रिय मित्रों, 2 शब्द बोलने के लिए कहा। आज आज़ादी की हमने आज जो शुरुआत की है, 15 अगस्त परसों है। सभी को, आप सभी को उसका लिए हार्दिक शुभकामनाएं। मेरे अपने साथियों की ओर से भी जो आगरा से आए हैं, और इस मौके पर बस यही कहूँगा कि आज ये 4थी मूट ट्रिब्यूनल है। शायद मेरे साथी इसमें इतना इंटरेस्ट नहीं लेते अगर उन्हें यहाँ जो कुछ मिल रहा है वो नहीं मिलता। बहुत ही मेहनत के साथ बिना किसी स्वार्थ के साथ जो सुशील वर्मा जी ने ये मुहिम चलाई है, मैं समझता हूँ कि आगे भी ऐसे ही चलती रहेगी इन्हीं भावनाओं के साथ। बहुत बहुत धन्यवाद।
Now I request our guest of honor, National President Shri Ajay, of Association of Tax Lawyers, Shri Ajay Sinha ji, please come. I request everyone to please welcome him with round of applause.
Hello, thank you very much. Good morning to everyone. Today marks a historic moment for the Delhi GST Professionals Group as they organize the 4th Moot Court on integrated GST issues, including watch contract, government supply, composite supply, mixed supply. The idea of establishing DGST for the enrichment of knowledge in the GST domain was envisioned by none other than Mr. Sushil Verma, mentor, a man deeply committed to the welfare of the professional community. The journey has been challenging, bumpy, and exhausting, but the hope remained strong. Dreams were realized, and the goal of organizing the Moot GST Tribunal has been successfully achieved. The DGST team stands as a dynamic and charismatic force behind this unique accomplishment in India. Few lines in my mind for Sushil Verma ji. अब शेष बचा जीवन जितना बस विद्या को दान करूं, ये सोच मेरी गिर ना पाए, बस ऐसा कोई जतन करूं. Time changes your body and mind in a year. Every cell in your body is a new. Your thoughts and emotions are not same as last year, but you also have the capacity to change the time and make it better. Life is short. Some people wait for good times to arrive for accumulate knowledge together and collectiveness. Few lines of Amitabh Bachchan on knowledge in Crorepati, which he has said on 7 September 2012. जीवन पथ जटिल है, ये कालचर कठिन है, ये पग पग के भेदभाव हैं, रक्त रंजीत पाँव हैं, जन्म से किसी के सर्वांश की छाव है, झूठ के रथ पे सवार डाकुओं का गाँव है, किसी के पास है छल कपट, किसी को रूप का वरदान है, ये सोच के मत बैठ जा कि ये विधि का विधान है. बद रहा है मर्दंग, ये कहता अंग है कि प्राण अभी शेष हैं, मान अभी शेष है, उठा ले ज्ञान का धनुष, उठा ले ज्ञान का धनुष, एक कण भी और कुछ मांग मत भगवान से, ज्ञान की कमान पे लगा दे तू विजय तिलक, काल के कपाल पे लिख दे तू गुलाल से कि रोक सकता है तो कोई रोक के दिखा मुझे, हक छीनता आया है जो अब छीन के बता मुझे, ज्ञान के मंच पर सब समान है, ना रूप काम आता है, ना झूठ काम आता है, ना जाति काम आती है, सिर्फ ज्ञान ही आपको आपका हक दिलाता है. Mr. Sushil Verma ji is himself is an institution, and I hope every person sitting in this hall is impressive with the qualities of Mr. Sushil Verma. He had been with us in almost our National Tax Conference of Association Tax Lawyer India, held at Ghaziabad, Nimrana, Chakrata, Kaithal, except Shimla. The convener Narinder Ahuja was with us at Kaithal and Chakrata. भाटिया जी हमारे बीच में हैं. Few lines for him. Work your way for a cause and not for the applause. Live your life to express and not to impress. I am also proud on the ATL member advocate Bharat Bhushan Devan, who is the advisor of DGST, and I am also proud on the Abhishek Bansal, who is also participate in the Moot Court today, I think so. And the few lines comes in my mind for the whole team of DGST. We shall pass through this world but once. any good things, therefore, that we can do, any kindness that we can show to any human beings, let us do it how, let us not defer or neglect it, for we shall not pass this way again. Thank you very much.
थैंक यू अजय जी, थैंक यू वेरी मच। आपने शायद डॉक्टर हरिवंश राय बच्चन जी की जो पोइम सुनाई है। फ्रेंड्स, हम थोड़ा लेट तो ज़रूर हैं, लेकिन हमने सबको सुना और अपने मेंटर्स को ना सुने तो पॉसिबल नहीं है, तो मैं सीधा एसपी सर को आमंत्रित करूँगा। आइए सर, प्लीज़।
Thank you. My mentor and my guru, S.C. Bhatia sir, Dr. Rakesh Kumar, our chairman tribunal, Mr. K.P. Singh sir, हमारे technical member, and Rajesh Khurana ji has joined back, our permanent tribunal chairman. He was in US. And friends, for 5,000 years, we were ruled by British. And we should be very careful that Donald Trump, with this tactics of mathematics, he cannot depress India. If we have tolerated 5,000 years of slavery and we have moved ahead, we care two hoots for Donald Trump. Whatever he can do to us, he can do. Let's have this willpower and stand by with this diastonic tactics of Donald Trump. He cannot oppress us. With this theme, why I'm saying this revolutionary lines, I'm not a revolutionist, I'm not a politician, is only to see that whatever law is thrown at us, we shall deal with it, honestly, with a lot of perseverance, learning. We will have a great aim in times to come. To achieve a great aim, you have to acquire knowledge. Such forums, together we learn. They provide us knowledge. With this knowledge, you require hard work. If on working day you guys have taken off and come here to acquire knowledge, this is a process of working hard. And hard work, when you have knowledge, when you acquire knowledge, you have great aim, you work hard, there is nobody in the earth who can stop your success. The success is not what you own today. I see a lot of youngsters who talk very fleshy language and behave in a very flashing manner. That is not success. Success is something that stays with you, that gives you peace, that makes you fearless. That is success. When we talk of no corruption, because the material things we acquire through corruption, you may visibly feel successful, but in your heart knows you have been the most unsuccessful person in the world. Because your hard work could not give you anything. I was just reading today morning, somebody in Bombay, tax consultant, has been caught for 73 lakh rupees fraud. He was doing bogus billing of his own client. Let's take a willpower. If we will not go on this path, we shall not get into corruption. Success must stay. And in this group, we have a philosophy. Here we don't win or we don't lose. Like when you are married to your spouse, if she loses, you win, you both lose. If you win, she loses, you both lose. That is the spirit of this group. Here we do not encourage win or loss. We encourage knowledge. And with knowledge, if you work hard, I have seen last 4 Moot tribunals, nobody can see such a transformation in a human being which has happened here in this group for last 4 months. 26 new councils we have tried. People have come from Haryana, Indore, Punjab, UP, and I can tell you their academics are brilliant. There are 2 terms in philosophy. I'm not a philosopher, so don't take me, I'm teaching philosophy. Self-awareness and self-realization. such forums, such moot tribunals make you aware of your capabilities. And most of you, when you come and hear, I'm sure you think, this we knew. We have read this. It is making you aware. But when you stand here and argue a case, you self-realize what is wrong with us. Maybe the court craft, the aggression, the language, the tone and tenor, how to greet judges, how to not address to the gallery as a lawyer. These are self-realization. When you self-realize, it leads to self-introspection. I've done it for 8 years. I don't think there was any more aggressive lawyer than I was in Delhi or in West Bengal. I've argued very hot cases. But I have realized it's not on. So when you have people like S.C. Bhatia with us, Rakesh Kumar, he's not my great friend for last many years. I know him for last 3-4 months only. But they are people of great mettle to learn. I'm not trying to praise them for anything because they have given this group a lot of learning, a lot of passion they have shown. But you must persevere. Success presupposes hard work and perseverance. You must not get in a hurry. In fact, I wrote a message today in my group. Success is not a hurried stuff. It requires patience. If you want to success with a fast chase like a car, you want to sprint and climb. I have seen many people in this our own bar, they have fallen down drastically because they rose very fast. That is not able to succeed. Success is consolidation step by step. That is what success is. Success is not multitasking. I will do insolvency cases, I'll do civil cases, I'll do criminal cases, I'll do GST cases. No, you will never succeed. An era has come where you have to specialize. Like in GST law, if you ask me, I specialize in infrastructure. For last, VAT also, here also, for last 25 years, I don't think I've ever done ex parte cases kind or C-form NII, JNI, I've never done those appeals. Because I want you to focus on what I do. Therefore, these moot tribunals, they only make you aware of your capabilities. Yes, we can draft appeal. We know what are the rules. We know how to fill up a challan. We know how to address the tribunal. So these moot tribunals, as a concept, if I were in your place, I will take you to every village in the country. Because our professions, tax profession, has been sidelined by all by bar councils. They care a shit about us lawyers. So this is a momentum we must carry. Our team will go wherever you want. We don't charge anything. They will spend their own money. But the transformation that is happening here, today also we have around 130 people physically, though it's on YouTube Live. Therefore, friends, especially the youngsters, do not waste your life by working till 9 p.m. That is the most horrendous thing to do in your life. You must live life. जिंदगी से फ्लर्ट करना सीखो. अपनी जिंदगी से बहुत इश्क करो. अपनी किताबों से भी इश्क करो. इश्क वो नहीं है जो अब लड़का लड़की के हाथ पकड़ के घूम रहे गाना गा रहे हैं. इश्क इज ए फारसी वर्ड. It means when you totally surrender to what you do. You can have ishq with your sister. You can have ishq with your mother, friends, your knowledge, your work. But do not waste life sitting till 10 o'clock and your kids waiting, wife waiting. You say, no, what are you doing? अरे मेरे को काम है बहुत. ऐसा कोई आप काम नहीं कर रहे which cannot wait till tomorrow. No lawyer is so busy. I guarantee you the work he does which cannot wait till tomorrow. Therefore, love your life. Sit with your friends. When you have to study, do study. जॉन आलिया के एक शेर है, किसी ने किसी से पूछा, I will end with this, कि दिल टूटा. हम सबके दिल टूटे. फैमिली से, गर्लफ्रेंड से, बीवियों से, हस्बैंड से, सोसाइटी से, दिल सबके टूटे. उन्होंने एक शेर कहा था, तुम जब मुझे मिलने आओगी तो मुझे तन्हा पाओगी. तुम जब मुझे मिलने आओगी तो मुझे तन्हा पाओगी. इस तन्हाई में ख्वाबों के सिवा कुछ भी नहीं. इस तन्हाई में ख्वाबों के सिवा कुछ भी नहीं. तुम मेरे दिल को सजाना चाहती हो, तुम मेरे दिल को सजाना चाहती हो, आ जाओ, इस दिल में किताबों के सिवा कुछ भी नहीं, इस दिल में किताबों के सिवा कुछ भी नहीं. Why I said this share? It's a very romantic share. I've used it in some other context. I changed a little bit language also. Knowledge gives you power. Between husband and wife, if you are more knowledgeable, the knowledgeable spouse shall be respected, honored, because you have knowledge. That knowledge teaches you how to persevere, how to be patient, how to bring up your children, how to bring up your profession. Do not get swayed. Arey, Sushil Verma comes in Mercedes, why not us? He comes in Audi, why not us? No, that's not your job. He gives, you can't earn. God has to give you. So do not compare yourself with your colleagues. Their story they know. Their story you cannot know. Write your own book. Write your own story. Write it beautifully. Well done. Happy Independence Day. Let's call Mr. S.C. Bhatia now to hear him before we start this Moot Tribunal.
सर काउंटर शेयर तो बनता है. नहीं, मैंने कहा काउंटर शेयर तो बनता है.
इतना रोमांटिक नहीं है कितना काउंटर शेयर है, जवानी निकल चुकी है. इतना रोमांटिक नहीं कि काउंटर शेयर डाल सके.
अभी बहुत कुछ है इनके खजाने में. जरा तहखाना खोल के तो देखो.
नहीं. Day before yesterday, I received a call from Mr. Verma. और इन्होंने कहा जी आपने पिछली बार आपने एक राम कथा का किया था केवट के ऊपर, तो इस बार कौन सी कथा? मैं कहा इस बार मैं कुछ भी नहीं बोलूँगा, मैं सिर्फ बैठूँगा और सुनूँगा लोगों को. मुझे कुछ और लोगों ने भी कहा कि जी आपने केवट के ऊपर राम कथा की थी, इस बार आप क्या भरत पर, या क्योंकि मैं कहा था कि मेरे को 3 कैरेक्टर बहुत अच्छे लगते हैं रामायण के, रामचरितमानस में भी और रामायण में, केवट, भरत और शबरी. मैं कहा नहीं, मैं इस बार नहीं बोलूँगा. जब आप कॉन्फ्रेंस करेंगे तो 15-20 मिनट के सेशन में तीनों कैरेक्टर्स पे बोल दूँगा. पर मैंने वर्मा जी से कहा था मैं इस बार कुछ भी नहीं बोलूँगा, मैं बैठ के सिर्फ सुनूँगा. वर्मा जी ने मुझे ये भी कहा कि आप टाइम पर आइएगा, क्योंकि मैं जनरली लेट हो जाता हूँ. ये मेरे में कमी है, मैं मान रहा हूँ. मैंने शायद लाइफ में ऐसा कुछ नहीं किया कि जिसकी वजह करके मुझे शर्मिंदगी होनी पड़े, पर 3 चीज़ों की वजह करके मैं शर्मिंदा होता हूँ. एक, मैं लेट हो जाता हूँ. जितनी मर्जी कोशिश कर लूँ कुछ ना कुछ देर हो ही जाती है. एक, मेरी हैंडराइटिंग सिवाय इस, मैं समझता हूँ कि 3 लोगों के और चौथा कोई पढ़ नहीं सकता जो वो देख रहे हैं. पर मैं एक बात कहूँगा, वर्मा जी, he is not only teaching you law, what is more important is that he is teaching you lessons of life. How one should lead the life, that he is teaching you. इनके लिए जितना कहा जाए मैं समझता हूँ कम है. पर मैं दावे के साथ ये कह सकता हूँ कि सारे हिंदुस्तान में जितनी मर्जी बार एसोसिएशंस हों, बार काउंसिल्स हों, हर स्टेट की बार एसोसिएशंस मोस्टली स्टडी सर्कल मीटिंग्स करती रहती हैं, कॉन्फ्रेंसेस करती रहती हैं. बट व्हाट ही इज़ डूइंग, no other bar association or bar council in India is doing or can do. मतलब जितना भी कहा जाए, मुझे लगता है, मैं अपने दिल से, अपनी आत्मा से कह रहा हूँ ये बात, कि ऐसा किसी ने न आज तक किया, न कोई और कर रहा है, न कर सकेगा, कर पाएगा. हम आज जब मैं आ रहा था, मैं कोशिश तो मेरी थी कि मैं टाइम पर पहुंच जाऊं. मेरा ड्राइवर कुछ लेट हो गया, कुछ रास्ते में आज जगह जगह के ऊपर, कम से कम 6 जगह पे हमें ये लगा कि ट्रैफिक जो है पुलिस ने maybe it was because of security reasons, although 15th August is only day after tomorrow. कुछ उसकी वजह करके लेट हुआ. कुछ हमारे राजकुमार राहुल कक्कड़ जी नीचे मिल गए, 20 मिनट इन्होंने देर करवा दी अंदर आने में और ब्रेकफास्ट कराने में, इसलिए कुछ लेट हो गया. Friends, day after tomorrow we are going to celebrate our Independence Day, 79th Independence Day. At this juncture, I am reminded of iconic words of, these are historic words, iconic words of Pandit Jawaharlal Nehru on 15th of August 1947. This is only one sentence I'll narrate from his speech. He says, from the ramparts of Red Fort, he said, "At the stroke of midnight hour, when the world sleeps, India will awake to life and awakening." एक शायर हैं वर्मा जी के बहुत फेवरेट हैं, राहत इंदौरी साहब. उनकी दो लाइनों को मैंने थोड़ा सा एक आध वर्ड बीच में सिंपल करने की कोशिश की, क्योंकि एक जगह वो कहते हैं पेशानी, पेशानी कहते हैं माथे को. तो दो लाइनें हैं उनकी. मेरे मरने के बाद मेरी पहचान लिख देना, लहू से मेरे माथे पे हिंदुस्तान लिख देना. और मेरे को ध्यान है, जब मैं बच्चा था स्कूल, मे बी 10th 11th और मे बी फर्स्ट ईयर ऑफ कॉलेज, एक बहुत पुरानी शहीद पिक्चर आई थी जिसमें दिलीप कुमार थे. उनका एक गाना मेरा हमेशा से बहुत फेवरेट रहा है, एक लाइन उसकी भी बोल देता हूँ. वतन की राह में वतन के नौजवान शहीद हों, वतन की राह में वतन के नौजवान शहीद हों, पुकारते हैं ये ज़मीन आसमां शहीद हों, पुकारते हैं ये ज़मीन आसमां शहीद हों, वतन की राह में वतन के नौजवान शहीद हों. 2 मिनट और भी बोल नहीं नहीं नहीं, पर ऑलरेडी लेट हो रहे हैं.
सर अभी तो हमने गजल.
अच्छा वर्मा जी से, अच्छा, तो इसके बाद ही सुनाएंगे. देखिए, एक बात जो वर्मा जी कहते हैं, मैं खुद ये मानता हूँ कि वी शुड ऑल बी फुल ऑफ ग्रेटिट्यूड. मैं तो खुद ही अपने लिए समझता हूँ कि शायद जितना हम डिज़र्व करते हैं भगवान ने उससे बहुत ज़्यादा हमारे को दिया. वी ऑल आर ब्लेस्ड. नहीं तो अपने आसपास देखें क्या दुनिया के अंदर है और क्या हालत है दुनिया के अंदर. तो इसलिए सिर्फ एक उसके अंदर कंडीशन है, दैट वी शुड हैव अनफ्लिंचिंग फेथ इन गॉड. जिसको भी हम मानते हैं, अगर वो होगा तो हमें सब कुछ मिलेगा. इसी के ऊपर 2-4 लाइनें मैंने सुनी, मेरे को बहुत अच्छी लगी थी, और वो तो मैं गा सकता नहीं, उन्होंने गा के भी बहुत अच्छा गाया बोला हुआ है. न सबूत है न दलील है, न सबूत है न दलील है, न सबूत है न दलील है, मेरे साथ रब जलील है, मेरे साथ रब जलील है, न सबूत है न दलील है, तेरी रहमतों में कमी नहीं, तेरी रहमतों में कमी नहीं, तेरी रहमतों में कमी नहीं, मेरे एहतियात में ढील है, मेरे एहतियात में ढील है, न सबूत है न दलील है, तेरा नाम कितना है मुख्तसर, मुख सर कहते हैं छोटे को। आप बोले राम, कृष्ण, राधा, अल्लाह, वाहिगुरु, बहुत छोटे नाम हैं। तेरा नाम कितना है मुक्त सर, तेरा नाम कितना है मुक्त सर, तेरा नाम कितना है मुक्त सर, तेरा तेरा नाम कितना है, तेरा जिक्र कितना तावील है। तावील कहते हैं बहुत बड़े को, कि नाम तो इतना छोटा सा है और अगर जिक्र करें तो वो कहते हैं जी मैं धरती को भी अगर कागज़ बना दूं और समुंदर की स्याही बना दूं तब भी मैं आपके बारे में नहीं लिख सकता। तेरा नाम कितना है मुक्त सर, तेरा जिक्र कितना तावील है। कितना बड़ा है। आपके ऊपर देखें, राम के ऊपर ही, राम लक्ष्मण सीता के ऊपर, हमारे यहाँ 100 से ज़्यादा तो रामायण हैं जो हम जानते हैं, उससे भी ज़्यादा हैं, और फिर भी हमें लगता है कि हर रामायण को पढ़ेंगे उसमें कुछ, किसी भी उसको पढ़ेंगे उसमें कुछ न कुछ नया हमारे को मिलेगा। इसीलिए कहते हैं तेरा नाम कितना है मुक्त सर, तेरा जिक्र कितना तावील है, न सबूत है न दलील है, मुझे कौन तुझसे अलग करे। हम बहुत बार मानते हैं कि हमारे अंदर भी, सबके अंदर उसका एक अंश है। मुझे कौन तुझसे अलग करे, मैं अटूट प्यास तू झील है, मैं अटूट प्यास तू झील है, मैं अटूट प्यास तू झील है, न सबूत है न दलील है, न सबूत है न दलील है, न सबूत है न दलील है।
थैंक यू सर, थैंक यू। फ्रेंड्स, इस सेशन के अंत में मैं आपको एसवी सर के 2 क्वेश्चंस के जवाब दूंगा कि किताबों से इश्क करो। सर 3.5 साल से किताबों से इश्क करते करते बीवी से इश्क करना भूल गए सर। सर सुबह 6 बजे उठते हैं, रात को 1 बजे सोते हैं, बीवी तलाक दे देगी अगले 3.5 साल बाद। तो दूसरा क्वेश्चन कल सर ने दूसरा क्वेश्चन सर का ये था, कल ग्रुप में सर ने पूछा था कि आप लोगों की एक्साइटमेंट खत्म हो गई है। सर एक्साइटमेंट इतनी है कि आज मैंने नई शर्ट खरीदी थी, मैं उसकी पैकिंग निकालना भूल गया। कल कोट ड्राई क्लीन करके मंगाया था, उसका लेबल भी आज मेरा शाम को मैंने यहीं आके उतारा। सर इतनी एक्साइटमेंट है। तो सर फ्रेंड्स, आप सभी का स्वागत है। अब मूट ट्रिब्यूनल से पहले शुरू करें हम। सर ने हमें प्रॉमिस किया था कि आज के दिन मैं एक गज़ल सुनाऊंगा, तो आप लोग तैयार हैं गज़ल सुनने के लिए या पढ़ाई करनी है? तो सर प्लीज़ एक गज़ल हो जाए, क्योंकि गज़लों का दौर चला है। सर आपने प्रॉमिस किया था।
शेयर का काउंटर शेयर आता है और गजल का तो काउंटर गजल तो आनी चाहिए।
Well, before we hear this, whatever little ghazal I can sing, on 20th next month, we'll have a Moot Tribunal on place of supply and valuation of supply. All new chartered accountants and advocates, 4 at least, who want to prepare and argue the appeals, send your name to Narendra Ahuja. On 13th October, this group shall hold a mega event in NDMC Convention Center. It's a full day conference without charge. There are only around 350 seats, and it will be a conference you would have never dreamt. Tax lawyers can hold this kind of a conference. It will be a non-GST conference. It will be for youngsters. You'll come to know diversified areas of PMLA, Black Money Act, MSME Act, banking laws, foreign exchange. There are 6, 7 subjects like this. Labor laws. So which I think I find most of the clients go to other people for these compliances. Little bit knowledge of law. So all my young colleagues, advocates, like I always say, our time is over. So which we could not learn, we want to give it back so that you have more diversified areas of practice, diversified areas of knowledge. And I tell you, it's not difficult. It's easy. So get ready for 13th October. कठिन है राह गुजर थोड़ी दूर साथ चलो कठिन है राह गुजर थोड़ी दूर साथ चलो बहुत कड़ा है सफर थोड़ी दूर साथ चलो कठिन है राह गुजर थोड़ी दूर साथ चलो तमाम उम्र कहाँ कोई साथ देता है तमाम उम्र कहाँ कोई साथ देता है मुझे मालूम है पर थोड़ी दूर साथ चलो मैं जानता हूँ मगर थोड़ी दूर साथ चलो कठिन है राह गुजर थोड़ी दूर साथ चलो अभी तो जलते हैं सारे चराग राहों में अभी तो जलते हैं सारे चराग राहों में अभी है दूर शहर थोड़ी दूर साथ चलो भाटिया साहब भी आपके लिए है अभी है दूर आपका सहारा चाहिए जब तक इस ग्रुप की पूरी सुबह ना हो अभी है दूर शहर थोड़ी दूर साथ चलो कठिन है राह गुजर थोड़ी दूर साथ चलो ये एक पल की मुलाकात भी गनीमत है ये एक पल की मुलाकात भी गनीमत है किसे है कल की खबर थोड़ी दूर साथ चलो कठिन है राह गुजर थोड़ी दूर साथ दिस इज द ग्रुप्स फिलॉसफी कठिन है साथ चलो वी विल अचीव इट थैंक यू
थैंक यू सर थैंक यू फॉर वंडरफुल गजल अब मैं एसपी सर और भाटिया जी से एक रिक्वेस्ट करूंगा कि एक अजय सिन्हा जी को एक मोमेंटो से सम्मानित करें
अजय सिन्हा फाउंडिंग एसोसिएशन ऑफ टैक्स लॉयर्स ऑल इंडिया बॉडी
फोटोग्राफर अभी तो फोटो नहीं अभी ग्रुप फोटोग्राफ नहीं अभी फोटो ले लेना आज हमारी कोर कमेटी का काफ़ी जिक्र आया था तो मैं अपनी कोर कमेटी के सभी मेंबर्स को एक रिक्वेस्ट करूंगा कि सामने आए एक ग्रुप फोटो के लिए कोर कमेटी के सभी मेंबर हमारे आ जाए एसपी सर आप भी आ जाइए सर पीछे आ जाओ हाँ पीछे आ जाओ खुराना जी आप भी आइए सर। आप सर आप बैठ जाइए, आप बैठे रहिए, आप बैठे रहिए, आप बैठ रहिए, सब पीछे आ जाएंगे। हमारी कोर कमेटी के सभी मेंबर्स प्लीज कम ऑन द स्टेज, ऊपर आ जाओ। मैं तो आ ही रहा हूँ, मेरे बिना तो आपकी फोटो अधूरी हो जाएगी। तो फ्रेंड्स अब मूट ट्रिब्यूनल का टाइम है। थैंक यू ऑल ऑफ यू, थैंक यू वेरी मच। ठीक है, अभी बुलाती हूँ। बुलाओ जी जी को, किस के बुलाओ। कौन कौन है? राकेश जी से बुलवा देता है। राकेश जी प्लीज 2 मिनट हो जरा। अंकित मित्तल जी एंड पूनम मारवा जी।
लोग इतना चाहते थे आपको, आज भी इतना चाहते हैं, ये तो कमाल की बात है।
और इसी वजह करके जो आप बात कह रहे थे कि मैं आपके साथ रहूंगा till the end of my life।
गॉड ब्लेस यू सर।
पूनम मारवा जी आप भी आइए प्लीज। राकेश जी पूनम मारवा जी को। तो फ्रेंड्स इससे पहले हम मूट ट्रिब्यूनल, हाँ कोई नहीं, मूट ट्रिब्यूनल स्टार्ट करें। अपने अपने फ़ोन स्विच ऑफ कर लीजिएगा प्लीज, या साइलेंट मोड पे कर लें। युगल टू टेक ओवर द स्टेज।
थैंक यू।
जितना कर सकते हो करिए।
Well friends, before we start the Moot Tribunal, let me brief you what is the importance of today's subject.
सर 2 मिनट जज साहब को बुला लें।
हाँ बुला लो।
आइए हमारे सेकंड जज साहब केपी मित्तल जी।
केपी सिंह साहब।
अंकित मित्तल से केपी मित्तल याद आ गया।
कुछ एक्साइटमेंट ज्यादा तो नहीं होगी ना?
ज्यादा हो गई।
क्या कोई नहीं, बैठे बैठे बैठिए ना आप।
फ्रेंड्स आज की आगे की कार्यवाही हमारा यंग एंड एनर्जेटिक सीए युगल गोयल जी संभालेंगे। युगल प्लीज कम।
Yugal, before you take over, give me 5 minutes. What we are going to debate today is infrastructural related issues. What we used to know in sales tax and VAT 46 amendment, works contracts. That theory of works contract is completely obliterated from GST law. The definition has no meaning, whether in central laws or local laws. A works contract is defined in section 2119. It's a means definition. That is, what is written there, that is the only works contract. It has not taken into account the constitutional provisions of works contract. Article 2, 46th Amendment, we had various kind of laws coming up. Like Kumarji Bhatt said, Gandan Dankar, it has no meaning. In GST law, there is nothing indivisible. Everything is divisible. That's the default rule of law. Here, works contract is defined by 12 type of contracts in section 2119. All those contracts are not defined in the Act. But in the next newsletter, I will write a detailed article giving you Supreme Court judgment definitions of these words. All those 12 activities must result into creation of immovable property by transfer of goods and services. That is the only commonality between pre-GST definition of works contract and post-GST definition of works contract is that it shall involve transfer of goods and services. That is, it shall remain a composite transaction, not composite supply. There was a dispute about works contract in pre-GST era, AMC, software, etc. You know that Tata Consult is judgment of 5 judges of Supreme Court. That dispute is taken care of in GST law. Works contract now is a declared composite service. That is why the interplay of composite supply and mixed supply with definition of works contract is very important to know. When we say composite service means it is taxed at flat 18%. Subject to some government notifications, we will take care of that. So if a given transaction in your concept note or a case before you does not amount to works contract, 18% is not applicable. Then you switch over to composite supply or mixed supplies. So that interplay is very important for you. It's going to be the biggest litigation area in the country, I guarantee you. Today you are in 1974 notices. Wait for 1920. I have lectured in DGGI on this issue. They are into very big issues on infrastructure companies. So we should study more and more on this issue. In fact, that should be your focus practice area today. You have done all those ITC, झगड़े बगड़े वो सब Supreme Court judgment के बाद सब खत्म हो जाने वाले हैं. So once you go to composite supply or mixed supply, you can have a 0 tax or 28% tax. That can be the journey from 0 to 28. That is, if you have a composite transaction where the principal supply is 0 tax, all ancillary supplies may be taxable individually at 28%, the whole transaction shall be at 0. This is where you have to read the law. Definition of section composite supply, mixed supply, read with section 8 of CGST Act. And if your analysis says this is a mixed supply, then the highest rate shall apply to the entire gross value. That is, even if 28% material is just 0.002%, the whole transaction shall attract 28%. Now this is where the role of professionals come. How do you guide your clients? How should they structure this transaction? If you do not have knowledge, if you do not appreciate these issues, the government is the biggest spender. and all these contractors provide services to the government, state government, government entities, or whatever. So if there is a government, central government, there is a local authority or a state government, and for your information, the definition of government you have to read from CGST law. State government is not defined in GST law. They have defined only central government. So state government, you have to go to section 3 General Clauses Act. What is the definition of state government? Local authority is only that what is defined in section 2, notwithstanding whatever any judgment may say. So you have to pick up judgments in GST era only, because pre-GST era definition may not have been the same, the context may not have been the same. Many times I hear youngsters, सब वो उसमें भी यही word लिखा है. You don't read a judgment with particular reference to a word. You read the judgment with a material provision and the context in which the judgment was given. So interpretation counts there. Works contract may have been defined in Income Tax Act. That definition has no meaning in GST law. But the taxable events are different. The scheme is different. Therefore, you have to understand this, that if these services are rendered to government, state government, whatever we discuss, local authorities, which are specified in Article 243 G and W, and those agencies to whom you are rendering the services, they are under a constitutional mandate to render those services. Only then we say this is a pure service, and this can be zero tax. And by amendment to notification 1217, they introduced an entry 3A, which says if in these kind of pure services transactions, so pure service, zero tax, only in relation to Article 243D, 243W, not otherwise, not the private transactions. So we will come to know how do we read these kind of provisions in GST mechanism. Can we say this is a zero transaction? Now the risk is what? A half-buck knowledge is a killer for the client. It's my default rule of law. If you tell a customer, your client, that this is 0%, based on whatever opinion you have formed, if after 6 years this was not 0%, that client will have to run. There's nothing you could do. Therefore, you have to read. Like the other day Mr. Bhatia told us, we have to learn to read the raw law. There is nothing which any judgment can teach you, I can tell you. A judgment only interprets a legal provision. And we are all capable. I tell you, I mean, I'm trying to pat on my back. Let me self-pamper myself. We had a session on works contract for our core team. There were arguing counsels also, people came from Agra also. I told them Safari Retreat functionality test will be upheld. Then came Bharti Airtel judgment after 6-7 days. Rajmani Jindal called me, this is what we discussed. That is, if you have read the law carefully, read Safari Retreat's 92 pages carefully, you don't have to read anything in GST law on that topic of infrastructure. We are going to discuss this, what is the meaning of functionality test. This means even if you are creating that plant or machinery for the purpose of your own business, input tax credit will be available to you, which otherwise 17.5 C and D bar. So the Supreme Court has redefined what is the meaning of those two exclusion clauses in these provisions. Section 17 generally deals with ITC which are blocked, 17.5 especially. But there Supreme Court says you are entitled to input tax credit. Then we'll come to what is immovable and movable. Again, shockingly, both these words are not defined in the Act. By default, all indirect taxes are levied only on goods or services in GST law, or a composite thereof, but they all remain movable. So if something has become movable and you sell thereafter, no tax is attracted. If no tax is attracted, no input tax credit also is attracted. So we will go into a concept which Narendra Ahuja is arguing. if I sell a semi-constructed property for which there is no completion certificate obtained and no OC obtained, can this still be movable, notwithstanding the definition given in schedule of CGST law? We shall discuss this. We will also discuss, which Rashmi Jain is arguing, she is arguing one of the appeals of her lifetime, I can tell her. She is going to argue functionality test. Then we have a part appeal from last Moot Tribunal. Renu Sharma is arguing 4 questions on exports. If a ship is sunk, will you get refund? So this involves interpretation of definition of supply, section 16, section 17, and section 16 IGST Act. There's a lot of interplay happening there. She is also going to argue, if there are 3 parties, can we still say there is no intermediary? So those are controversial questions you are going to see today. And then Rajmani Jindal, she is our star mafia of this group, star also and mafia also. She is also going to argue an appeal where she is going to invoke exclusion of time taken in rectification proceedings. That is MP Steel General Corporation by the state of MP, Supreme Court of India. So will the judges condone that delay? We'll have to wait and see. I'm sure our judges have read all those cases. Then my friends from Abhishek and his colleague from Agra are going to argue transfer of developmental right in a pre-GST era, post-GST era. That is, you will have a session on contracts interpretation. How do you interpret a given contract? Most of us are very poor in reading. If it's a 100-page contract, you have to read. You can't pick up one clause and say, oh yes, I got it. No. These contracts are not statutory contracts. These are private contracts. Whatever you write is binding on both the parties. You can't say the tax rate is changed, so give me tax rate if there is no clause in the Contract Act. Tax may go up 100% up, you will not get it. Like yesterday I lectured in one of the export associations towards evening, and they said, can we transfer this 50% tariff to the importer? I said, what's your contract? They said, nothing, make nothing, you have to pay. Or he will not charge, he will not give you more price. That is, once you are drafting contracts, be very careful. In this kind of country, in developing economies, tax rates can change on a flash. Government says, paisa nahi aa raha, tax rate change kar do. So what is the ripple effect of those changes on your contracts? You have to have contractual clauses right in your contract. And another appeal which we are really going to argue is, what is the meaning of a government? That appeal I shall be arguing as an appellate counsel if we find time at the end. You'll have to wait if you want to hear that appeal. So what is the meaning of a government? And can, even if I satisfy all the conditions of a notification and the judges hold this is not a government, 243 you are ruled out. You will be taxed fully. So that is something which will be quite a risky affair. The kind of appeal I am going to argue is only simple this concept. So transfer of development rights, joint development agreements between builders and landowners. What are the implications? So these are 7 issues. There are around 16 issues in this area which are very controversial. But 7 are the most important areas where in this country you are going to face a huge litigation. I can guarantee you, इससे बड़ा litigation इस देश में नहीं होगा. इंफ्रास्ट्रक्चर में बहुत पैसा है. बड़े कॉन्ट्रैक्टरों ने जीरो, मेरे पास कुछ ओपिनियंस हैं, लोगों ने जीरो कर दिया सर, प्योर सर्विस जीरो. वो प्योर सर्विस नॉट फॉर 243 W, प्योर सर्विस जीरो. And now they are facing liabilities worth hundreds of crores, builders. Then we also have a case of builders being argued by a brilliant CA, Vikas Garg, who has tried to innovate the appeal. Let's see whether it holds. How builders evade taxes and what you should know in a transaction where a builder sells a flat. This will involve interpretation of inclusive contracts, exclusive contracts. Inclusive contracts, exclusive contracts. So it's a big session. maybe we'll have a little late, so you will have to have patience. One appeal, CA Gunjan from Indore, he has missed his flight, lost 15,000 rupees today. He missed his flight because his taxi got punctured. That was on unjust enrichment. That is, if you have paid tax under a mistake of law. You have charged the customer. Customer has refused to pay. Sushil Verma tells you this is non-taxable because of fla ruling. Can you get the refund? Notwithstanding limitation under 54th of 2 years. Here you have to read a VK say footsteps Supreme Court judgment by Dr. Chandrachud. All other judgments are at variance with the law laid down on VKC footsteps. So there we have to see whether you can claim refund beyond 2 years, 3 years, 4 years, maybe you are in arbitration. And then Mr. Narendra Ahuja is also going to involve the compensation and liquidated damages received, whether these are taxable. Well friends, you are going to have a very engrossing section. Honeymoon is over for 1 hour. We have heard good ghazals and all good stuff. Now hear the law. And our judges are absolutely ready to punish both the counsels. Whether prepare yourself better. Otherwise, don't enter the tribunal. Let's welcome our 2 judges and let's start the Moot Tribunal. Thank you. My lord, there was a last time order. Rishmi? Okay. हाँ जी आप शुरू करो. रश्मि को बुला लो सर. उसने बड़ी काफी बड़ी की नहीं लगती.
Thank you, sir, for insights on the topic. Good afternoon, everyone. I welcome you all to the 4th GST Moot Tribunal of our group. Let's start. Today, item number 1 by CA Gupta, sir. The matter was kept for order on the last date. The judges will deliver the judgments. Thank you.
I request the arguing counsel CA Chandresh Gupta ji to again read the question of law which he has framed for this court.
Thank you, my lord. With your permission, I give you a very short brief of the case. Final refund sanction order RFD 06 was issued, but refund was not credited to the bank account. The department alleged that there are some adverse reports and proper officer, assistant commissioner, has withheld the refund. The order was signed and issued by the assistant commissioner. This order was not signed by the commissioner. My lord, the government counsel is incorrect to say that this order is of the commissioner. First Appellate Authority, Joint Commissioner, dismissed the appeal on the ground of non-maintainability. So now 2 questions of law arise. Withholding of refund under section 5411, and second, maintainability of the appeal before the First Appellate Authority. My lord.
Well, in the last session...
Your Honor, I want to read a judgment. I promised last time to you.
Okay.
Yeah. Now friends, question here is, which we framed in this Moot Tribunal. Can an order passed by commissioner on file, conveyed by assistant commissioner to the appellant, is this order of the commissioner? If so, whether commissioner is an adjudicating authority in law whose orders can be appealed in section 107. This was a question taken by me from Supreme Court judgment of Radha Krishnan Industries versus State of Himachal Pradesh. My lords, I'm going to read this particular law. The High Court dismissed the writ petition, I'm quoting the law at bar, on the ground that the appellant had an alternative remedy in law. The sole ground which was weighed with the High Court in holding that the writ proceedings were not maintainable is that the writ petitioner has efficacious remedy, rather alternative remedy under GST Act. In addition, the High Court has observed that the writ petition filed by GM Powertech, against whom similar allegations have been levelled, has been dismissed by the relegating to the pursuit of alternative remedy. The learned senior counsel appearing on behalf of the appellant submitted that GM Powertech had been relegated to pursue an alternative remedy since an order of assessment had been passed against it. However, insofar as the appellant is concerned, the writ proceedings were instituted to challenge the levy of provisional attachment under Section 83. And there is no alternative remedy provided under the Act for challenging an order in Section 83. Section 107 incorporated chapter 18, which deals with the appeals and revisions, provides as follows. Appeals to appellate authority. Any person aggrieved by a decision or order passed under this Act or the CGST Act by an adjudicating authority may appeal to such an appellate authority as may be prescribed within 3 months, so and so. Subsection 1 of 107 makes it abundantly clear that an appeal to the appellate authority is available against a decision or order passed under GST Act by an adjudicating authority. Subsection 2 similarly provides that. We will skip this, Your Honor, this is not necessary. Subsection 4 of Section 2 says adjudicating authority means any authority appointed or authorized to pass any order or decision under this Act, but does not include the Commissioner, Revisional Authority, the Authority for all Advanced Ruling, the Appellate Authority Advanced Ruling, the Appellate Authority and the Appellate Tribunal. Now Supreme Court says, para 62 of this judgment, from the above definition, it is evident that the expression adjudicating authority does not include, among other authorities, the Commissioner. In the present case, the narration of facts indicates that on 21st October 2020, the Commissioner had, in exercise of his powers under Section 5.3, made a delegation inter alia to the Joint Commissioner of State Taxes and Excise in respect of powers vested in Section 83(1). The Joint Commissioner, in other words, was exercising the powers vested under, was exercising a power which are vested in the Commission under Section 83(1) to order a provisional attachment in pursuance of the delegation exercised 21 October 20. That being in position, clearly the order passed by Joint Commissioner as a delegate of the Commissioner was not subject to an appeal under Section 1071, and the only remedy was available in the form of the invocation of writ jurisdiction under Article 226 of Constitution. Your Honor, you have raised a question, can a Deputy Commissioner appeal or Additional Commissioner appeal who is working an independent in the provision, he can quash the order of Commissioner? This was your question to me. Yes. This question is answered by the Supreme Court. If it is an order of Commissioner, which is very clear from the order framed, that this order was Commissioner stopped the refund, and this order was conveyed by the proper officer to the appellant. It is exactly same case is here. This order sheet was copied in the Supreme Court judgment where Commissioner signed, okay, go ahead. And this order was conveyed to the petitioner in this Article 226 petition. Supreme Court says Commissioner is not an adjudicating authority. So once in principle Supreme Court says Commissioner was not an adjudicating authority, Section 107 is ruled out, completely ruled out. Appellate authority cannot hear this appeal. Now, on this issue, there are two more cases answering your question, Your Honor. An appeal is a formal request to a higher authority or court to review a decision made by an inferior one, essentially a complaint. This is from A.K. Karyappa case. Complaint to seek correction of an alleged injustice or error. It is a right granted by statute requiring a written petition outlining the grounds of appeal, and it serves as a mechanism to ensure fairness and accuracy within a hierarchical system, whether in legal, corporate, or governmental contexts. Yes, generally an appeal must be heard by a higher authority or court to ensure fairness and to provide a higher level of review. Though the specific process, this was your answer, your question I'm answering, though the specific process varies by jurisdiction and type of appeal. In India, for example, CPC allows for appeals the Court of Session or Session Judge to be heard by Session Judge or an additional Session Judge, a level higher than a magistrate. That's more important. Similarly, appeals against a Supreme Court ruling can in other cases be heard by a larger or constitutional bench of Supreme Court. Let me stop here. In Central, they have appointed a Commissioner Appeals only for this reason. And this was done through a notification subsequent to the Act. So a Commissioner State order can be appealed to Commissioner Appeals. Both are same level. But here you cannot say Commissioner's order could be heard by an additional commissioner who works under him, who works under his delegated powers, under 6(2) additional commissioner not appointed by the government. Commissioner delegates these powers. For 6(2), 1 and 2 you have to distinguish. Commissioner is appointed by the government. Other authorities are given delegated powers by the commissioner. So it is very impossible to dream a delegatee will not uphold the order of the commissioner. And that is why Supreme Court says commissioner in GST law is not an adjudicating authority. It is excluded from section 2 subsection 4 definition of adjudicating authority. If that is so, under section 1071 he can hear appeal only against order passed by adjudicating authority. Therefore, necessarily he has to come to tribunal or go to High Court. So as a revenue counsel, to be fair to the appellant, what can this honorable tribunal say if your honor agree with this Supreme Court judgment? You have to simply say, okay, well, this is not on. You appoint a commissioner appeal, you can...
yeah, that is a big fallacy in Delhi GST Act, that they have not appointed independent commissioner appeals, which they should have done, like Central.
No, but Your Honor, there is one more question, Your Honor.
Mr. Verma, I will like to draw your attention on another judgment of Supreme Court.
Yes, Your Honor.
In the case of Collector of Central Excise Madras versus Messrs. Rubber and Company, Tamil Nadu.
Your Honor, this is a very old judgment.
It is very old judgment.
Yes, but I'm giving latest under CGST law.
That is right.
A specific judgment shall prevail over any other judgment. It's a specific judgment under GST law. Why should we give an interpretation of any other judgment? It's right under section 107. I have no reason to read MM Rubber. I can counter it right from this judgment. I know MM Rubber very well. But we have a right under GST law this judgment. Why will I fall? And this is a subsequent judgment to the MM Rubber. That's very old judgment.
That is right. That is an old judgment. But the only thing is that there also it was a superior authority, Board of Collectors, which are I think superior than Commissioner also. So Board of Collectors gave the directions, and the Supreme Court held that the appellant will be adjudicating authority himself and not the authority who gave the directions.
I also raised this question.
Here the question is that the final order has been signed.
No, but MM Rubber was not interpreting who is an adjudicating authority.
No.
Here they say commissioner is not an adjudicating authority itself.
No. Here in.
I know you are MM Rubber, but this was not the question before the court.
No, it was not a question before the court, but court has also given judgment on it. I'll just take you to.
You know, the power under section 35 is the power of superintendence conferred on a superior authority.
Correct.
So we are not dealing with an appellate mechanism at all. It at best can be 263 here. There is no superintendence of control here. That's not the question before this honorable tribunal.
That is right.
So
the only thing is that Supreme Court has held in this case that if the order has been passed on the directions of the higher authority, that order will be deemed to have been passed by the same officer treating him as
but here Supreme Court says commissioner is not an adjudicating authority. So very basis of appeal goes in 1071. The additional commissioner cannot hear appeal which are orders not passed by adjudicating authority. Supreme Court says definitely says commissioner not adjudicating authority. How this judgment will be relevant? It's totally irrelevant judgment. Sorry to say, Your Honor. And it's not in this context at all. 35 is a totally different verdict provision.
Is totally different, but I am only emphasizing on the
I've conceded.
Yes.
Even in CPC I've read a provision.
Yes.
But here you have a Supreme Court directly under GST law.
Correct.
And this is 19 man.
Anyhow, if that being the case, one thing is that through you, the instructions should be given to the DGST.
Yes, Your Honor. Yes.
That separate appellate authority should be, independent authority should
Yes,
be
Your Honor.
constituted, number one.
And his appeal
Number
should be
two,
heard on
we have
merits.
every right to take this appeal and decide whether that refund, withholding of refund is correct.
Yes, Your Honor. Absolutely. On the justification, this tribunal can go through.
So, on that
We can adjourn the matter of next tribunal. I'm not ready with that merits.
Okay, okay. Then let's
Yes, Your Honor.
it to the next one.
Oblige, my lord.
Your Honor. Thank you. Now, here, friends, the question was, which we framed in this court team was, what happens in Delhi? Delhi is a unique city. They have constituted a committee of officers who keep signing some files. It goes here and there. For example, a refund is cleared by a special commissioner. जैसे उसकी अपील आप डिप्टी कमिश्नर के पास करिए. So we had raised this question before the honorable judges. I am very grateful they agreed with this first legal proposition. Can a deputy commissioner pass order against a special commissioner order? It's ruled out. Therefore, we raised this question of law in this Moot tribunal, and it was argued very hotly last time, and the honorable judges wanted time to read. I am grateful to honorable judges. They read and gave us some more guidance on this. But Supreme Court said commissioner is not an adjudicating authority. And once he is not an adjudicating authority, section 107 is not applicable. And special commissioner works under delegation of commissioner's power, under 6(2). He is not appointed by the state government. Therefore, this Radhakrishnan SC judgment, para 54 to 62 are completely relevant. Keep raising this question of jurisdiction. Jurisdictional issues are very critical for us lawyers to appreciate कि कहाँ jurisdictional issue आपको raise करना है. You may win, lose, don't bother about lawyer. Work hard, do some research and come out with a proposition that yes, this order seems to be without jurisdiction. Thank you, Your Honor. Yes, Your Honor.
Section 73 and 74 gives power to the adjudicating authority. And that section does not say anywhere that adjudicating authority will take prior approval from some special commissioner or somebody. Under what provision those files are that in a that adjudicating authority's power are.
But that's the only question. That's the question we are raising. That's illegal exercise. In fact, there was a refund committee. I think Mr. Bhatia knows that case, where Delhi High Court passed very serious stricture. Where is the provision for such a committee? But problem is that Delhi commissioner, they don't know anything. इनके साथ क्या बहस करेंगे जाके आप? This woman who is the commissioner here, she doesn't know ABC of GST.
There is no provision in the statute regarding a committee or anything.
In fact, we core committee discuss your issue.
So that
in this group, the problem is all of them are made to read. But I don't read alone.
Sir, when a quasi-judicial power is given to one adjudicating authority,
either is withdrawn or he decides.
No, then even his senior cannot direct him out.
He cannot. Yeah, all orders passed on the direction of superior need to be quashed. And that is what going to hold this next tribunal when he quotes a judgment, my friend, that this order should be quashed, passed on a superior. But then what is the default consequence? The tribunal cannot say the demand goes. They can remand at best with strictures, whatever. Unless default consequences are provided under the Act, it's very difficult for the court to create a default consequence and say this thing goes.
at least tribunal cannot.
Now that also we'll discuss this question today. We have this question also here. Yes. Thank you, Dr.
Thank you, everyone. Item number 2, represented by CA Yugal Goyal, myself. Whether the limitation for claiming refund start from the date of first application or the second rectified application, implications for refund including power of first appellate authority to issue show cause notice, a critical issue faced by all the professionals. I am the arguing counsel and SV sir arguing for the revenue, and then after final observations from SV sir. Your Honor, if you allow, then I will start with the case. Your Honor, this case involves a rejection of refund claim amounting to rupees 27.45 lakhs filed under section 54 of the DGST Act for unutilized ITC on account of export of goods for the period April to May 2023.
on the ground that refund application was time barred by limitation, that is 2 years from the relevant date. Further, the deficiency memo has been issued to us in form number GST RFD 03, which has been issued even after the acknowledgement of the refund in RFD 02. In our case, what happened, Your Honor, we have filed the refund application. Authority has granted us the RFD 02 acknowledgement of a refund, and then after they come to know that there are certain deficiencies in our refund application, and they have issued RFD 03. So this is the main opening of my case. Your Honor, the statements of facts are as under. In our case, the appellant Measures Rolex Exporter is a registered exporter. For the period April to May 23, the exports were made under LUT without payment of tax, and an application for refund of unutilized ITC was claimed. The refund application was filed on 31st of March 2025. You can refer page number 22 to 28 to the appeal petition, which was initially well within the limitation period, that is 2 years from the relevant date as provided under explanation 2 to section 54. Page number 22 to 28.
These are your refund application.
Yes, sir. Afterwards, an acknowledgement for refund has been issued in form GST RFD 02 on 2nd of April. The copy attached on page number 29. Despite this, a deficiency memo was issued to us on 2nd of April 2025. You can refer, Your Honor, at page number 32, which is order of adjudicating authority, first and second line, page number 32. Stating some defects.
Page number 32.
Yes, sir.
Yes.
However, a rectified application was filed in response to this deficiency memo on 14th of April 2025. Later on, the refund was rejected on the ground that it is being time barred, treating the refund application as this rectified refund application as a fresh refund application, completely ignoring the fact that GST RFD 02 has already been issued in response to an earlier application. Being aggrieved from the order of adjudicating authority, the appellant filed an appeal before the first authority, which was again dismissed on 1st of July 2025. You can refer, Your Honor, on page number 33 to this appeal petition. Further, the first appellate authority has issued a show cause notice to the appellant under section 107 subsection 11 to the DGST Act to know the merits of the case in connection to exports and to show cause how unutilized ITC is available to the appellant. Feeling aggrieved, Your Honor, the appellant filed an appeal before this honorable tribunal. The main question before the tribunal is whether, if an acknowledgement has been issued in form GST RFD 02 against a refund application under section 54 of the DGST Act, read with rule 90, then can a deficiency memo be issued at a later stage, and can such an application, even if rectified, be rejected as time barred by limitation? Sir, in this regard, the grounds on which the appeal has been framed are as under. Your Honor, under explanation 2 to section 54, the relevant date as applicable in our instant case, the export of goods, the relevant date is the date on which the ship in which the goods are loaded leaves India. One was in time, yes. In initial application was in time.
Yes, my lords, my friend is right. In rectified application, those has to be filed afresh. It relates back to the original application. Case can be remanded on these directions. Thank you.
Thank you.
Well done. Very good drafted application, Jugal Goyal. Congratulations. You won it. अरे टाइगर है हमारे ग्रुप के, शेर है शेर। गालियां कितनी खाई है पूछो उसको। तो अभी भी क्लैरिटी नहीं बोलेंगे। नाउ नहीं जी, हमारा अपना ग्रुप है। नाउ व्हाट इज द लॉ लेड डाउन बाय द जजेस हियर? मोस्ट ऑफ अस do not follow this law at all, none of you. Section 54 deals with refund. The only two subsections to read is 54.5 and 54.7. All other are machinery provision, कब देंगे, क्या करेंगे, क्या नहीं करेंगे. 54.7 says, notwithstanding what is written in subsection 5, the proper officer shall pass refund order within 60 days from date of application. उसको जो नाटक करना है 60 दिन में करना है। 15 दिन है उसके पास डेफिशिएंसी मेमो देने के। आई कीप टेलिंग यू, limitations under GST are sacrosanct. There is no provision where any proper officer can condone the delay unless Supreme Court does under Article 142. RFD 03 cannot be given after 15 days. There is a case argued by my friend Rajesh Jain, Jian International versus State of Commissioner, Delhi GST. This lays down the law clearly. There is another case of Supreme Court. It is called, you can note down, Hamdard Waqf Lab versus Union of India. It's on section 11B of Central Excise, which is a similar provision like 54.7 and 54.5. Supreme Court says, जो भी आपको करना है 60 दिन में करना है, 60 दिन में नहीं करोगे तो interest meter will start. That is section 56(1) will start. Now what is the litigation here? Litigation is if you have given a refund application, like my friend should have done, he has not done in this case. He should have enclosed an evidence, I have written letter to commissioner, why has not given my refund. Put up a letter after 15 days, sir, 15 days are over, no RFD 03. RFD 0, he can give RFD 08. That is, he can reject your refund, give a show cause notice to you. Jawab do. Don't delay the reply because the time you take to reply will be excluded for the competition of section 60 days in 54(7). 60 दिन हो गए, उसको चिट्ठी लिख दो, सर इस साल ओवर, अब आपको ब्याज देना है. Now supposing after 60 days he rejects, and if you win in appeal, interest will be given to you when 60 days expired. वो आपको appellate authority को बोलना है कि साहब ये लिखिए, इसमें ब्याज कैसे कब से मिलना है हमारे को, इसमें लिखिए, और आपकी अपील में ये प्रेयर होनी चाहिए थी. Like when he came here to the tribunal, he should have put a prayer, why need interest, why was my refund illegally rejected, and direction should be given by the honorable tribunal can give so much of direction also, interest should also be given, right? So this is the law of section 54, and let's clap for Jugal Goyal once again. He argued very well. Thank you.
Thank you, sir.
इतना मोटा आदमी स्मॉल क्वेश्चन तो पूछेगा नहीं. अच्छा,
जो ये लिमिटेशन 15 डेज या 60 डेज की है, ये वर्किंग डेज होता है या फ्लैट डेज होते हैं?
ये फ्लैट डेज है, इसमें एक्सक्लूजन नहीं है.
एक्सक्लूजन नहीं है
ना. अब 15 दिन खत्म, आपको चिट्ठी लिखनी है हर हालत में उसको, और कॉपी टू द कंसर्न कमिश्नर, ये 15 दिन हो गए, बाय बाय. 60 दिन हो गए, उसको लिख दो, रिफंड दो, इंटरेस्ट मीटर स्टार्ट्स. तब ये अफसर भागेंगे, इनकी इंटरेस्ट इनकी जेब से जाता है, इनकी दे कैन लूज देयर जॉब्स. मैंने अभी एक केस दिल्ली में, आई हैव जस्ट टेकन एन इंटरेस्ट ऑफ 43 लाख रुपीस. आई टोल्ड देम आई होल्ड यू इन कंटेम्प्ट, डोंट स्केयर मी. द सुप्रीम कोर्ट, दिल्ली हाई कोर्ट, हाउ विल यू नॉट गिव इंटरेस्ट? सर ये सोचो. मैं कहा आप सोचो सर, नौकरी आपकी, मेरी तो ना नौकरी, मैं तो नौकरी नहीं करता, मैं फ्रीलांसर. So if you become fearless, if you know the law, you will serve your client very well. If you are within your legal rights, you are not trying to blackmail anybody. But put in a simple, gentle reminder to the proper officer. साहब ये टाइम निकल गया, आपको ब्याज देना है, हम ब्याज लेंगे. एक्नॉलेजमेंट होनी चाहिए, उसकी स्टैंप लगा के लो, घुग्गी मार के नहीं. And give same copy to the commissioner of the head के लिए इन्होंने रिफंड टाइम पे नहीं दिया. This is how you innovate and make these officers work better. Okay, next, Jugal. तो है ना, बस सौदा कर ले मेरे से, मैं कर ले दूंगा तेरे को, बाद में लंच में बात करेंगे. चलो नेक्स्ट.
Thank you, Runner. Thank you, sir. Item number 3, represented by C.A. Renu Sharma. Refund implications of SIP chunk on high sea sales, bill price or shipping price, and their applicability for refund, including the concept of composite service, service providers, whether intermediary, etc. Great concepts and issues being argued by CA Renu Sharma. And then final observations by SV.
Now, what is this case Renu is going to argue? These are again controversial issues under GST law. Huge controversy. The definition of export is changed from Section 5 of Central Sales Tax Act. There is a change in definition of export of goods. The GST law defines territorial waters, which earlier laws had not defined. So if goods are exported through a ship sinks, can authority deny your refund of unutilized ITC? Now this is an interplay of 54 with section 7. What is the concept of supply? And whether section 16 or 17(5)(h), goods lost, destroyed, etc., will be applicable under these circumstances or not, that's another question she is going to argue. In her case, there are necessarily 3 parties. And she says, my client is not an intermediary. So we will dwell on this concept, whether even in the 3 parties, can there be a provision where they say, I provided services on my own, I'm entitled to get refund. Then she is going to raise another issue to you, whether shipping bill or bill value which will prevail notwithstanding the circular issued by the central government. We will discuss this. And these are very important questions of law. Then the payment received in INR, though convertible for exchange through a something account specified in the circular, in the law. When you read circulars, be very careful, you are reading the provision first. Because if the provision says Vastro account, as your payment has not come through Vastro account, the courts may not give you power to give relief. High Court may read it down, not the tribunals. Because tribunal are authorities created by statute. They cannot interpret a constitutional provision. So these are the 4 issues Renu is going to argue. And you know she is very quick. I'm trying to preempt her time.
My lord, the appellant is before the Honorable Tribunal on mixed question of law and facts. The issue before your lordships are on 4 grounds on the basis of which the refund of the applicant is rejected and only partial amount is allowed. My lord, the first issue raised in the show cause notice was purely on law. The officer reduced the refund on the basis of Rule 89 subclause 4, that is the lower of the invoice value or shipping value being the value taken for export for refund calculation. Rule 89.4, that is explained on page number 84, my lord. Which says the free on board value declared in the shipping bill, as the case may be as per the shipping bill and bill of export, or the value declared in tax invoice or bill of supply, whichever is less. I would request to read section 15(2) of the CGST Act for reference here. Section 15 subsection 2 clause C says the value of supply shall include incidental expenses including commission and packing charged by the supplier to the recipient of a supply, and any amount charged for anything done by the supplier in respect of the supply of goods or services, or both at the time of or before delivery of goods or supply of services. My lord, the contract was CIF, and in GST returns also CIF value was considered as per the shipping bill. Copy of the GST returns are also attached. That is inclusive of freight and insurance. So the fact was already declared to the authorities. The appellant accepts his mistake that the invoice was made without including freight and insurance, but the same was separately declared in the invoice that is attached on the page number 50. On the left side. separately mentioned.
This is your page number 15.
Yes, yes.
Madam, here you have mentioned only subtotal, packing charges, that's it. Against delivery fee, freight, insurance, everything is blank. So this is the what the fallacy was, and because of that your refund was reduced by the adjudicating
my
officer.
lord, on the left side, the terms and conditions CIF contract and freight and insurance are recovered from the customer as per contract. The value has been mentioned there, and the value inclusive of freight and insurance is 11,25,600 is mentioned there.
Okay.
And the total amount received was also mentioned 11,25,600. That is matched with the shipping bill.
It matches with the shipping bill, correct.
Apart from that, the payment was also received accordingly as per CIF contract. My lord, my question is that when the main provision, that is section 15 itself, is very clear about the value of supply, then how can a rule override that main provision? The CIF value is our transaction value as per section 15, which should not be denied on the basis of only rule, and refund should be allowed in this case in full. My next issue before your lordship is the rejection of refund on the transaction with XV Imports UAE due to non-receiving of payment in foreign convertible exchange, and instead the payment was received through online portal.
One second, Renuji. Let's discuss ground wise. So I'll like government counsel to please.
Your Honor, if you go through section 15, sorry.
My lord, page number 71 also covers section 15.
Now, Your Honor, section 15 marginal heading is value of taxable supply.
Correct.
The value of supply of goods or services of both shall be transaction value, which is the price actually paid or payable for the said supply of goods or services or both, where the supplier and recipient of supply are not related and the price is the sole consideration for the supply. Subsection 2. The value of supply shall include taxes, waxes, we will skip this. The value of supply shall not include the following, where the value supply so and so. Now subsection 5 is more relevant in relation to rule 46, I believe. Notwithstanding anything contained in subsection 1 or subsection 4 which decides the inclusions or exclusions and the value of taxable supply, the value of such supply as may be notified by the government on the recommendation of the council shall be determined in such manner as may be prescribed. Now, if you see this circular number 37/11/28 on page 21 of our appeal petition, they have referred rule 46.
Page number 76. Yes.
We can read rule 46.
Rule 46 is on page number 73. Tagging has been done.
Rule 40 deals with tax invoice. This says subject to rule 54. So if rule 54 contains anything contrary to rule 46, rule 54 shall prevail, not rule 46. Now they have referred this rule 46 to determine the value of supplies on these things, and the circular says the value recorded in GST invoice should normally be taken transaction value as determined under section 15. Read with the rules made thereunder. The same transaction value should normally be recorded in corresponding shipping bill of export. Now, the question of law is, if section 15 gives power to the government to decide the valuation, and if in rules this is prescribed, like in Rule 46, and to effectuate the provisions of Rule 46, read with Section 15(5), a circular issued, the circular shall be binding on the authorities. They cannot go away from this. Regarding her point on valuation, this is a very debatable issue, because it does not say it will be the only value. The circular says should normally be the transaction value. So it does not mandate what shall be the final value.
So transaction so far is concerned, it has been specifically mentioned on the invoice, and this same amount has been realized in FC.
Yeah, but I'm also saying the same thing. I'm saying that the tribunal has to decide a question whether the higher value has to be adopted or the lower value has to be adopted. The circular does not mandate what will be, it only says should normally be, right? But for the officer, there is nothing illegality in the order. He is not going to decide what is this. But this tribunal has a difficult question, will this circular issued on Rule 46 shall prevail over Section 15? Especially if she is able to say I have realized the full value including freight, etc., etc. And she is dealing with the CIF contract. If the contract was no CIF, then the different considerations should have followed. Contract is a CIF contract. Therefore, this is for the Honorable Tribunal. Well, I will say as a concede, it's a debatable issue. It's a debatable issue.
Well, it is a debatable issue, but on contrary, if we go by High Court of Jharkhand in the case of Tata Steel, and then again VKC Footstep. So they have mentioned that refund is not an unfettered right, and government will well within powers to impose certain restrictions, conditions and safeguard for the grant of refund. This is as per Tata Steel. Then in VKC they have mentioned that refund is not a constitutional right but a matter of statutory prescription. So following VKC Footstep, refund, when it is not a constitutional right but a matter of statutory prescription, so legislature is empowered to put any condition or restriction on issue before issue of refunds.
Your Honor, with due respect, both Jharkhand High Court and VKC were not dealing with the question of valuation. They were this 54, Mafatlal Industries said it's not a fundamental right.
Correct.
So we don't need VKC Footsteps.
Correct.
But here, this rule with Section 15 has not been interpreted in any of the refund judgment till today. Till today.
Till today.
Till
You're
today.
right.
So
You're
VKC
right.
Footstep rightly says refund. They can say कि हम इस पे refund, like it says cash refund only for 2 transactions.
Correct.
So that's a restriction put, they have upheld. Input service पे नहीं देंगे, they have upheld. They have upheld the formula, right or wrong. Rule 89 SAS formula, they upheld. But here we are dealing with the question of valuation. On what value will she be entitled to refund? Rule 46, I mean off the record, to assist the court, I will say it does not mandate
Yes,
that
it
you will
doesn't
adopt the
mandate.
lower value than
No,
the
no.
higher value.
No, it doesn't mandate.
So this is a tricky question for the Honorable Tribunal. I will keep quiet.
But my lord, when the Section 15 already declared that the all incidental charges will be inclusive of that, then why should that be removed?
No, but my dear friends, you have to have interplay with Section 15(5). That's a residuary power given. That's a residuary power given to the government by the Parliament.
But the circular also used the word should. That was
No.
not mandatory there.
I know, that's what I am
When
saying.
they
It's not
included-
mandatory.
Yes.
But it doesn't mean that government didn't have a power. If they had said that this will be the value, even then tribunal could have interpreted. It's only a circular. Circular is their understanding, not our understanding.
Well, but in your refund application, which value you have adopted?
In my refund application, I have adopted the value inclusive of freight and insurance.
No.
That, my lord, I have given the paper to you in the morning now. That is of amended GST return where I have changed the figure to the
Okay.
invoice value.
So you must have amended it because as per your previous documents,
Yes.
which I have gone through, you had taken FOB value.
In the taxable value and in the invoice value, I have taken the full value. But in the amended GST return, I have amended the figure to the invoice value.
Mm-hmm.
Sir, will it depend on the facts and circumstances?
You can't interfere in the court proceeding. You cannot interfere. No, after the court. After the court. हाँ.
इशू वही बनाते हैं जिनमें कोई जजमेंट नहीं है.
So, no, let's go over the ground 2 now. Okay. Now, you please come on ground 2.
Yes, my lord. My lord, I would also like to clarify, if I would have taken the taxable value in GST return, then both figures should have been that would have been matched, and there would be no issue in application of refund. But issue has been created due to taken invoice value in the GST returns. The next issue before your lordship is the rejection of refund on the transaction with XP Imports due to non-receiving of payments on foreign convertible exchange. Instead, the payment was received through online portal. Yes. This issue put before the Honorable Tribunal is also based purely on law, my lord. Proviso to section 16 subsection 3 of the IGST Act, that is on page number 94. Proviso clearly states that the registered person making zero-rated supply of goods shall, in the case of non-realization of sale proceeds, be liable to deposit the refund so received under this subsection along with the applicable interest under section 50 of the Central Goods and Services Tax Act within 30 days after the expiry of the time limit prescribed under the Foreign Exchange Management Act 1999 for receipt of foreign exchange remittance in such manner as may be prescribed. So here the reference has been given of FEMA Act for the time limit, and it also indicates the manner for receipts of foreign exchange remittances also. So if I go through the chapter 2 section 8 in FEMA Act 1999, that is also attached at page number 97. Point number 8, my lord, which prescribes the realization and repatriation of foreign exchange, which says save as otherwise provided in this act, where any amount of foreign exchange is due or has accrued to any person resident in India, such person shall take all reasonable steps to realize and repatriate to India such foreign exchange within such period and in such manner as may be specified by the Reserve Bank. Here FEMA Act 1999 prescribes the process of export as regulated by the RBI, which is mentioned at page number 85 para 3.2 last para.
85.
Yes.
85.
Last para 3.2 last para.
Okay.
Accordingly, it is clarified that the acceptance of LUT for supplies of goods or services to countries outside India or SEZ developer or SEZ unit will be permissible irrespective of whether the payments are made in Indian currency or convertible foreign exchange, as long as they are in accordance with the applicable RBI guidelines. Now I would like to give reference to Circular 88/7/2019, that is on page number 98. 98. That prescribes the manner of receipt and payment. Yeah, last point, my lord.
Last point is 98.
Yes, point number 3. Point number 3, last. Processing of export related receipts through online payment gateway service providers. It has prescribed the manner through which authorized dealer category 1 banks have been allowed to offer the facility of repatriation of export related remittances by entering into standing arrangements with online payment gateway service providers, subject to the following conditions. And these conditions have been followed by the Appellate Bank, that is AD1 category bank, Dashes Bank. The declaration of the bank is also attached as page number 62. where the bank has declared that it has entered into standing arrangement with the OPGSP, that is PayPal, for the purpose of facilitating repatriation of export-related inward remittances. So the appellate has followed all conditions which is prescribed for taking refund. So the allegation of payment not received in foreign convertible exchange is also not sustainable and should be quashed.
Your Honor, I think her exports are self-questionable. Just read, see page 58 of a paper book. It says garments of 6718 kilogram. And what is 35? We don't know. Just see the next invoice. If these are export invoices, they are very shabbily made invoices. Garment 6718 kg, then it says 6718.2 kg. There are no payment terms on the invoice, which is a mandatory part of the expired invoicing. Now, we should go through the declaration given by Deutsche Bank. Renu, what page is this?
61.
Ji?
Declaration by bank? 62.
Let's read 62. Is it really relevant judgment? This came on 15/1/25. And what period are your transactions? Madam, what are the periods of your transaction?
Let me check.
January 24. Right? So a declaration cannot relate back by a bank. There is no provision. No, even if we say, let's read for what they were authorized. We further declare that our bank has entered into a standing agreement for the purpose of facilitating repatriation of export-related inward remittances for small value e-commerce exports only. That is what the declaration of a bank is. Can this be relied upon? If at all it's relevant. Now, let's go back to page 90. She referred about the foreign convertible. कौन सा पेज है आपका वो?
Foreign convertible.
88.
RBI?
हाँ, page number 85.
85.
85. Now, if you read para 3.2, and you know, from however onwards, around 6th, 7th line, the word towards the end of the line, however, export proceeds against specific exports. What are those specific exports? My friend should have gone into, does she cover into the schedule appended to these circulars? Specific exports may also be realized in rupees provided it is through a freely convertible Vastro account. Where does HDFC write this is a Vastro account? This could be a Hawala account. So if at all we need to rely on a circular issue under FAMA, it has to be construed strictly. It cannot happen because some money has come. She is wanting a refund from the government. She has to strictly construe the circulars, notifications, and satisfy the conditions. The HDFC bank receipt attached, it doesn't talk of Vastro account at all.
My lord, I am taking the reference of accordingly. It is clarified that the acceptance of LUT for supply of goods and services outside India will be permissible irrespective of whether the
My friend, you are taking a shelter in this circular. I'm talking of this. You are taking shelter in this.
Yes.
16.3 doesn't talk of the circular. The circular is issued in reference 16.3 IGST proviso. So there has to be, you have to satisfy these conditions. You should have got a declaration from bank. It's a Vastro account.
If you,
in foreign currency, there are 11 types of accounts that run in foreign exchange. That's why the banks do not give you certificates at all nowadays.
Yeah, if the read B.2 manner of receipts and payments. Page number 898. General guidelines for exports. 98. General guidelines for exports, point number 3. अलग है क्या? किसके कौन से सेट की कॉपी नहीं है?
No, but how is it relevant?
Processing for export related receipts through online payment
you just see the heading you have taken. It's not a circular. You can't use extracts in a tribunal. RBI circular extract. No, these can't be used in tribunal. You have to file full copies. Anyway, this is not relevant at all. You are taking a shelter. You received a payment in Indian rupees due to convertible foreign exchange. Yes. So only that RBI circular is binding. This has no meaning. We are not, nobody questioning your exports. Question is whether you receive the payment.
The payment is received in nostro account, no?
No, कहाँ लिखा है? आपने आपके बैंक की स्टेटमेंट में कहाँ लिखा है nostro account?
No, that is through nostro account. That has been written in the bank.
नहीं, the circular says what? Vostro account.
But
Vostro account and for specific exports.
Yeah, Vostro account.
So what are those specific exports? What are those specific exports? Are you covered by these conditions specific
no, that
exports?
Is general export.
Now this is your circular and this is the correct circular. You are having these specific exports.
Written in the RBI guidelines.
And then even your contracts also this is not mentioned. Exports are never out of a contract. On this, the matter can go back. You can produce evidence before the proper officer with direction from the tribunal.
Yes, the sale was through online e-commerce operators. Sale was made through online e-commerce operators, through websites also. So that
you are talking of these two invoices here. This is not from e-exports.
Yes.
This is not e-export. You are given a they are not e-exports.
That was sale done through our website.
ये कहाँ लिखा आपने? This is not a case below.
That was not required to be mentioned.
No, it's required to be mentioned. Come on. E-commerce 9(3) separate provisions in law. How come this is not required? It's 100% required.
My apologies for that. I will submit those documents also if required.
No, I don't think this tribunal can go on waiting for the additional documents, one more additional evidence application. You know, I don't mind if this case can be sent back and she can produce all the evidence with directions that they have to strictly follow the circular.
My lord, the next issue before this honorable tribunal is that the services provided by the appellant to the Brett and Company were not on his own account and hence not satisfy the conditions of section 2(6) of the IGST Act. I would like to read section 2 subsection 6 of the IGST Act along with the section 2 subsection 13 of the IGST Act, that is on page number 90. Yes. Export of services means the supply of any services when the supplier of service is located in the India, that is my appellant. The recipient of service is located outside India, that is Brett and Company. The place of supply of service is outside India, that is questionable. The payment for such service has been received by the supplier of service in convertible foreign exchange or in Indian rupees wherever permitted by the Reserve Bank of India. That is also have been received. The supplier of service and the recipient of the services are not merely establishment of a distinct person in accordance with explanation 1 of section 8. That is also have been fulfilled. Now section 2 subsection 13 defines intermediary, which means a broker, an agent or any other person by whatever name called who arranges or facilitates the supply of goods or services or both or securities between two or more persons, but does not include a person who supplies such goods or services or both or securities on his own account. Now section 13 subsection 8 clause B says that in case of intermediary services, the place of supply of the following services shall be the location of the supplier of services. My lord, as per the allegation imposed by the Education Authority, the services were not provided on own and the transaction does not fulfill the condition of export and hence the refund is rejected. But in this case, the appellant is providing services to Brett and Company on his own and the separate contract was made, and in turn the appellant has subcontracted the same to, in part with Sahani International, and there is no bar in the subcontracting. I would like to read the first, discuss the reference of circular 159/15/2021, that is on page number 92, para 3.5.
Which para?
3.5.
Which circular?
159/15/2021.
Which page?
Page number 92.
Okay.
intermediary services. An important exclusion from the intermediary is subcontracting. The supplier of main service may decide to outsource the supply of main service either fully or partly to one or more subcontractor. Such subcontractor provides the main supply either fully or part thereof and does not merely arrange or facilitate the main supply between the principal supplier and his customers, and therefore clearly is not an intermediary. Here the appellant is providing main supply to Brett and Company, and he subcontracted the part of the same to Sahani International. This issue is also on the law, my lord, and as per the law there is no restriction on these transactions, and allegation must be dropped on this issue since the law is very clear on this.
Yes, Your Honor. Your Honor, let's understand. When we talk of definition of intermediary, a person is not deemed to be intermediary if he is supplying services on his own account. This is a simple question. Okay, there are two parties, there can never be any intermediary. Right? Here there are apparently three parties. When we talk of subcontracting, subcontracting has to be authorized by the contractee. I will tell you why so. I will tell you from her documents in her case. Not necessarily I agree, but a contract must provide. L&T judgment of 45 SC1 Supreme Court, they defined what is subcontracting. Once you are dealing with international contracts, if the payments are struck, if I am the arbitrator, I will not even give her payment. Now, what is subcontracting? The services have to be back to back. If she has been engaged for 4 services, these 4 services have to go back. Let's read the agreements. On page 63. Page 63, 64. So these are the letters exchanged between the appellant and Brett International. Right, Your Honor? Right? Now, just see the agreement. It's an afterthought they have created. After the agreement says the company is engaged in the business of electronic surveillance services, that's all. And what are the letters exchanged for? Electronic services and security solutions. The security solutions word is missing. Now, even if you take the scope of work, it goes totally different. Conduct market research, identify potential service areas for electronic servicing, explore business opportunities, the whole thing, the whole agreement goes for a 6. Now, has she subcontracted this? Even if assuming no contractual privity is required between contractee and the subcontractor. She has not. It's an afterthought. This evidence is misleading. Now, let's see the agreement she has with Shakuntala and Sahani International on page 67. It says the company so and so has engaged the main contractor to explore service area and potential market in India for electronic surveillance solutions only, no security solutions. You know, this point 1, 67.1. Whereas, yeah. Now, this is what she claims is a subcontract agreement, which is done on 15th day, October 23. It talks of electronic surveillance solutions, no security solutions, which is the main thing in a software export. In furtherance of the above engagement, the main contractor desired to subcontract certain exploration-related activities to any institutional. Now, what do you mean by exploration? Is it a petroleum exploration or a market exploration? These agreements are afterthought. Then let's go further. Scope of work. Scope of work is totally changed. Can we say this fellow is doing a subcontracting for the contracting? Provide local insights, preliminary reports, market intelligence and contract leads, coordinate with the main contractor for guidance and reporting duty, conduct exploratory activity in design metro cities in India to identify potential client sectors. These were not the scope of the work given by Bright International. Had these agreements been carefully drafted, perhaps this question could have been debated. This whole evidence is a piece of afterthought, just to get refund.
All these are inclusive. That doesn't mean that all has been provided to that.
Document don't tell lie. When you file documents, document never tell lie. You want government money, you have to prove your documents beyond doubt, beyond reasonable doubt. Intentions have no role to interpret documents. जब एविडेंस बनाते हो सारा कानून पढ़ना है आपको, तब एविडेंस बनानी है, even if it's an afterthought. इसलिए you are being questioned.
हम यहाँ पे एक्स्ट्रा तो ऐड कर ही सकते हैं ना, जरूरी नहीं है.
No, you can't. You can add more documents. Jerry, you will create documents of October 23 now.
Yes.
Oh, create, file with affidavit. You want to go to jail? You want to go to jail?
Client will provide affidavit. I am not.
Huh?
She wants a bill case also.
In her case, that's only with me, not with the other. We'll discuss that lunch. That they have to know the law. They can't do cut paste copy from Google and come here. ये Google cut paste copy है. No, that's not the law. If RBI says Vastro account, it has a meaning. You are totally wrong. अगर पेमेंट आनी होती तो यहाँ भी ट्रांसफर कर सकते, पेमेंट तो आ गई. That's why they put a precondition payment in convertible foreign exchange through Vastro account. All banks are not authorized to Vastro account, and the Deutsche Bank authorization only for small exports for e-commerce. That authorization also goes for ethics. कोई बात नहीं, डीजीए में सब फंसे हुए हैं सर.
Some time to read it. For that, we don't want any disturbance.
Please,
you were making an accusation against the appellant that these all documents are afterthought and fabricated.
I didn't say fabricated, it's afterthought.
Afterthought.
I'll prove it again, beyond doubt.
See, the first email came on which date?
No, sir, the emails have no relevance. We are talking only of subcontracting. I'm not questioning emails at all.
No. I'm just.
email तो हम question ही नहीं कर रहे सर.
मैं आपसे question कर रहा हूँ.
Yes, you are now.
First email जो है कौन सी date को आई?
Are we talking of this part or export part? इसमें तो कोई email है नहीं
कि जब मेरे को order मिलेगा उसके बाद ही मैं सब contractor ढूंढूंगा.
हाँ बिल्कुल ठीक है सर. उसमें कोई doubt ही नहीं.
उससे पहले तो नहीं करूँगा.
उसमें कोई doubt नहीं है सर.
So I got an order or inquiry from.
ये 12 अक्टूबर 15 अक्टूबर को subcontracting हुआ. I have gone through the dates. Dates I'm not questioning at all.
अब उसके बाद जो उनका कंटेंट है,
हाँ जी,
आप उसको चैलेंज कर रहे थे.
नहीं, मैं कुछ और भी चैलेंज करूंगा. I'll prove this is afterthought, beyond doubt.
बताएं.
Just take page 66. The consultant shall be entitled to fee remuneration of 16,000. This page 66, para 3.3. Compensation. The consultant shall be entitled to fee remuneration payable as per the agreed milestones on monthly basis. Additional out-of-pocket expense, if any, shall be reimbursed on submission of bill. Let's go through page 68. This is not subcontracting at all. Subcontracting has a very different meaning in law. Point 4. Compensation to subcontractors shall be mutually agreed upon in writing based on the successful identification of viable opportunities or any business conversion resulting. Where is this condition by the contractee? Are we changing the scope of the contract?
How I am changing the scope of contract?
Yes, it is not in our contract with the foreign buyer.
See, the thing is that she has to deliver the services to the foreign buyer, and foreign buyer has not mandated that she must appoint a subcontractor. Number one.
Yes.
Correct? She can do it in-house also, and if she doesn't have infrastructure or facilities.
That's $1 million question whether she can do or not. We are not discussing that law issue.
No,
she cannot.
I'm saying she can.
Subcontracting also always has to be approved by the contractee. Always. The Supreme Court settled law. We can postpone to next hearing. We'll give you Supreme Court judgment on this. Okay. Subcontracting, unless authorized by the contracting, there can be no subcontract. That is why under L&T judgment, they say the sale done by subcontractor is deemed to be a sale of a contractor.
No problem, because we hold a different opinion on it.
Let me come on this again. Let me see. Now, the compensation which she has, the appellant has, in point 3, is not subject to any condition. On page 66, is not subject to any condition at all, except submitting reports. In a subcontractor, the whole scope is changed. Do you think a contractor will approve this? Then look at the termination clause. Subcontracting is never like this. I must have drafted thousands of subcontracting agreements. It's all back to back. And this whole contract is back to back. It's not a part contract done. The scope is changed, the termination is changed, the payment terms has changed. It's very difficult to say this is a kind of a subcontracting done to take benefit.
If the Britain company has given them a contract or they have given them the order with a condition that they will subcontract it.
No, sir, in that also.
Then whatever you are saying is correct. But here, we are not able to locate or find any clause.
That's exactly I'm saying. If Britain company has not authorized to take services, these are very personalized professional services. The contractee must know who is this guy doing a job for them, using their name. It can never happen. A subcontractor can't be any Tom, Dick and Harry in the world. These are very highly skilled services. Market exploration. सारी हवाला यहाँ से होती है सर. Well, how can a Britain law के Sushil Verma, who is a lawyer, he is doing the marketing services? Is it possible? It's an afterthought.
That has been accepted by the.
No, they have not even placed invoice documents on the record.
Sir,
what invoices were raised? Where are the invoice copies? We don't know.
So the same will be produced to the.
Why? You are presuming tribunal will remand the matter. You can't take this tribunal for granted. The invoice copies for other exports are enclosed, not for services. Why not? Why not?
So that may be available to you in the very
No,
shortly.
what available? You have to prove your case. Well, for other exports, you bring document.
No, here we are shifting the focus on some other point.
No.
My only concern is that whether these agreements are valid, which we have started.
No, these agreements are not valid. Subcontracting is not possible in this till the approved by the contracting Switzerland. No, the contractor has to inform it. This is an international convention by WTO. In subcontracting, for example, say Nayara, which is now closed, of course. If you see the subcontracting, I have seen Reliance industry subcontracting is approved by the English company. Who can be your subcontractors? What are their capabilities? That means she can create any report, put a subcontractor name and take money. And why there is no compensation in the agreement? As agreed. Well, they have a compensation of $14,000. Subcontractor को पता नहीं कितने पैसे देंगे. They change the scope of the work. That can never be subcontracting, sir. It is not possible. It's impossible to hold this is a subcontracting contract.
Sir, I have already attached application of additional evidence where I have written that the all majorly documents have been fired in our office, and copy of FIR also has been attached there.
Not bad, but this is not a ground taken below of document fired. Again, afterthoughts.
Sir, I have arranged.
There is no ground taken below.
That FIR is also incorrect. The police has given a report that is a false.
No, but I don't have an FIR copy here.
Sir, I have attached.
She has attached.
On page number.
She has attached the copy of FIR.
Wait, sir, tell me which page.
So page number 46 to 48.
Anji?
46 to 48.
Let's see the FIR. (46) is not FIR.
48.
Okay. This is 12/11/24. You are dealing a case of 23.
Yeah, but documents were there, no?
No.
All documents were there.
What I've written in FIR, the fire suspected to be so and so and completely destroyed important books of account, the business records. These are documents are available online to you. All exporters keep a separate file data. What documents were exploited? Are you only exporter? You do domestic
business.
Then no, this FIR has no meaning for tribunal. It's from 24, November 24.
But all documents were there, no?
In any documents you had through invoices,
documents
copies you could have taken from Brett Lee if you are from there.
Do you have the documents? Because whenever fire brigade comes, they also make
give a panchnama.
They give a panchnama.
It's not there.
So we need that.
It's all fabricated, sir. It's all afterthought.
That also.
We need that because that will ultimately establish which documents were there or what all has been destroyed. So for that, besides this FIR copy which you have attached, that panchnama.
Jonah, I have one more point. FIR is November 24.
Yeah, that is.
She has bank documents of 23. Appellant has his agreements of 23.
Correct.
Only the documents are destroyed.
So in
It's a
short
complete
time span,
story
I have
cooked
arranged
up
all
to
documents.
take government refund.
Since my fellow other chartered accountant was handling the case, and due to old
You cannot blame any chartered accountant in the tribunal. We told you many times. Don't blame lawyers.
In the short time span, I could
Next
arrange
point,
all
sir.
these documents.
You can take a call. I have no issue. But this is all fabricated. According to me, it has absolutely no relevance to the case.
The fourth issue before your honor is refund rejected on the basis that goods never reached destination, and ITC also should be to be disallowed by invoking provisions of section 17(5) due to goods lost, destroyed, etc. My lord, I would request to read some provisions of CGST or IGST Act for reference before arguing on this issue. Section 2, subsection 5 of IGST Act, that is on page 90. This is the export. Which defines export of goods with its grammatical variations and cognate expressions means taking goods out of India to a place outside India. And here reaching of goods to its destination is not mentioned anywhere, my lord. Export of goods with its grammatical variations and cognate expressions means taking goods out of India to a place outside India. And here reaching of goods to its destination is not mentioned anywhere in that. Now section 16 of IGST Act, that is on page number 94. Which says zero rated supply means any of the following supplies of goods or services or both, namely export of goods or services or both, which we already have discussed now the definition of export of goods.
Is not being questioned. The question is that
Yes.
so whether it was out of the
Indian territory or not.
That was out of the territory, my lord.
So we have any proof of the case
एक अपील बिफोर लंच और कर लें.
My lord, the bank supply was zero rated supply and it was X contract, that is the FOB. Ex India, it means the appellant's liability against goods was completed when the goods reached the port and freight and insurance were to be borne by the importer. Now ship sank on high seas. Yes.
That's what my friend KPC is asking you. That do you have any evidence to prove that the ship sank after the crossing of the Bengal of India?
No, my lord, I don't have that such an evidence, but from customs we can arrange that also. Since the insurance वगैरह all borne by the importer, not by us. And my supply was completed when the goods were on board.
Your Honor, if we see the definition of exports, definition of exports is goods taking out of India. In nowhere this is written in the law that the goods will reach destination. For the purpose of IGST Act, the definition of supply is same as in section 7. Supply shall presuppose delivery of goods. And if you read section 74, it contains an offence for both transferring invoice, not delivering goods, and taking goods without invoice. Both are offences in section 74. And by the operation of section 20 IGST Act, all local provisions also are invoked in for IGST Act.
section 74 I will speak fraudulent with common intention to cause loss.
Yes, sir. I'm only giving an example for the definition. I'm not invoking section 74 here. Section 74 not invoked here. Now, let's read 17.5H. My friend has to answer this as well. What happened? For input tax credit, there is no separate provision in IGST Act. So section 20 says all local provisions of ITC shall be applicable to IGST Act also. 17.5H says no input tax credit shall be given if goods lost, stolen, destroyed, written off or disposed of by way of gift by free samples and goods lost, stolen, destroyed, written off.
Who was having the property of goods? Whether her goods have been lost or the goods of buyer has been lost.
You know, here we have to make an inquiry. She claims it's an FOB contract. You say FOB contract? It's an FOB contract.
FOB.
Right?
Correct.
There is no contract document annexed. How do we presume? Can this tribunal presume कि it's FOB contract? इनवाइस लगाए कोई FOB contract है? कोई बैलेंस बोलने से बात नहीं बनेगी. Notwithstanding FOB contract, that's a contractual termination between them. Question is whether the goods were taken beyond territorial waters of India.
That's what I'm
Where
asking.
is this proof? Number one. Number two,
one is this.
the appellant also has to answer goods lost, destroyed, no input tax. Refund is for the unutilized ITC.
Yes.
If there was a refund of IGST paid, she had a very strong case. I would have conceded. She is filed an LUT, she wants to claim unutilized ITC.
Correct.
If ITC is governed by section 16, 17.
No, but in that particular case, it has to be established that the property of goods were with whom? Who was having insurable interest in the goods? Here the insurable interest is with the buyer.
I fully agree with you. Section 24 sales of goods, the risk passes to the buyer.
Correct?
That's a default rule of law. But who
Yeah.
was to prove it? Not me and you.
No, no, we can take it on sumo moto also.
Not sumo moto from where?
From the documents and
There's no
facts.
document?
You have not attached any document.
I have attached BRC for that.
No, no, no. Shipping bill of that particular.
No, where is the contract? The exports can never happen without contracts through sea.
The contract has been not attached, but that will be arranged.
In a FOB contract, the very moment she loads the goods on the ship,
Yeah.
ownership passes to the
Yes, he has to give the contract.
That's what
Yes.
she should say.
Yes.
No, no, that's one part, sir. She still has to come out on 75H. It's not that easy.
No, no,
Export
75H
is complete. Export is
Export
complete.
is complete, but the only thing is, I am asking the main question is that you are saying goods lost, stolen,
Goods lost, destroyed.
destroyed. In my case, whose goods? If those goods belong to me,
Your Honor,
then it
once
is
she
like-
gives you a copy of the contract, we'll argue this issue.
So
My
you,
lord, export has been accepted by the officer also, that the export has been completed.
but
There
you
was
have
no
not
doubt about it.
brought any documents in that respect here. So better you.
If what you expect is, you shouldn't have to argue FOB contracts here. Your point should have been very skewed and limited. You are expanding the scope of arguments, so you have to answer.
In a FOB contract, the very moment she loads the goods on the ship, ownership passes to the buyer. Now, even if the goods are destroyed,
That's what I am saying. So for that, you have to bring all the documents here.
Mr. Khurana, the FOB contract is not adopted in CGST Act. That is a one sec, sir. That's FOB, CAVR, commercial, international terminologies. That has to be interplayed with the law you have created. Those judgments were there when
Mr.
export
Khurana,
was
let's
defined
not
separately.
discuss it here
Yeah,
because
yeah.
my friend
That-
Bhatsa was also trying to argue something.
He's
He
very
was stopped
desperate.
to.
Yes, I think we can discuss later.
Yeah.
If she can file a copy of the contract, we'll take it when next class.
No, no, that's right. What I am saying is that Mr. Bhatt also wanted to clarify something. He was stopped that he cannot interfere in the court. So please don't mind it.
My lord, the question was on a disallowance of ITC. And my ITC should not be disallowed because my supply was completed, my export was completed.
Madam Renu, your ITC was not denied, your refund was denied.
Refund was denied.
There is a difference. That's where you have to read the law.
So
You are on a
was
very
along
different
with the-
tangent than what your case is.
Along with the eligibility of
That's what
ITC
you are on a totally different tangent than what your case was. That's where you got confused.
What's the fourth ground?
No, there's no fourth
That
ground.
That's it. Okay.
We can adjourn the
So,
matter.
We will adjourn the matter with the directions to you. Under Rule 45, you have to bring all these evidences again,
my lord.
which are missing today, and you have to satisfy this court about the ownership of these goods, and you have to bring the bill of entry and FOB of the value of those goods also.
Yes, my lord.
Correct. So with a complete trail, and
Yes, of course. Surely. Surely.
And regarding that first question of valuation, yeah, that is the main issue. So we'll go with the appellant, and that will be allowable. And regarding question number 2, regarding export of goods and payment received. So here the matter has to be
Examined again.
examined again. Correct? And next was your
Only one thing is wrote all the 3 shares to file documents. You are arguing the best appeal in this Moot tribunal after Rashmi Jain. You goofed up because you didn't create correct evidence. You really goofed up. Once you attach a circular, read circulars each line. Otherwise, don't depend on this. The tribunal is least bothered about circular. There are no departmental officers is binding upon them. They have taken a different view now. जब अपील बनाते हो गूगल से कट पेस्ट नहीं करना है.
I took the RBI guidelines for my reference.
So you
actually.
didn't read guideline Vastro account. आप उसमें लिखते हैं हमें Vastro account.
There was-
The circular you wrote was for e-commerce small exports,
That was a declaration.
and that was
from the
25.
bank, there might be
And how will relate back to 23?
So when the issue came
that
up
circular
with
is
me, then the
25. They are
declaration
not
was-
giving a letter to you. The circular you close was November 25. I mean, March 25. How can you relate back to 23?
Okay.
ध्यान से जल्दबाजी नहीं.
फायर ब्रिगेड
Well done, Renu.
फायर ब्रिगेड का
Longest
पंचनामा भी
appeal
लेकर
argued.
आए
God
हैं
bless you.
और जो आपने ई कॉमर्स के थ्रू एक्सपोर्ट किया है उनका उसके भी सारे
Details will be provided.
She got confused. Now, friends, here there were 4 issues. I'll take another 2-3 minutes, notwithstanding what my team says. One was the valuation. Rule 46 says lower of the value. It is in contradiction to section 15. So, honorable judges have accepted her case that you can adopt a higher value for refund. Department can go to High Court. How can they go against our rules? But rules cannot override that. So, if you are depending on a INR receipt payment based on a freely convertible foreign exchange, you have to strictly comply with the proviso to section 16(3) IGST Act. Strictly means exactly strictly. You are basing on a notification. So, remember Dilip Kumar judgment of Supreme Court. If a notification is subject to a debatable interpretation in favor of revenue will go not against the SSC, not in favor of SSC. So, she goofed up. She didn't say it's a Vastro account. Vastro accounts are the Nastro, Vastro, they are different accounts for different purposes in the foreign exchange. And banks are very strict. Government is very strict on these issues. So, not that payment was no payment. India से भी ले सकती थी payment आ गई थी मेरी किताबों में कुछ भी लिख दो आप. हाँ तो इन्होंने बैंक में लगाया ना सर्टिफिकेट. They didn't have a Vastro account. The circular was for a different purpose. These were not her exports. तो वो जल्दबाजी में लगाया क्या. So now the Honorable Tribunal give me more judgments. Ship sinks. There are 3 Supreme Court judgments on this issue in Customs Act. 2 are against the SSC, 1 is in favor of the SSC. Section 7 has to be interplayed with section 16 and definition. If supply could be made without delivery of goods, if we talk of FOB contracts, then this is a constructive delivery. The importer may never receive goods, right? So this FOB contracts never means that the risk passes. A risk will pass if it's a contractual term and condition. It's a free on board, the ship crosses territorial waters, it's okay. But you cannot invoke whose risk is this. That depends on what contracts you have entered into. Then the Honorable Tribunal also has to decide whether 17(5)(h) does it have any interplay with the sinking of ship. We are going to argue at length that this is not, refund cannot be given in these cases. A revenue has to only argue this. We cannot say to give the refund. And the 4th issue was, what is it? Now, when we talk of intermediary, subcontracting has to be authorized by the contractee. It's a settled law in the world. Especially in international transactions, you may be dealing with all kind of people. She may have subcontracted to a terrorist. He cannot give money to a terrorist. And if you are doing back-to-back contracts, the terms in the main contract and subcontractor have to be identical. If you are changing the terms and conditions, then this is not a subcontracting. You are creating a new contract. You can. But that benefit of circular may not come to you. Because you are taking a benefit that main service was subcontracted. Main services is 4. In the agreement you write 2. 2 are gone. When you do enter into subcontracting, the scope is totally different. Compensation different. Termination is different. That means Renu Sharma did not apply her mind to draft carefully the contracts. Tribunal will not go into your invoice. Invoice has no value in any court of law. I am making it open to you. Invoice does not show any transaction. The purpose of invoice is the reimbursement of price. आप कुछ भी लिख दो उसमें क्या फर्क पड़ने वाला है? So international WTO convention is there. International transactions are governed by contracts. I can also call a copy of letter of credit. उसमें लिखा होता है किसका रिस्क है, कौन पैसे देगा उसके. So once you are claiming refund on account of unutilized input tax credit, we have to try and understand that can section 16, 17 will interplay
with the claim of refund under 54? But that's a very big question. When I was drafting this order, I drafted it for her because I know if she has to slog, and she slogged. But I think of late she failed. She went to Calcutta and some शादी वादी जो भी था इनके घर में, वहाँ गुड़ गड़बड़ हो गया इसका, सब गड़बड़ हो गया. And in law, never take things for granted. You have to first know what is devil's argument, revenue counsel's argument. पहले आपको उसको बताना है क्या मैं उसको onslaught झेल सकते हैं आप हम तो सब कहते हैं हमें सब कुछ आता है दुनिया की हर चीज आती है हमारे को वो दूसरों ने भी बोलना है आपको. So when you prepare law, you have to read law. You are relying on a circular, you must fully satisfy the circular. If you create these kind of evidences, which is apparently on the face of it of an afterthought, वो नहीं होना चाहिए. अगर confirmation मुझसे ले लेते from Switzerland की company से, yes or over. So you have to apply your mind. If you are relying on a document which is subject to the scrutiny for a third party sitting abroad India, उससे confirmation ले लो कि भाई हमने subcontract कर रहे हैं हम कर दें. We have a very specialized associate with us. Will you permit? सिर्फ ये permission आपको लेनी थी. This was the legal input in this case. अगर वो होता तो they would have become an approving party to your subcontract. Then the revenue counsel would have never argued that there is no contractual privity. In all contracts, wherever a contract governs your transactions, take it as a default rule unless expressly excluded that contractual privity is a must to a contractual transaction if you are relying on a contract. Thank you so much. Next. एक और केस लेंगे.
Sir, even regarding that FOB contract, even the contract is missing and she has received the payment from the buyer. Can that be taken as an evidence?
The refund is not related to payments. Payment is one condition. Goods का introduce little later और 2(6) में services के लिए mandatory है. But whether export happened, payment is as a consequence of exports having been done. If I am questioning the export itself, तो goods तो उसको मिले ही नहीं. Ship डूब गया. Let's say कि beyond territorial waters defined है. अब क्या ये इसकी स्कीम है जीएसटी के कि शिप डूब गया आपको रिफंड मिलेगा? No. That is the only interplay. क्या section 7 को overlook कर सकते हैं हम? I'm not saying yes or no. I'm not going to declare my mind here. लेकिन section 7 तो आपको पढ़ना है. Section 7 supply is equally applicable to IGST Act. IGST में supply की definition नहीं है. फिर 17(5)(h goods lost destroyed, क्या ये इनके ITC को restrict करेंगे?
But actually sir 17(5)(h तब applicable होगा जब पोजीशन मेरे पास होता है goods का. जब मैं सेल
वो that's yes. नहीं वो कहाँ लिखा है? कहाँ लिखा है 17(5)(h) में?
सर वहाँ पर ब्लॉक क्रेडिट के लिए
नहीं कहाँ लिखा? नहीं कहाँ लिखा? Don't add possession in your possession. कहीं नहीं लिखा एक्ट में. Let us say आपके यहाँ से मालवी सदन से आपने कर्नाटक से माल भेजा. माल आपसे निकल गया बाहर. सुन लो, आपके पोजीशन में माल तो नहीं है. कर्नाटक में आग लग गई उसको. ये गुड डिस्ट्रॉयड और नॉट?
सर यदि उन्होंने मेरे को रिसीव कर लिया, उसने मेरे यहाँ से डिलीवरी ली जो कहीं पे डिस्ट्रॉय हो जाएगा.
नहीं फिर आप फैक्ट चेंज करोगे कानून चेंज होता रहेगा. अभी इसको सप्लाई नहीं हुई.
अभी इसको सप्लाई नहीं हुई. $1 million क्वेश्चन जो है वो है कि प्रॉपर्टी इन गुड्स बिलोंग्स टू whom? If the property in goods are with buyer, क्वेश्चन खत्म. If they are with seller, इंश्योरेबल इंटरेस्ट किसका है? दोनों चीजें आपको देखनी है बस.
कहाँ लिया डॉक्यूमेंट कहाँ है? चलो नेक्स्ट चलो नेक्स्ट पे टेक वन मोर क्विकली.
Thank you, judges. Thank you, SU sir. Thank you, ma'am. I request everyone please not to interfere between the proceedings of the tribunal. Please don't mind. Any questions you may have, please raise after the matter is over. Thank you. Item number 4, represented by Advocate Rajmani Jindal. Friends, the appeal is going to teach us the concept of pure services when provided as per entry 3A, 3 and 3 capital A of notification 12/2017, which provides for example pure services, composite supply of goods and services in which value of goods does not constitute more than 25% that are provided to the central government, state government or union territory or local authority by way of any activity in relation to any function entrusted to a panchayat under Article 243G of the Constitution, or in relation to any function entrusted to a municipality under Article 243W of the Constitution. A very important concept, more so when majority of the infrastructure litigation is going on to happen for and with government services. Thank you.
Honorable President and Honorable President and his companion members of the DGST Tribunal, the most respectfully I submit for kind consideration of this tribunal. All the conditions have been mandatory conditions have been satisfied. Now, my lords, I'm just discussing on the pure services. The pure services means which does not deals with goods or does not fall under the definition of the goods or deemed services under Schedule 2nd of the GST law. My lords, now the brief facts I'm just deliberating. The Appellate the Agra Government Service Providers Private Limited, the Appellant Company. My lord, this is page number 16. 60. Yeah, 16. Statement of facts. Got it? Yes, my lord. The Agra Government Service Providers Private Limited and Appellant Company near Taj, Agra. It is the registered tax payer under Section 25 of the DGST Act. My lord, this is dealing in the this company is dealing in the pure services under notification number 12 by 2017 as amended up to date. My lords, under Section 67 of the DGST Act, a search was conducted for the tax period 23-24 because the appellant had not filed the returns under Section 39 of the DGST Act. My lord, the returns could not be filed because to disclose all the transactions and the claim exemptions because the return was because the regular CA of the firm who was entrusted with the responsibilities and he was responsible for the maintenance of the books of account, and the main partner of the firm, Shri Ramesh Sharma, had to go out for station for some very critical family matters. And in this process, no communication also took place, my lords. As the company always had unutilized input tax credit, the tax payment was not to be made in cash. Further, the said CA firm had given a written advice that the transactions we have with various clients are covered by the notification number 12 by 2017, my lords, under the various heads. Under this bona fide belief and based on the best professional advice, the company could not be said to be suppressing the facts as alleged by the proper officer or details from the revenue to evade tax. The appellant shall be and is always willing to discharge its legitimate tax dues, notwithstanding whether it charged the customers or not, my lord. Hence, the intention was never to suppress the turnover or to avoid making of the payment of tax. My lords, I just also want to state that for the tax period 23-24, which is the main allegation of the proper officer, we have deposited all the tax with interest and penalties till date, my lords, in the month of July, on 15th of July. We have, yes, my lord, and we have attached that on as annexure 11 or 11A, my lords. It is the appellant company could not produce the books of account or related documents like contract and agreement. This is the only reason, my lords. The appellant was then served SCN on 4th of January, my lord, annexure A4 by the proper officer zone 3 under section 74 of the DGST Act, with CGST Act, IGST Act, and also with relevant rules for the period 23-24. The appellant was show cause as to how the services provided to various agencies are held exempt under the Act or notification 12 by 2017 as amended up to date, and why not GST at the rate of 18% with interest under section 50 of the DGST Act, and consequential penalty under the law will not be imposed. My lord, we respectfully submit that our finance manager Shri R.K. Sehgal did appear before the proper officer on 4th when the notice was put on the portal to take up the matter, and but due to his preoccupation, the proper officer, due to his preoccupation with some recovery meetings, he waited up to 5 p.m. to appraise the proper officer of the helplessness of the situation. The appellant is and to seek more time. He wanted to explain the whole situation. The situation is that Mr. R.K. Sharma, who is the regular CA firm, he was away with the family for few months on the critical family meeting, and he could not all the documents, whether it's a contract, agreement or documents, it's with him. So we are not in the position to give any document or attend any appeal or any notice, show cause notice meeting. Another notice on 27th of January, Annexure 5 by the proper officer under section 74 of the DGST Act, read with CGST Act and IGST Act also, for the tax year 23 was received as the last opportunity to appear and file documents by 10th of February. Again, our finance minister appeared before the proper officer and handed over the request letter for adjournment to him, but he refused to take that letter on record and angrily conveyed that no further time could be taken in this case, as this matter of recovery, and this is a matter of recovery of admitted tax, and that cannot wait. All pleadings with the proper officer did not result into any fruitful decision. And then, my lords, adjudication order dated 10th of February, Annexure A6 by the proper officer, read with under the DGST Act, CGST Act and IGST Act, also with relevant rules for the tax period 23-24 was received, stating that all the services rendered by the appellant are taxable services without any exemption. Hence, the entire turnover reported in the balance sheet, that is 38.2 crores, is to be taxed at the rate of 18%, determined 6 crores 87 lakh 60,000, interest 1 crore 45 lakhs, and penalty and proceeding shall be initiated separately. The appellant filed rectification application, my lord. This is kindly to be noted. I filed a rectification application then on 2nd of May itself, within a statutory period, and against the adjudication order of 10th of February, and that was also that has also been decided on 8th of May itself, Milord. 8th of May, Milord. This is the point to be noted, is that when this is within the period of 3 months, this is within the order was of 10th of February 25. I filed the rectification application on 2nd of May, and the order came on 8th of May itself.
So it is 6 days.
6 days? No. 10th May we will complete the 3 months. No. Yeah. That is okay. It will totally take 6 days only. Yeah. Yes, Milord. Yes. That is okay. He stated that all the records be stated in before the proper officer, that all the records are with the chartered accountants. He was out of station for few months, and that is why we could not attend the show cause notice. Filed reply and also prayed that the adjudication order dated 10th of Feb may be withdrawn and heard on merit. Shri S.K. Mangla, director, was personally present and reiterated the grounds of the rectification application in detail. The rectification application was dismissed by the proper officer or 8th May, as I stated earlier. Agreed by the adjudication order of 10th of February, Annexure A6 of proper officer, and the dismissal of the rectification application dated 2nd May under section 161 of the Act. The appellant filed appeal before the Honorable Appellate Authority, Joint Commissioner, under section 107, subsection 1 of the CGST Act on 1st of June. The appeal was filed after mandatory statutory period of 3 months without condonation of delay application under section 107, subsection 4. Yes, my lord.
Your appeal was filed under section 107 on 1st June.
Yes, my lord. but within the statutory period of 3 months was over, but within the another 6 months of continuation of delay period.
1 month.
1 month. 1 month. 1 month. Yeah.
But you did not file any application for the
Yes, that's true, Lord.
Yeah.
We
And your rectification application was disposed of on 10th of
8th of May.
8th of May.
Yes, ma'am.
8th of May.
Yeah.
So from 8th of May till 1st of June.
Yes, my lord.
What was the reason that you kept on waiting and you did not file the
Number one, my lord, we were not aware of what we have to answer. We were not so educated to answer or deal with this matter. We were just waiting for some expert legal advice. So first we have arranged for that. This is what we have written. I will explain. This is the only sufficient cause or reason we took 21 days to answer. 20 days to file appeal before the tribunal.
You are putting a reliance on a Supreme Court judgment.
Yes, my lord.
So as per that judgment, how much grace period can you exercise?
I filed this application on 1st of June. 20 days was, but still 10 days were remaining.
No. We'll discuss it later on.
Let me come just a moment, my lord. Let
to complete your
yes. My lord, kindly see the impugned order on page number 33, please. The order of 1st June.
Before going into the merits and order.
No, I'm just coming on the grounds of appeal. Just a moment, I want to, because since I'm discussing about the period of the delay and all that, so I just want to show in the order. Yes. 34. My lord, section 107 subsection 4, the appellate authority may condone a delay up to 1 month if sufficient cause is demonstrated by the appellant for the delay. ऑर्डर में खुद ही ये लिखा हुआ है ऑनरेबल अथॉरिटी ने कि 107(4) में 1 महीने तक वो कंडोनेशन डिले कंडोन हो सकती है अगर सफिशिएंट कॉज दिखाया जाए तो जब मेरे को 1 जनवरी को पहली बार SCN दिया गया, फिर 27 को दिया गया, हर बार मैंने अपनी जाकर पोजीशन बताई, कोई फैक्ट्स नहीं छुपाया. So much so, on 15th of April, 15th of July, I deposit all the tax, interest and penalty so that I can prove my bona fide. I have no intention to evade tax. Because I have a genuine problem. I don't know how to put my case before the honorable authority. I was relying on my CA. He was not there. He has gone out for some critical family meeting and whatever the reason, he was not there. And when I called him to take the records and all that from his office, he said that the books were not updated. Because since he was away, he could not devote time. So I was having no detail. At that time, I asked him to give me some legal advice. That is attached with this at page number 104. Kindly see.
104.
हाँ जी.
Whether your books are being audited?
Yes, my lord.
And the same chartered accountant is auditing?
Yes, my lord.
And he is writing the books up?
Yes, every books he was maintaining.
Your chartered accountant is maintaining your books of accounts also. He is issuing you legal opinions also.
Yes.
And he is doing your auditing also. So he is doing all sort of works, whichever
Multitasking, sir.
they are probated.
But they
No.
institutes regulations.
Audit part he is not doing. He was just
No.
Yeah, that is a slip of tongue, I can say. He was
Stick
just maintaining the books of account.
He is writing books of
I apologize for that.
No, but the books of accounts were in his possession. Means what?
बुक्स लिखते थे वो सारी जो बुक्स अकाउंटेंट का भी काम अकाउंटिंग सर्विसेज वगैरह भी करते थे.
अकाउंटिंग सर्विसेज रमेश शर्मा दे रहे हैं.
हाँ, उनकी जो पूरी फर्म है उनके ओनर जो थे वो रमेश शर्मा थे.
ओके.
और जो बाकी अकाउंट्स वगैरह का मेंटेनेंस ऑफ बुक्स ऑफ अकाउंट थी वो उनके ऑफिस में होता था.
Means it was being done under one umbrella.
Audit part I have not said.
No, my lord, the question notwithstanding, question is whether the first appellate authority should have condoned the delay or not.
No, Verma ji, there are many fallacies. I'll come one by one on technical things.
Yeah.
Let me start without going into cases. The first appellate authority in its order dated 7 June 25 stipulates that you had filed appeal against adjudicating order. Education order.
Yes.
Dated 10th
February.
Is it correct?
Yes.
Do you admit?
Yes.
I am again asking you. Do you admit this?
Rectification order.
Now again you are changing the statement. आपने अभी बोला कि आप जो है वो
मैं 10 फरवरी के ऑर्डर के अगेंस्ट मैंने रेक्टिफिकेशन फाइल करी.
आपने यहाँ पे लिखा द फर्स्ट एपलेट अथॉरिटी इन इट्स ऑर्डर डेटेड इतना जो फर्स्ट एपलेट अथॉरिटी ने बोला है उसमें उसने बोला है कि आपने अपील फाइल की है एजुकेशन ऑर्डर के अगेंस्ट
10th February.
डेटेड 10th February.
Yes.
करेक्ट. इज इट करेक्ट ना? आप उसी ऑर्डर के अगेंस्ट ही अपील में है ना?
उसी ऑर्डर के अगेंस्ट नहीं मिलोड. रेक्टिफिकेशन का जो ऑर्डर है, जो रेक्टिफिकेशन का ऑर्डर है,
रेक्टिफिकेशन का ऑर्डर तो आपका आया 2 मई को. आपने 2 मई को रेक्टिफिकेशन फाइल की है.
हाँ, मैं इसी ऑर्डर के अगेंस्ट हूँ.
Again 10th February only she
Yeah, only 10th February.
As per appeal.
Yes, only 10th February. Yeah.
ये जो आपने रेक्टिफिकेशन ये 161 में ये रेक्टिफिकेशन जो आपने फाइल की है ये किस ऑर्डर के अगेंस्ट की है?
ये मिलो 10 फरवरी के ऑर्डर के अगेंस्ट हमने रेक्टिफिकेशन फाइल की.
और ये दिस वाज पास्ड बाय द प्रॉपर ऑफिसर.
यस मिलो.
एंड you have filed an application of rectification with the same officer.
Yes मिलो.
Okay.
It was dismissed.
It was dismissed.
And then it was.
Then we filed an appeal before under 1071 before the Joint Commissioner Appeals.
That is also in time.
That is
delay by 1 month. I mean.
But within a condonation.
Within condonation time, exactly.
Yes.
Now,
that's the only issue.
But you missed file an application and affidavit and the required fees for filing this an application for condonation of delay. You did not file that.
No, I filed. No, it's there.
आपने जो अपील फाइल की थी वो नहीं, वो आपने 10th फरवरी के ऑर्डर के अगेंस्ट की थी.
हाँ जी.
ठीक है. 107 में.
हाँ जी.
करेक्ट. अब आप आए अपने APL 05 पे. पेज नंबर 5 खोलिएगा अपनी पेपर बुक का.
हाँ जी.
इसमें जो फर्स्ट पैरा है उसकी लास्ट लाइन पे आ जाए आप. एन अपील अंडर सेक्शन पहले निकाल लें पहले आप.
हाँ जी, निकाल लिया.
हाँ जी. फर्स्ट पैरा जो है द एक्ट से शुरू हो रहा है.
हाँ जी.
उसके बाद नीचे आप आते जाएं.
हाँ जी.
बाय होल्डिंग डेट देयर इज नो एरर ऑन द फेस ऑफ ऑर्डर एंड ऑन 1 जून 25 annexure 2 एन अपील अंडर सेक्शन. यहाँ से पढ़िए आप. पेज नंबर 5 APL 05 जहाँ आपने लगाया हुआ है.
हाँ.
फॉर्मेट जो है.
हाँ जी, ठीक है. पैरा डिस्क्रिप्शन एंड क्लासिफिकेशन ऑफ.
नो मैडम आपने ये जो APL 05 है आपका,
हाँ,
इसका सेकंड पेज,
पेज
नंबर
4,
4,
the act by the proper
यस,
officer.
इसमें थोड़ा सा नीचे आइए, जहाँ रमेश शर्मा चार्टर्ड अकाउंटेंट के बाद could not reply to SCN but dismissed, यहाँ पे आ गए आप?
हाँ जी, हाँ जी,
यहाँ से आप पढ़ना शुरू कीजिएगा.
Chartered accountant of the company could not reply to SCN but dismissed by holding that there is no error on the face of the order, and on 1/6/25 an appeal under section 107 was filed against the rejection of rectification order before the honorable appellate.
ये कहाँ है? ये अपील कहाँ है?
ये आपने थोड़ा गलत लिखा.
ये अपील कहाँ है? आप हमारे पास जो आए हैं
वो मैं आपको 10 फरवरी के ऑर्डर के अगेंस्ट.
नो बट आपने जो APL 05 मेरे पास फाइल किया है वो तो आप फाइल कर रही हैं अगेंस्ट रिजेक्शन ऑर्डर.
यस मिलॉर्ड.
तो दिस इज अ टेक्निकल, योर अपील इज नॉट मेंटेनेबल. मिस्टर डी.
No, Your Honor, APL 05, to be helping her out, it's a matter of procedure. A technicality should not come in the way. The main appeal grounds are taken against 10th Feb 25 order. So this is, I'm sure this is a mistake, as Your Honor have.
I apologize,
no doubt about it. But this is a matter of procedure. Form is a matter of procedure. And in the first tribunal, you even maintained the appeal without filing an APL 05.
No, that is right. But the only thing is that what is the intent? The intention is to file appeal against the adjudicating order, adjudication order, or against the rejection order. So इसीलिए मैं शुरू से बार-बार उनसे बार-बार क्यों बोल रहा हूँ adjudication order, education order, क्योंकि यहाँ पे इन्होंने जो उनसे यहाँ पे मेरे पास जो ये अपील में आई हैं वो आई हैं ये रिजेक्शन ऑर्डर की अपील, जिसकी अपील कभी फाइल ही नहीं हुई, जिसका कोई ऑर्डर ही नहीं है.
That is a technical error, my lord.
नंबर 1. इसके बाद चलिए अब आगे आएगा.
मिलॉर्ड मैं वापस अपने ऑर्डर पे ही आऊँगी, पेज नंबर 33 पे इम्प्यूट ऑर्डर जो है. Admittedly, Millard, page number 34. Admittedly, the appeal was to be filed against the order dated 10th Feb 2025, and this has been filed on 1st June, which is way beyond the statutory limitation prescribed. Further, there is no application for condonation of delay filed by the taxpayer on any ground. The only ground taken is that the appellant was waiting for the result of the rectification application. Lord, even on this issue, the rectification application was dismissed on 10th May. It was not dismissed, it was dismissed on 8th of May. And the appellant took another 21 days to file the appeal. If it had been vigilant to file the appeal on before it would have been covered under the condonation period under section 107. Nothing has been brought to my notice to show that how can I can entertain this appeal, which is filed much beyond the maximum period, including the condonation period. My lord, this is wrong. Condonation period में भी अभी 20 days, 10 days बाकी हैं, अभी 10 दिन नहीं हुए. This is again wrong. फिर last 2-3 lines, my lord, kindly pay attention. Notwithstanding this, the undersigned has no power to condone the delay beyond the maximum permissible period, that is 1 month, in terms of section 107, subsection 4 of the DGST. Hence, I dismiss the appeal as time barred. This is not time barred. This is even the honorable authority was not appreciating the facts. Lord, I just want to submit this. Okay, the honorable authority has not appreciating the facts. The period was still remaining. My lord, kindly, I just want to mention one citation. रजिस्टर साहब ये दे दीजिए. इसमें my lord, just kindly see this citation, उनको भी दे देना. 3 months का कैलकुलेशन कैसे करना है, दिस हैज़ बीन डिस्कस्ड इन अबाकस केस लो साइटेशन. यस my lord. इवन इसमें लिखा हुआ है अगर लास्ट डे का भी पीरियड है तो दैट हैज़ टू बी काउंटेड. यस my lord. एज सेक्शन 9 ऑफ द जनरल क्लोज एक्ट इसको एक्सप्लेन करता है, ठीक है मिलॉर्ड। फिर उसमें विद इन द पीरियड में भी ये बताया गया है कि द ऑनरेबल हाई कोर्ट हैव फर्दर ऑब्जर्व दैट सेक्शन 9 ऑफ द जनरल क्लॉज एक्ट प्रोवाइड गाइडेंस टू हाउ टू कंप्यूट पीरियड्स ऑफ 3 months टाइम स्पेसिफाइड इन द स्टैट्यूज। तो इसमें आई एम वेरी मच कवर्ड इन दिस मिलॉर्ड। तो 3 months का जो 3 months का पीरियड मेरा अभी उसमें अभी ख़त्म नहीं हुआ था, कंडोनेशन पीरियड 10 days वर रिमेनिंग। तो ये वाला बात जो है कि ये दिस इज़ टोटली रॉन्ग कि अंडरसाइंड हैज़ नो पावर टू कंडोन द डिले, नंबर 1। सेकंड, आई विल कम टू सेक्शन 14 ऑफ द लिमिटेशन एक्ट। अगर इसमें वैसे तो वेरी मच आई एम कवर्ड विद इन दिस कि ही हैज़ ऑल द पावर, और इसमें आई जस्ट वांट टू स्टेट वन मोर थिंग मिलॉर्ड, the honorable authority, if the court considering condonation of delay, if it is a meritorious case, as my case is there in this condonation of delay, he can on his own motion he can condone the delay. It can direct that a formal application with affidavit to be filed same day to ensure a proper record for his record and allow the other party to respond. Of course, that is revenue. The honorable court should not disregard the merits of the main matter simply because of the procedural delay, if the reasonable explanation is provided. मेरे केस में मिलोड, नंबर 1 अभी 1 month एक्सपायर नहीं हुआ था, नंबर 2 if I go for section 14 of the limitation act, I am very much covered in that also. Now I will come to my grounds of appeal, my lords. Kindly see.
I think first is the matter of first is condonation merits have no role.
Sorry?
Because first is of condonation, only then appeal can be heard.
So on that, but do you want to say something regarding that?
See, I would like to say that the provisions of section 107 subsection 4 are sacrosanct. The limitation, the statutory limitation is 3 months. 1 month is not your right. It's a pure discretionary power of the first appellate authority, but it has to be exercised judicially. So that's more important. Now, in this case, the appellant did not file a condonation application. Where she admitted I am uneducated, but her chartered accountant was not uneducated. He was writing books, auditing, and doing everything, and they were too much dependent on the chartered accountant. That's a fact. They filed a rectification application within 3 months under as per section 161, and the rectification period, there is no provision in section 107 or in any part of the act where such periods could be excluded. That is the scheme of the act, right? That is the scheme of the act, especially for the section 107. Wherever they wanted to exclude period, for example, the stay orders and refund applications, there the legislature mandated this period could be excluded. But here, I mean, off the record and to be fair to the tribunal, I have to concede the judgment of MP Steel Corporation, which the appellant has annexed. This judgment deliberated right from Mukri Gopalan to Madan Lal to Parson Tools. Mukri Gopalan was a judgment by 2 judges, which was interpreted by 3 judges in Parson Tools. Then came Madan Lal case, and ultimately they said that sections Article 14 of Limitation Act being a beneficial provision, it should not only apply to the courts, even to the authorities like tax authorities, right? So this judgment may help, but here the problem is, here also there is no condonation application filed which is directly to be heard by the first appellate authority.
This is what I am coming to.
Yes.
That the judgment she is relying on is MP Steel.
Yeah, another judgment also, my lord.
No, but this is Supreme Court, so you don't have to bother about other judgments.
Don't bother about it.
Okay.
You are basically invoking section
14.
Article 14.
Article 14.
Limitation Act.
Limitation Act.
Yes, my lord.
Correct. So,
let me read, my lord.
1 second. The Supreme Court, Honorable Supreme Court, in the case of MP Steel, has held the party who invokes Article 14 should not be guilty of negligence,
Yes, my lord. Yes, my lord.
lapse,
Yes, my lord.
or inaction.
Yes, my lord.
Further, there should be no pretended mistake intentionally made with a view to delaying the proceeding or harassing the opposite
Absolutely,
party.
my lord.
Correct?
Absolutely.
But in your case, you have intentionally not filed the application for condonation of delay,
No, no.
and you have violated the condition of section 14 by your inaction and lapse in filing the appeal in time, and thereafter not filing any application for condonation of delay before the first appellate authority. Correct? So this, by not filing, this further adds to your inaction and lapse. So you are basically not compiling the conditions mentioned in Article 14, correct? Then at page number 33 and 34 of the judgment, while discussing the judgment of Parsons Tools, the Honorable Court held that the Limitation Act will not apply to appeals or applications before the tribunal unless expressively provided.
That's
Right.
true. That's
In
true.
GST laws, applicability of Limitation Act has not been expressly provided anywhere.
No, Your Honor, in MP General judgment, they applied this judgment to the authorities like tribunals. Parson tool they were referring in reference to Mukri Gopalan's case. Last 2 pages are very clear on this, right? They apply. Now, the only benefit which the applicant can get is she has deposited the entire tax.
She has deposited the
Entire
entire
tax, not only pre-deposit, and there is definitely in action, and like you Honor rightly pointed out, okay, the crux of MP General is this.
Yes.
But to be helping them out in the tribunal
in
as
the
revenue
interest of-
counsel
in the
and in
interest
the
of-
interest of justice,
Yes.
she did file rectification application time. There was no role of inaction there, and the rectification application disposed of. But she took 20 days to
20
file the
days
appeal
thereafter.
on the ground that she said that I'm an uneducated appellant. I don't know about all this. But within the extended 1 month, 8 days were still to go.
Yeah.
She filed an appeal.
Correct.
Number one. Number two, when she went to the appellate authority, she did not file condonation application. Right? Now, condonation application is a part of our GST mechanism. But there, the appellate authority should have asked her, it was within that 1 month of condonation period discretion. If it was to be exercised judicially, she should have direction, can you file condonation application now?
Yes, my
Had
lord.
she done it, the case was over.
This is what I described.
I would say the Honorable Tribunal should order file condonation
File
application
condonation
and let him dispose of
That's what I'm-
based on MP General Corporation.
MP General.
And she has to file the rectification application also. Now, if a rectification application dismissed, Your Honor, the original order never merges in rectification.
Yes.
So limitation has to start from 10th February only.
10th February only.
She need not file an appeal against the rectification application.
no.
Only if it's partly accepted, then the original order merges with the rectification application.
Correct.
I mean, Your Lordship know more, far more than I know
No,
about
no,
income
no,
tax.
no.
So this is the law. I think she could be shown some respect, subject to cost.
Yes, subject to cost. The order has already been drafted for cost.
My lord, I
Yes.
just want to state few lines.
No, now because there is no point now. Though you are not absolutely covered with MP Steel, but then also in the interest of natural justice, despite having violated the provisions of Section 107 and Section 17 of Limitation Act, but in the interest of natural justice, this court remands back the matter with first appellate authority and to decide the case on merits and levy cost of 50,000 rupees on appellant, which has to be deposited within 2 weeks of this order with Delhi GST Professionals Group registered. All rights and contentions of both the parties shall remain open.
Highly blessed, my lord.
Now, before we go for lunch, understand the law, where most of us are committing huge errors. If you get an adjudication order, 73, 74, there are only 2 orders you get. There is no other order. There is no other demand and recovery order you can ever get. Right? If you need rectification, don't wait for 3 months. If the demand was 10 crores and you had paid 5 crores, if you don't file rectification, you pay 10% of 10 crores. If you get it rectified, you pay 10% of 5 crores. If certain deductions are not given by mistake, they say you have to read 161(3) and proviso. That is the scope of rectification. बाकी छोड़ दो बकवास है 1 and 2. Rectification, what is rectification? We must know what is the term rectification. Rectification is a process whereby your original order is subjected to alteration. Where, yes.
Sir, I would just like to poke in between. I discussed with you, been facing the same issues. Sir, in adjudication, after the order has been passed either in 73 or 74, we have 3 months without the condemnation to file the appeal. But if I immediately, say within 7 working days after receiving the order, I am aggrieved with the order and I file the rectification, the officer has got 6 months to look after the rectification. And in most of the matters, officers beyond 4-5
Doesn't matter, we'll come on this, we'll answer this issue. Let us say you filed rectification within 7 days. Let us say what Rahul says. I know this case, right? Now supposing he passes order after 8 months. You have not filed the appeal. There is no bar, you cannot file the appeal, right? But the appeal will not be filed till you deposit 10%, right? So move an application, a second application to officer, I want to file the appeal and I have this much time, deposit us. He will deposit us. There is no doubt he will not deposit us. You have to be, as a lawyer, act as a lawyer, not as a goo type person. Tell him, sir, I have to file an appeal. So if you have rectification disposed of after 3 months 20 days, so the limitation statutory 3 months is over. 20 दिन और निकल गए आपके. So ये 3 महीने 20 दिन का period shall be excluded for the purpose of calculation of 3 months time, not extendable time. This time is excluded only for the purpose of calculating statutory period of limitation, which is 3 months. 1 month is condonable. Now supposing 3 months were over, you are still in condonable. This is where section 161 comes into play. Okay, your condonation should be accepted if you prove that you were pursuing an alternative remedy before the same forum or wrong forum for the same purpose. That is the scope of rectification. But if you simply file a rectification application, it has no legs to stand, तेरा order natural justice के खिलाफ है, ये बकवास सब लिखते हैं हम लोग जो, it is not a rectification application. A rectification is basically arithmetical errors or error of jurisdiction. Jurisdiction is always subjected to, under section 154 income tax, or here subject to rectification. Apparent on the face of record, of course, that is a rectification. Now in our rectification, this is not error apparent on face of the order. It's an error apparent on face of the record, which is much bigger term than the order. आपको order में गलती नहीं ढूंढनी. Supposing राहुल कक्कर ने उसको 50 डॉक्यूमेंट दिए जिसको रिलीफ मिलता है, उसने रिलीफ ही नहीं दिया. This is an error apparent on record. So you have, as lawyers, we should know the differentiation between error apparent on record, error apparent on record and order. CPCA में error apparent on face of the order है. When you go to tribunal, this is all error apparent on face of the order. But 161 is error apparent on record.
Even in income tax also, under section 154 also, it is error apparent from record,
yes,
not on order.
Yes, yes. But I'm talking of tribunal orders are error apparent on record. So, yes.
Sir, you mean to say if I have given the document and the document clearly give me the relief for that, which the officer has not given to me,
It's a case for rectification. It's a case of rectification. Right? Now supposing it is not rectified, then don't dispute, you have to deposit 10% of the original demand. Now there you cannot say that I am appealing against rectification and till then I will not file appeal. That will be stretching it too much. That is not Article 14. One stage you can exclude. अब वो राहुल के केस में 6 महीने बाद उसने रेक्टिफिकेशन की, अगले 3 महीने में इसने अपील फाइल की, मेरा स्टैट्यूटरी राइट है, उसको 2 साल लग गए. Like in this case of MP Steel, a delay of 8-9 years was there between the order and order. They excluded that period. This is the only judgment in the history of tax MP Steel. There is no other judgment of Supreme Court. अगर किसी हाई कोर्ट ने रिलीफ नहीं दिया, ये जजमेंट वहां कंसिडर नहीं की, don't bother about the high court ruling. Once you have a Supreme Court judgment, never ever read high court. It makes no sense. MP Steel clear. So Article 14 gives you a leeway. The period you pursue in an alternative remedy for the same relief before, like my lord asked a question, were you with the same proper officer? Yes, before the same forum. You can't take rectification 154, I'll file additional commissioner.
So just to add in further, what has happened in our case where I have filed the writ in the Punjab and Haryana court, we filed the application. Our appeal was rejected. As the appeal JCCT said that I cannot take because under 107, this condemnation period I cannot exclude because on the portal it is not showing me to have any kind of a provision wherein I can do this appeal, because it is showing me time barred. Either I have to do it offline. If I do it offline, then the order is also offline and your demand stays even though you have deposited 10%. So we cannot do anything. They even went to the Chandigarh, their head office, asking for the clarification. Nothing happened, and finally we had to move the writ in the Punjab High Court, and our judgment hopefully is going to.
It will come in your favor, let me tell you. Now these technicalities, we are not bothered about law. I don't bother about your form hai ya nahi hai. Least bother, this for the courts to bother, not us. Don't bother about this APL 01 वो 3 महीने अगर नहीं है तो put a physical appeal. I have a Supreme Court judgment covered. I don't care whether your portal takes or not. You take it wherever you want to take it. That's your problem. But don't miss the opportunity. कि you APL 01 में वो नहीं ले रहा, ये नहीं ले रहा, वो नहीं ले रहा, वो courts की innumerable judgments हैं. Where Supreme Court has to be followed, notwithstanding the technicalities, must has to be followed. Tran 1 में हुआ, सारे portal खोले गए. Tran 2 में portal खोले गए. So remember this limitation issue. If you screw this limitation issue, your client is gone. 4 महीने के अंदर आपको अपील फाइल करनी है. Like you say 73 की लिमिटेशन 3 साल है, एक दिन फालतू है तो केस टाइम बार्ड है. That has no value. तो you can't say कि वहां आपको लागू है, ये रेवेन्यू को जो लागू नहीं है, रेवेन्यू के भी लागू है. तो अगर 3 महीने खत्म हो गए, आपके पास 1 महीना है. 1 महीने के अंदर जो कुछ आपको करना है उसमें रिलीफ लेना है. Rectification cannot be filed after 3 months. Please remember, period is excluded if you take these alternatives within the statutory limitation. You can't go let 4 months go and then file a writ. High Court will throw you out. So जो rectification आपको जो भी झगड़ा करना है वो 3 महीने के अंदर करना है. Let him take 6 months, doesn't matter. But then if you do not file appeal, the recovery can be pressed. Recovery का rectification में stay नहीं है. Stay is only when you file the appeal. So that also you have to take in mind. That's why you have to put pressure on the officer, pass my rectification. Mark copy to commissioner. तीसरे दिन, 10वें दिन, 7वें दिन उसको keep giving him letters. Hell with him. It's his job to do it. Well, let's clap for the honorable judges. So much stress they have gone through. And we have finished 5 appeals. You can?
4.
4. We will easily finish the balance 4. Thank you so much. And Rajmani, she has won the appeal today. 50,000 रुपए DGST group को देना है उसको. अब तो पक्का देना है. अब बिल्कुल हम लेंगे. Otherwise, next time we will move on application. She didn't deposit cost. Appeal be dismissed.
फिर सबको बोल देगा प्लीज मेंटेन साइलेंस इन द
back. Now I request both the judges to please take your seats. Sir, please. I request everyone to maintain silence for the court proceedings. Next item is item number 6, represented by C. Rashmi Jain. The appeal is about the exclusion clause of section 17(5)(d) of the CGST Act, that is plant and machinery, irrespective of their movability when used in business, including for own business, can be eligible for input tax credit. Safari retreats, Honorable Supreme Court guided tax of functionality is going to be applied in this case. A very difficult and interpretational appeal being argued by Madam Rashmi Jain, including the latest ruling of Bharti Airtel by the Supreme Court, where telecom towers, though fixed in nature, have been found eligible for input tax credit. Keeping sitting on the edge of your seat to hear Rajmani ma'am, Rashmi ma'am, SV sir, and the final lecture on this topic by SV sir. Thank you. I request also to please put your mobile phones on silent mode. Thank you.
My lord, the appellant is a registered taxpayer firm dealing in construction.
Sir, Mike.
What you are going to hear is the most important topic of today's event. Section 16(1) gives you input tax credit eligibility. 16(2), 3, 4, 5 are machinery provisions कि क्या मिलेगा क्या नहीं मिलेगा आपको. Section 17(1), 2, 3, 4, 5 they tell you कहाँ क्या मिलेगा, कितना % मिलेगा, tax free ये वो करके. 17(5) deals with blocked input tax credits. The most important and draconian provision was 17(5)(c) and 17(5)(d). It is dealing with the definition of works contract in section 2 subsection 119. I told you in the morning, works contract is a means definition. So if you are doing a composite supply by way of goods, composite service by way of goods and services, that results into creation of an immovable property through those 13 activities mentioned in 2119, we say this is a works contract activity. Only such activities have been declared as a composite service in schedule, right? 17(5)(c) says and D says basically same meaning कि अगर आप कोई ऐसी works contract activity करते हैं immovable, including for your own business, ITC will be denied. That is, मैंने एक माल बनाई, मैंने किराए पे दी, वो कहते हैं आउटपुट टैक्स तो हम लेंगे पर ये अपने बिजनेस क्लब में आपको आईटीसी नहीं देंगे, राइट? आई एम ए होटल, मैंने गेस्ट हाउस बनाया जिसका मैं किराया लेता हूँ, कहते नहीं देंगे. मैंने एक शेड बनाया जो मैं किराए पे देता हूँ, वो कहते आईटीसी नहीं देंगे. But the concept was you can deny if it was immovable, but within these both subclauses there were exclusion clauses. Plant and machinery, especially 17(5)(d), they excluded, they defined what is construction for the purpose of this particular provision, and they said that if plant and machinery you are using this as a plant and machinery, ITC will be given. Plant is not defined, machinery is not defined. Earlier both the provision carry plant or plant and. This came into some disputes before Supreme Court. Odisha High Court in Safari Retreat judgment linked with output tax, input tax theory. If you are collecting output tax, why should you not get input tax credit? Supreme Court reversed it in Safari Retreat. Supreme Court did not give ITC because you are paying output tax. So when you read Safari Retreat, you have to take this in view. You have to first read last 4 pages of Odisha High Court judgment, then come to Supreme Court 92 pages. Supreme Court did not link this कि आप output दे रहे हो input मिलेगा, उन्होंने कहा नहीं. उन्होंने बोला कि ये जो plant and machinery है, is this within the exclusion clauses? Now if the plant and machinery came within the exclusion clause, ITC मिलेगा आपको. वो ITC तब मिलेगा when you are not in the covered by section 17. अगर 17(1) में वो सारी टैक्स फ्री सप्लाई करते हो तो ITC आपको रिवर्स करना है. तो सुप्रीम कोर्ट recrafted the proposition of Odisha High Court. इसलिए इसको मना करने की क्या जरूरत है? ITC ले ले. अगर तू सारी तूने प्लांट मशीनरी बनाया जो सप्लाइंग इलेक्ट्रिसिटी, तो ITC किस बात का? नथिंग, मिलना ही नहीं. तो सुप्रीम कोर्ट said कि since plant word is not defined, lot of judgments were quoted by Arvind Datar. I had a long chat with Arvind Datar also on this case. But Supreme Court said that these judgments are irrelevant. They say these judgments were passed under different enactments who have no compatibility with GST law. So they remanded the matter back to Odisha High Court to decide what is plant. Especially the Tata hotels case where the bathrooms के जो टूटियां तक were held as a plant under income tax law. There are so many judgments, cinema halls, etc. Many judgments. Now what Supreme Court went further in Safari Retreat was, they say it may be advisable to apply a test of functionality. If this was a plant and machinery and you say within the exclusion clause, what was the function of this, whatever you created? Was it required to be done in the course of your business? Was it linked with your business? And by using, did you make taxable supplies? That is by implication. Right? This is where the concept of functionality test came in Safari Retreats by Supreme Court. So Supreme Court did not lay down anything input milega ya nahi milega. This is all misnomer. Supreme Court only gave guidelines. अगर ये है तो input tax मिलना चाहिए. But since case was remanded, so obviously there was no finding. Odisha High Court has not taken up this matter so far. Then in came Bhartiya Airtel and Indus Tower. They were making telecommunication towers. Telecommunication towers are made, you pick up 4 cement and concrete pillars, उसके बीच में आप गाड़ देते हो उनको. And the government said this is removable. But the petitioner made out a case that no, they are not removable. We can detach it any time, except the cement thing goes up, entire matter we can reuse it. It is reusable at any site. And they in Supreme Court, they concept is so, and there was no reverse argument by N. Venkatraman, the government counsel. Supreme Court allowed, based on a functionality test, input tax credit on this telecommunication towers.
Otherwise, it was specifically written in section.
Yes.
17.
Notwithstanding, the concept of telecommunication turnover towers was excluded from 17(5)(d) explanation. Supreme Court said no. That is, even when these telecommunication towers were excluded, and this argument was taken by the government, that Parliament has excluded, they say no. Plant and machinery will override your explanation. हमें तो प्लांट आईटी से कहां आपने ब्लॉक किया, उसमें किया. प्लांट एंड मशीनरी है या नहीं, नीचे आपने एक्सक्लूजन किया, तो हम कहते हैं प्लांट एंड मशीनरी है. So imagine the import of this judgment. How big is this judgment? जो आप इंफ्रास्ट्रक्चर में काम करते हो, जो मैन्युफैक्चर काम करते हो, आपको हर चीज को देखना है. If it is totally immovable, ITC is denied. मतलब जिसको आप डिटैच नहीं कर सकते, ऐसे कर नहीं सकते, so safari is on a particular limit. But even if it's immovable, like they constructed mall only for the purpose of renting, Odisha High Court gave relief input tax credit. but they gave relief on the ground कि आप output tax लेते हो. They went through a GST policy, government, but which is based on लिखे उसके. But Supreme Court redefined it. कि can this mall be considered as a plant? जिसके through आप revenue कमाते हो, income कमाते हो और tax देते हो. Now, if tomorrow they hold this mall constructed exclusively for renting as per their contracts, if this is held as a plant, imagine the scope of this functionality test. बहुत बड़ा test होगा. तो before you read any high court advanced rulings, जो हम advanced ruling कभी नहीं पढ़नी चाहिए आपको. It has no sense anywhere. It has no meaning. It's not even binding on the department. तो इसका वो सिर्फ उस एप्लीकेंट पे बाइंडिंग है जिसने दी है, एक्ट में लिखा है. हाई कोर्ट की जजमेंट आपके खिलाफ है, यू हैव टू रीड हाई कोर्ट विद इंटरप्ले ऑफ सुप्रीम कोर्ट रूलिंग. लेटेस्ट सुप्रीम कोर्ट जजमेंट्स आर बाइंडिंग, नॉट द ओल्ड जजमेंट्स, राइट? सो रश्मि जैन इज गोइंग टू आर्ग्यू दिस वेयर शी इज इनटू बिजनेस ऑफ कंस्ट्रक्शन. शी हैज constructed an RMC plant and revenue has denied input tax credit. Am I right? Please go through. Yeah, sir.
सर जैसे अभी आपने बोला कि मॉल में अगर डिसाइड हो जाता है तो डेट विल बी ए वेरी बिग ब्रेक थ्रू, बिकॉज उसी लाइंस के ऊपर पे जितने होटल्स हैं, जितने रिजॉर्ट्स हैं, जो भी मतलब है वो सब प्लांट में आ जाएंगे.
What my video have said so? Okay, this is the endless scope now. नहीं, because this was not a point before Safari. Supreme Court was not considering hotels. जो होटल वाला केस इनकम टैक्स का किया गया था, वो कहते हैं हम तो होटल की बात ही नहीं कर रहे हैं. द केस वाज बिफोर ए कमर्शियल मॉल, उसको डिफाइन कर रहे थे. उसके बीच में उन्होंने लीगल प्रोपोजिशन डाली. सफारी में कोई ऑर्डर नहीं हुआ है. सुप्रीम कोर्ट डिड नॉट गिव एनी ऑर्डर, बट सुप्रीम कोर्ट गेव गाइडलाइंस कि अप्लाई फंक्शनैलिटी टेस्ट. दैट इज द ओबुलेट डिक्टा ऑफ सुप्रीम कोर्ट. Obligate dicta is equally binding on the lower courts. Supreme Court में binding नहीं है वो. And that is not an Article 141 law when obligate dicta is given. So obligate dicta is contextually it is relevant. Bharti Airtel was an extension of Safari. Yes.
Bharti Airtel actually it was tested on its functionality test. The function of this mobile tower is to transmit sound frequencies to the
yes, sir.
unit, and it connects the two intended user who are intended users. That's why it's a plant.
Honorable bench, may I start with? My lord, the appellant is a registered taxpayer firm dealing in a construction business as work contract service provider by way of contracting for asset owners. The appellant has constructed a ready-to-mix plant at his site to prepare cement mixed concrete, basic ingredient for construction, to be used in construction work that appellant does for the asset owners. This appeal challenges the denial of input tax credit to the tune of 36 lakh rupees availed on this ready-to-mix concrete plant installed at the appellant site. This plant is not a civil structure, my lord. This plant is not a civil structure, nor it is a factory building. It is a plant and machinery required to manufacture critical input, concrete mixture with cement for construction business of the appellant. The plant is exclusively used for producing ready-mix concrete for taxable outward supplies. All procedural requirements under Section 16 of the DGST Act have been complied with. There is no dispute in this regard, and the plant was constructed for business use only. My lord, the key question before this honorable tribunal is whether under the circumstances explained as above, the authorities below were justified in challenging the input tax credit on construction and use of ready-to-mix concrete plant used in course and furtherance of the business of the appellant. More so, under the exclusion clause of Section 17(5) subclause D of DGST Act, and whether the case is fully covered by the judgment of Safari Retreat of the Honorable Supreme Court of India. My lord, I would like to read Section 17 subclause D along with the explanation. May I? Yes. Thank you, sir. My lord,
Section 17, apportionment of credit and blocked credits. Section 17, subsection 5 read as, notwithstanding anything contained in subsection 1 of section 16 and subsection 1 of section 18, input tax credit shall not be available in respect of the following, namely, subclause D, goods or services or both received by a taxable person for construction of an immovable property other than plant and machinery. My lord, it's plant and other than plant and machinery on his own account, including when such goods or services or both are used in the course or furtherance of business. Explanation says, for the purpose of this chapter and chapter 6, the expression plant and machinery means apparatus, equipment and machinery fixed to the earth by foundation or structural support that are used for making outward supply of goods or services or both, and includes such foundation and structural supports but excludes land, building or any other civil structures, telecommunication towers and pipeline laid outside the factory premises. My lord, this exclusion clause specifically allows ITC for plant and machinery, thus carving out an exception from the journal restriction. My lord, I would like to draw your attention. The learned Joint Commissioner appeal has rejected my appeal on the following grounds. Sir, I am reading those grounds with your permission. May I, sir? Yeah. Sir, it's written there. I have also examined the provisions of section 16 of the DGST Act and section 17 subsection 5 of the DGST Act. While ITC is available to an SSC registered under GST law in respect of goods and services used in the course of business or for furtherance of business, certain credits are blocked and are not eligible for availment. One such restriction is provided under section 17 subsection 5 subsection clause C and D of the Central Goods and Services Act 2017 in respect of goods and services procured for construction of an immovable property. The proper officer, after examining the law on this issue as above and after carefully going through the Supreme Court judgment in the case of safari retreats, came to the conclusion that the taxpayer is not entitled to the relief. I have also carefully heard the counsel Ms. Rashmi Jain CA, who have vehemently argued in favor of the taxpayer and has reiterated the grounds of appeal. She has cited many judgments that define plant and those are quoted in safari retreat judgment of the Supreme Court. I have gone through the same carefully but unable to support her arguments. The plant was constructed by the appellant on his own account and for his business, and this is fully covered by the provision of the Act in section 17 subsection 5 quoted herein above. My lord, in other words, we can say that the learned Joint Commissioner appeal failed to appreciate the law laid down in safari retreat. The relevant paragraph of this judgment that was quoted and argued at length has not been discussed at all by the Joint Commissioner appeal. My lord, I would like to read para 16 subclause C of the safari retreat judgment with your permission. May I, sir? Sir, I am reading para 65 subclause C of the safari retreat judgment. It reads as follows. The question whether a mall, warehouse or any building other than a hotel or a cinema theatre can be classified as a plant within the meaning of the expression plant or machinery used in section 17 subsection 5 subclause D is a factual question. So it is a factual question which has to be determined keeping in mind the business of the registered person and the role that building plays and the role that plant and machinery plays in the said business. If the construction of a building was essential for carrying out the activity of supplying services such as renting or giving on lease or other transactions in respect of the building or part thereof, which are covered by clause 2 and 5 of schedule 2 of the CGST Act, the building could be held to be a plant. My lord, based on the factual question, building to be held as a plant. Then it is taken out of the exception carved out of clause D of section 17 subsection 5 to subsection 1 of section 16. Functionality test will have to be applied to decide whether a building is a plant. फंक्शनैलिटीज डिसाइड करना है तो उसको वो प्लांट बनेगा. Therefore, by using the functionality test in each case on facts in the light of what we had held earlier, it will have to be decided whether the construction of an immovable property is a plant for the purpose of clause D of section 17 subsection 5. My lord, now in our case, the question whether ready to mix concrete plant can be classified as a plant within the meaning of the expression plant and machinery used in the section 17 5 subclause D of DGST Act is a factual question which has to be determined keeping in mind the business of the registered person and the use of this ready to mix concrete plant for supplying works contract service for the asset owners. Sir, the business of the appellant is construction. He is providing construction services to the asset owners. This plant is an operational necessity for the business of the appellant. The ready to mix concrete plant is directly linked to the output supply of works contract service by the appellant and satisfies the functionality test laid down as mentioned above. My lord, I would like to draw your attention on the recent judgment of Bharti Airtel of Supreme Court pronounced on 8th August 2025, wherein Supreme Court upheld the decision of Delhi High Court dated 12th December 2024 allowing input tax credit on telecommunication towers. Sir, the judgment is attached herewith. The Supreme Court reaffirmed that telecommunication towers, though fixed, are not immovable property but qualify as plant and machinery when functionally integral to business operations. The court rejected hair-splitting distinctions between pre-GST and GST regimes, holding that ITC denial applies only to immovable property. My lord, in our case, the ready-to-mix plant is integral to the appellant's construction business and it falls within the statutory exception to clause 17(5) subclause D. Sir, my lord, in Bharti Airtel, Delhi High Court, the tests of permanency, intermittency, functionality and marketability are discussed at length. Would the bench would like me to read those paragraphs? Sir, I am reading paragraph 16. That's on page 17. Yes, sir. High Court judgment of. Page 17 of the judgment, sir. So, para 16. Tested on the aforesaid precepts, it become apparent that the stand taken by the respondents, namely of telecommunication tower being liable to be viewed as a immovable property, is rendered wholly untenable, as the Supreme Court held in Bharti Airtel telecommunication tower would clearly not qualify the 5 fundamental aspects which define an immovable property. It was found that they neither qualify the test of permanency nor can they be said to be attached to the earth. Mobile tower, it was held, could be dismantled and moved, and that they were never erected with an intent of conferring permanency. This placement on concrete base was only to enable those towers to overcome the vagaries of nature. Therefore, there cannot possibly be a doubt with respect to telecommunication towers being movable property. Para 17, sir. Turning then to the provision of section 17 subsection 5 itself, it is pertinent to note that the said provision set out various goods and services which would stand excluded from section 16 subsection 1 and thus not liable to be taken into consideration for the purpose of availing input tax credit. Amongst the various goods and services which find mention in subsection 5 are those received by a taxable person for construction of an immovable property. Clause D of section 17 subsection 5 also excludes from immovable property plant or machinery. The expression plant and machinery has been defined by the explanation appearing in section 17 subsection 5 to mean apparatus, equipment and machinery fixed on earth by foundation or structural support. However, it is specifically excludes telecommunication tower from the ambit of the expression plant and machinery. So, para 18. In our concern opinion, the specific exclusion of telecommunication tower from the scope of the phrase plant and machinery would not lead one to conclude that the statute contemplates or investigates telecommunication tower to be immovable property. Telecommunication tower would in any event have to qualify as immovable property as a precondition to fall within the ambit of clause D of section 17 subsection 5. This exclusion, their exclusion from the expression plant and machinery would not result in it being commonly held that they constitute articles which are immovable. So, para 19. The decision in Vodafone mobile service as well as Bharti Airtel, though rendered in the context of the 2004 rules, have on application of the generic principle which would apply to the concept of immovable property, have in explicit terms come to conclude that telecommunication towers are liable to be treated as movable. In view of the aforesaid, we have no hesitation in coming to the conclusion that telecommunication towers would not fall within the ambit of section 17 subsection 5 subclause D of the CGST Act. The denial of input tax credit consequently would not sustain. My Lord, I would like to sum up my pleading. My Lord, that the input tax credit claimed and utilized by the appellant is fully covered by the judgment of Safari Retreat. Further, wherein the Honorable Supreme Court had laid down this principle of law of functionality test, and in the case of the appellant, this test is fully justified. The ready-to-mix concrete plant is not a factory building, but a plant and machinery required to manufacture critical input, concrete mixture with cement for construction business of the appellant, and hence input tax credit availed and utilized is fully justified. My Lord, I pray, in view of the above factual and legal metrics, it is respectfully prayed that the order by the lower authorities be quashed and all proceedings be stopped. Any other relief that this Honorable Tribunal may deem fit and proper may also be given. It's prayed accordingly. Sir.
Did you ever file a copy of your balance sheet and depreciation charts below the authorities police statement?
Yes, sir.
My question is that did you ever file balance sheets and depreciation charts?
Sir, my case is start from the audit by the departmental audit team.
Okay.
Then after the auditor informed my jurisdictional officer about his findings that we have claimed the input tax credit on the RCM plant.
Correct.
So there all the things were...
no, while demonstrating that this ITC should be allowed.
Yes, sir.
At that point of time, before the adjudicating authority,
yes,
audit team is a different team. This tribunal has already held regard for that.
Yes, sir.
And your adjudicating officer is a separate person. He has to decide your case on the information, facts and details available in his file, as
yes,
well
sir.
as details, information and documents which you will produce
yes,
before him. My simple question is that did you ever place balance sheets, depreciation
yes,
charts,
sir, we have filed.
copy of invoices
before
the adjudicating authority or before the first appellate authority?
Sir,
because I was not able to locate those things in your documents, and neither in the orders which have been framed by the officer. He has also never mentioned that all those things were placed or books of accounts were placed or something like that.
Sir,
so that's what I am asking you this.
Sir, we have filed and the officer while जब ऑफिसर ने SCN दिया है सर, वहाँ पे उन्होंने हमारे कुछ सिर्फ बिल्स का मेंशन किया जो कि स्पेसिफिकली उन्होंने इस इनपुट प्लांट के लिए SK मेटल्स की मंगाए थे. बाकी चीजों का
वो चीजें अलग है. मेरा क्वेश्चन सिर्फ ये है कि क्या आपने इसको बिल्डिंग के अंदर वहाँ पे दिखाया है RMC को बैलेंस शीट में, बिल्डिंग में दिखाया है, प्लांट एंड मशीनरी में नहीं दिखाया?
सर हमने प्लांट एंड मशीनरी में दिखाया है, उसका डेप्रिसिएशन भी क्लेम किया है.
मैंने आपसे अभी पूछा, आपने आरएमसी प्लांट को बिल्डिंग में दिखाया, आप कह रहे हैं हाँ जी मैंने बिल्डिंग में दिखाया।
सर हमने
आपको मैंने फिर देखो, मैं जब कोई क्वेश्चन पूछता हूँ ना, प्लीज़ उसको केयरफुली सुने और उसको आंसर करें। मैंने आपसे कैटेगरीली पूछा, आपने अपनी बैलेंस शीट में उसको कैपिटलाइज जो किया वो बिल्डिंग में किया?
नहीं सर,
आपने बोला हाँ जी मैंने बिल्डिंग में किया।
नहीं सर, सर प्लांट एंड मशीनरी में किया।
So how it will be substantiated that you have shown it as under your plant and machinery?
Sir, please
Plant
repeat.
and equipment, there is one head. Sir, equipment, plant and machinery.
जी sir.
So, you see, you have to show either as a plant or building, land, building, plant and other machinery. So, under which head you have classified in your balance
Sir,
sheet?
plant and machinery.
Plant and machinery.
Yes, sir.
So, did you file balance sheet and,
Yes, sir.
and list of fixed assets?
Yes sir.
But that is not available here.
It is not available here.
Sir, I will provide it again.
You should have provided before the first appellate authority, or at least here also in your paperwork, which you have not done so. Anyhow, dear sir, whether you want to say something in it?
Your Honor, in the order is written, this has been capitalized as what the order is silent.
It has been capitalized, that's what I'm asking.
It has been capitalized, order is mentioned. And on law issue, I think it lost to evolve. It should go back, matter should be remanded with the directions of the tribunal to go through their balance sheet, what they have done. Because simply for the sake of argument, you say it's a plant and machinery, that could be good.
Yeah.
But somebody has to find out. Yes.
So let me come to the, because time is running out, there were many other things which I thought I will do. I'll straight away come to the order. Appellant is instructed to file copies of balance sheets, depreciation charts and copies of invoices of RMC plant purchased and installed by the appellant along with IA by tomorrow morning here. The matter is remanded back to adjudicating authority for limited purpose of verification of nature of work contract transaction from the invoices of your suppliers and to verify that if the RMC plant is capitalized under the head plant and machinery or not. If the invoices pertaining to work contract for RMC plant comply with the requirement of section 16 and the RMC plant is appropriately disclosed in the balance sheet under the head plant and machinery, then the claim of input tax credit shall be admissible. Accordingly, the order is passed by first appellate authority, stands set aside. All rights and contentions of both the parties are expressly kept open.
Now there was a question by Ankit that the telecommunication towers were excluded for the purpose of 17.5D. This point was taken in Bharti Airtel. Bharti Airtel said that simple exclusion doesn't mean that they were declared immovable property. Right? So when you read an explanation cannot be outside the law. Explanation can clarify a legal position. So if through an explanation you exclude certain things, but those things are covered by the main law, explanation will not deny you the benefit. Right? So in Bharti Airtel they...
With the permission, with the approval of my council, GST council, they will remove it from the statute now. Pronounced by Supreme Court. Now it will be deleted with the permission of our GST council.
नहीं सर इस पे नहीं है, आप इस पे अमेंडमेंट नहीं करेंगे. प्लानर मशीन ने तो कर दिया. सफारी के बाद they will have to wait for the remand order.
It has been categorically written in section 6, subsection 6 of section 17. Now it will be removed. That will be with the permission of GST council.
Let's see.
Now it will not stand.
Sir, quick, but
not
very
stand
quick
in the
discussion.
statute.
Hanji.
In my mind, the order is little out of the law. Even if the said R&M plant is classified as a building and that building is used as a plant, simply because of the fact that it is used.
No, ITC is available. Supreme Court says so. ITC is available. No, it is available, sir.
Then by
no, we are not on that question of building. The case question is about limited to RM plant. Even if a building is immovable, doesn't matter. It has to come in the exclusion clause as plant and machinery. I told you in the beginning remarks.
Sir, Mr. Verma, I beg to differ.
Sir.
Sir, if it is classified under the head building, building means छत, boundary wall, दीवारें, वो. तब उसका नहीं मिलेगा. Until and unless that building, that मैं सुपर स्ट्रक्चर या कमर्शियल या कंक्रीट की बात नहीं कर रहा. कंक्रीट में तो जो ब्रिक क्लीन सारी होती है, जो ईंटों के भट्टे होते हैं, वो सारे के सारे ही उसी में बनते हैं. बॉयलर्स जितने मोलेसिस जिसमें उबलती हैं वो भी सारे आरएमसी उसमें कंक्रीट के होते हैं. बट दे आर classified as they are classified.
But Supreme Court says something else.
No,
let
but
me
they
read
are
Supreme Court
classified
to you.
as. I'm
On
just
building,
telling.
let me read Supreme Court to you straight away. We
Yeah,
need to
please
ask
tell
you.
me. Tell.
The question whether a mall, warehouse, or any building other than a hotel or cinema theatre can be classified as plant within the meaning of the expression plant or machinery used in section 1750 is a factual question which has to be determined keeping in mind the business of the registered person and the role that building plays in the said premises. If the construction of a building was essential for carrying out the activity of supplying services such as renting or giving on lease or other transactions in respect to the building which are covered by clause 2 or so and so, the building could be held to be a plant.
It has to be held to be a plant. तो उस बिल्डिंग को आपको अपनी बैलेंस शीट में क्लासीफाई जो है सर ना उसका बड़ा फर्क पड़ेगा सर. अगर उसकी क्लासिफिकेशन वहाँ पे गलत हो गई तो उसका सारा का सारा रोल गलत हो जाएगा.
लेकिन सर क्लासिफिकेशन फॉलोड बाय अकाउंटिंग स्टैंडर्ड्स, उसमें कानून क्या करेगा?
Sir, the building has to be categorized.
नहीं उसने अप्लाई किया, उसने उसको रिपोर्ट को फॉलो नहीं किया उसने.
Land building, but there is listen please listen. That has to be, this building has to be classified in the final accounts according to the accounting standards, not according to other laws.
Yeah.
So that has to be classified under the head of building, and depreciation is applied accordingly.
Depreciation में आपको ITC नहीं मिलेगा. बस.
Income Tax Act, Section 32. So that will not change that it will.
Legal position will not change because of classification of balance sheet. But yes, the order is correct of the tribunal to the extent कि आपने किया क्या RMC plant का, किया क्या आपने?
My question is different. My question is that adjudicating authority ने मेरे जो भी मैंने फाइल किया उसको उसने एक्सेप्ट किया.
नहीं किया ना, उसने रिजेक्ट किया.
नहीं एडजुडिकेशन ने ऑडिट लेवल पे आया सर.
नहीं उसने रिजेक्ट किया. ऑडिट उससे पहले हुआ, ऑडिट उससे पहले हुआ. पहले हुआ, ऑडिट पहले.
ऑडिट लेवल पे आया तब.
I request everyone to please maintain silence.
रिपोर्ट भेजी उसके बेसिस के ऊपर उसमें रिकमेंड की उन्होंने, ऑडिटर से रिकमेंड करे. हां जी. उस पे उस टाइम पे उन्होंने इस चीज को माना.
नहीं माना ना, उसने आईटी से मना किया ना. आईटी से मना किया वरना केस को बनता है.
ITC was denied.
चलो नेक्स्ट.
सफारी रिट्रीट में सुप्रीम कोर्ट ने माना प्लांट माना और कहा का आईटीसी मिलेगा.
मैं कहाँ माना सुप्रीम कोर्ट ने, कहाँ लिखा आईटीसी मिलेगा?
नहीं आईटीसी प्लांट
कहाँ लिखा?
बिल्डिंग को
आपने पल्ले से नहीं लगाओ.
मॉल वगैरह
ये यूपी के भाषा नहीं बोलो, कल लिखा, कहाँ लिखा? रिमांड किया केस को, ये प्रिंसिपल्स दिए उन्होंने. अभी तो उड़ीसा हाईकोर्ट जब सुनेगा तब की बातें हैं, तब तक लड़ाई करो.
लेकिन गवर्नमेंट ने उसको प्लांट और मशीनरी की जगह प्लांट एंड मशीनरी.
They have only basis of functionality test they have classified. But so far as representation in balance sheet, that will not change its character. It will stand.
Let's clap for Rashmi Jain, our deputy convener. Beautifully argued. अभी भी तुम्हारे को गुस्सा जो आता है कंट्रोल कर लो. गुस्सा नहीं आना चाहिए लॉयर को कभी भी. The order could be totally wrong. Tribunal can say anything. You still have to bow down before the court. Learn it.
Sir, can I just take 10 seconds of break?
Only 10 seconds.
10 seconds. Friends, firstly, today I had a little heartbreak. Somebody asked me कि आप मजनू बन के क्यों आए हैं? So मेरे actual में factual answer is क्योंकि आज मुझे डिबार कर दिया गया था आज के moot session से because I was delayed.
Indisciplined.
Because
you say that I was indisciplined as a senior member of the group. No, he was barred, no doubt about it.
I was debarred.
Indiscipline not to be tolerated.
Present my matter because I could not submit apostrophe of just one day. But I do accept that.
Not one day, you wanted 1 week time.
Sir, I wanted only 1 working day extra. But any which ways, debar is debar. As I said, limitation, the clause of limitation is over, so it's over. As our chief says that even the Supreme Court won't help you. So I understand.
In this case, Supreme Court won't help you.
Yes. So this reminds me of a quote क्योंकि आज मैंने अपना quote बोला नहीं था. So before I take off my quote, I want to quote the quote. Just a small line which probably could be a tribute to our chief, Shri SV sir. What he thinks for all of us is, give a man a fish, you feed him for a day. Give a man a fish, you feed him for a day. But if you teach him how to fish, then you feed him for the life. Thank you.
Well done. Beautiful. क्या क्या
रश्मि मैम के सबमिट करे हुए डॉक्यूमेंट्स लोअर अथॉरिटी ने अपने ऑर्डर में कंसीडर नहीं करे या ऑर्डर में मेंशन नहीं करे.
देखिए ऐसा है उस केस के अंदर
बोल रही है
ऐसे
एक
नहीं, अगर मैं आपको बता रहा हूँ उसका तरीका क्या होता है. अगर रश्मि मैम ने किए होते तो उनको चाहिए था जो पेपर बुक उन्होंने सबमिट की है एपलेट अथॉरिटी पे, चाहे वो फॉर्म में, चाहे वो फर्स्ट एपलेट अथॉरिटी पे की या यहाँ की, उसके अंदर आपको अपनी जो रिप्लाई होती है, रिप्लाई के साथ जो आपने साथ एनक्लोजर्स लगाए होते हैं वो लगा के आपको अपने पेपर बुक में देनी चाहिए. चाहे वो पेपर बुक आप किसी भी स्टेज पे फाइल कर रहे हो, जिससे कि आपने जो चीज़ आपको पहले अपनी इनोसेंस खुद प्रूव करनी है इससे पहले कि कोर्ट आपसे पूछे या आपको मौका दे. बहुत बड़ी जजेस जो होते हैं वो आपको मौका ही नहीं देते, सीधा डिसमिस कर देते हैं. करेक्ट. तो इसलिए आपको चाहिए अपनी पेपर बुक जब भी आप प्रेजेंट कर रहे हैं, पहले तो आप अपील फाइल करते हैं, उसमें तो आप एक ब्रीफ ग्राउंड्स और ब्रीफ फैक्ट्स बना के लगा देते हैं. उसके बाद जब आप पेपर बुक बनाते हैं तो पेपर बुक में जो पहला नोटिस, जैसे मैं आपको इनकम टैक्स की बात करूं अगर, तो जो पहला 143(2) का नोटिस आता है जहां से प्रोसीडिंग हमारी शुरू होती है, उस नोटिस से लेके और आप जब आपको 143(2) का नोटिस आता है आप लोग साइलेंटली बैठ जाते हैं. सर 2 मिनट ले रहा हूँ सुशील जी.
सर प्लीज कैरी ऑन.
लेकिन आप उसके अंदर क्योंकि कहीं पे कोई कंप्लायंस की डेट या कुछ लिखा नहीं होता, सिंपली होता है कि आपका केस स्क्रूटनी में लिया गया, आपको उसका भी जवाब, क्योंकि आपका जो नोटिस आता है वो ई पोर्टल पर आता है. ई पोर्टल पे आता है तो वहाँ पे आपके पास ऑप्शन आती है, विंडो आती है फाइल रिप्लाई. वहाँ पे आपको रिप्लाई बॉक्स पे आप सोचते हो इसमें कुछ लिखा तो नहीं, मैं क्यों रिप्लाई करूँ. अरे नहीं भैया, आपको वहीं से स्टार्ट कर देना है कि आपने ये नोटिस भेजा, मेरे को नोटिस मिला, इसके अंदर कुछ नहीं लिखा हुआ, इसलिए मेरे को प्लीज़ बताया जाए क्या कंप्लायंस मेरे को करनी है. करेक्ट. उसमें से 2 लाइनें लिखी होती हैं कि यू गिव द डिटेल्स एंड सबमिशंस which you are relying on, the income which you have filed in your return, which is a very vague and very big thing. तो आपको उस चीज़ को रिबट करते हुए लिखना है कि आपने ये मांगा है मेरे से, तो मेरे को स्पेसिफिक दो और बाकायदा लिखो कि 142(1) इशू करो. उसके बाद 142(1) आपको इशू हुआ, आपको 4 142(1) इशू हुए, 5 हुए, तो डेट वाइज 142(1) का अपने कंप्यूटर्स में फोल्डर अलग बनाओ, जिस समय आता है उसका रिप्लाई बनाओ. वो इसलिए आपको ऐसे ही मेहनत करनी है क्योंकि जब आपको उसकी अपील फाइल करनी है तो आपको उस समय वो सारी चीज़ें वहाँ पे लगानी है.
Thank you, judges, SV sir and Rashmi ma'am. Our next item is item number 7, represented jointly by Advocate Nikhil Agrawal and Advocate Abhishek Bansal. Concept of transfer of development rights from landowner to the builders for development of the project, their taxability, pre-GST and post-GST projects, and their implication, along with the interpretation of the final notifications on this issue. Another very important issue for the real estate and the best prepared duo to argue. Final observations by SV sir thereafter. Thank you. I request everyone to maintain silence please during the court proceedings. Thank you.
This is an appeal filed by these duo of lawyers. It has three controversial issues. It has an implication of transfer of developmental rights. It has 2 implications. One is the contract was entered into prior to GST era, implemented post GST era. So there are both amounts before 1717 and post 1717. Then we have to understand what is the implication of TDR. With TDR there is another concept, especially in Western India, is called floor space index. If you have constructed a building, you can buy additional floor space from the government. That is 4 floor ban gayi, government कहती है 1 floor और बनाओ, इतने पैसे दे दो, we will give you a revised map. Right? Now that building may be owned by you, may be leased to you. In both cases the additional FSI is given. दिल्ली में जब इतना नहीं है ये, लेकिन बाहर ये ऐसा वेस्ट में बहुत है, क्योंकि प्रॉपर्टी इज वेरी एक्सपेंसिव देयर, राइट? नाउ द थर्ड इज where you do not transfer the development right, you sell it. कहते हैं पूरी बिल्डिंग बना ले, 4 फ्लैट तेरे 4 फ्लैट मेरे, right? This is a third issue on this particular issue. There is a judgment of, it's not mentioned in their appeal, nor I am going to discuss, there is a judgment of Pratibha Construction versus State of Telangana. It's a Bible on TDR. There the petitioner took a point that TDR is not, we are not liable to TDR reverse charge on various grounds. Supreme Court refused to stay the judgment and directed the petitioner to deposit tax, TDR. Final order is yet to be, this is the final theory on TDR. Now there is a Bombay High Court ruling that I will discuss in my arguments, why TDR, why tax on TDR cannot be had. So this is a very controversial issue of joint developmental, landowner to builders, etc., all these issues. But then there are 3 notifications that these gentlemen are going to interpret in their own favor, why TDR is not applicable. So hold on to your seats. This is a very interesting topic and very relevant for the entire country. क्योंकि सब जगह अपार्टमेंट एक्ट है, अपार्टमेंट बन रहे हैं, हर जगह है पूरे हिंदुस्तान में. इसमें कॉन्ट्रैक्ट्स की बहुत दिक्कत है. आपके लिखने से कुछ नहीं होने वाला. आप जी अपील में कुछ भी लिखें, मुझे देखना है कॉन्ट्रैक्ट में क्या दिखाइए, राइट? सो ऑल दिस इंफ्रास्ट्रक्चर रिलेटेड इश्यूज दे फ्लो फ्रॉम द कॉन्ट्रैक्ट्स. तो जब भी आप कभी अपील बनाएं रियल टाइम, इससे ओनली मूट कोर्ट, यू हैव टू फर्स्ट गो थ्रू द कॉन्ट्रैक्ट के कॉन्ट्रैक्ट में आपके राइट्स क्या थे, उसमें क्या आपके ऑब्लिगेशंस थे. स्टैट्यूट डज नॉट कॉस्ट एनी ऑब्लिगेशन ऑन एनीबॉडी. और बोला भी जिसने सप्लाई की उसको टैक्स देना है और जहां से मर्जी लाए. तो इसमें जो डेवलपर है उसको आरसीएम में टैक्स देना है, लैंड ओनर की आपको लायबिलिटी नहीं. लेकिन एक नोटिफिकेशन से पहले लैंड ओनर्स की भी लायबिलिटीज थी. दैट वाज, इट वाज फॉरवर्ड, नाउ इट इज रिवर्स. सो ऑल इंफ्रास्ट्रक्चरल इश्यूज ऑलवेज कीप इन माइंड दे फ्लो फ्रॉम कॉन्ट्रैक्चुअल ऑब्लिगेशंस. कानून बहुत बाद में आता है. जेडीए कॉन्ट्रैक्ट है, ट्रांसफर ऑफ डेवलपमेंट राइट कॉन्ट्रैक्ट है, गवर्नमेंट ने आपको एफएसए बेचा कॉन्ट्रैक्ट है, आपने बिल्डिंग बनाई कॉन्ट्रैक्ट है, आपने फ्लैट बेचे कॉन्ट्रैक्ट है. सो यू कैन नॉट गो आउट ऑफ दोस कॉन्ट्रैक्ट्स. सो फॉर एग्जांपल वन ऑफ द अपील्स वी हैव विकास गर्ग, ही से नहीं हमने तो ये बाद में स्कीम चला दी थी. अरे कौन सी स्कीम चलाई, कहां से लाए आप? सो इफ यू वांट टू अमेंड ए कॉन्ट्रैक्ट, you have to amend the contract, inform the concerned authorities. You are dealing with land. आपने 12 मंजिल की 50 मंजिल बनानी है, अपने बना लेंगे आपस में अमेंडमेंट करके. So there are collateral laws of land and building, MCD, which get involved. आपको कंप्लीशन सर्टिफिकेट देना है किसी ने, आप अपने बना लेंगे कंप्लीशन सर्टिफिकेट, उसकी प्रोसेस है बनाने की. So you have to go through relevant laws, go through relevant contracts, and then form an opinion. Where do you stand? One wrong opinion given by you, if it goes for next 6 years, अब 6 साल के बाद केस खोल सकते हैं वो, तो 6 साल तक वो गलती आप चलाते रहेंगे, वो धंधा करता रहेगा. 6 साल बाद अगर कोई डॉक्टर राकेश कुमार जैसा कोई आपका जज आ गया तो आपका रिलीफ का कोई चांस नहीं. वो बैलेंस शीट में इतना घुमा देंगे आपको, हमें समझ नहीं आएगी क्या हुआ हमारे साथ. So of the record, yeah, right questions. This is accounting. Accounting is governed by balance sheet. Nothing. हम लायर्स को तो मैं पता नहीं इस चीज का कुछ भी, बट चार्टर्ड अकाउंटेंट्स नो व्हाट दिस बैलेंस शीट मींस. अकाउंटिंग स्टैंडर्ड्स हैव नो प्लेस इन जीएसटी लॉ. ऑल चार्टर्ड अकाउंटेंट्स बी केयरफुल. आप क्या अकाउंट में करते हो, इट्स नन ऑफ द बिजनेस ऑफ जीएसटी लॉ. अकाउंटिंग स्टैंडर्ड्स हैव नॉट बीन अडॉप्टेड इन जीएसटी. जो आप कॉन्ट्रैक्ट्स के रेवेन्यू रिकॉग्निशन करते हो, दैट हैज नो मीनिंग इन लॉ. यू हैव टू गवर्न सेक्शन 1213 ऑफ टाइम ऑफ सप्लाई. मेरे पास एक केस आया था, मैंने ओपिनियन दी थी, उसका सीएफओ बहुत नाराज हो गया मेरे से. मैं कहा तुम किसी कहीं और जाके दिखाओ, अकाउंटिंग स्टैंडर्ड नो मीनिंग, कंटेस्ट इट. सो विद दिस बैकग्राउंड, लेट्स हियर निखिल एंड अभिषेक व्हाट दे हैव टू से.
हेलो.
प्रतिभा कंस्ट्रक्शन वर्सेस स्टेट ऑफ तेलंगाना.
Respected judges, may I? नमस्कार.
The details grounds of backgrounds of my case are as the appellant is a private limited company engaged in the business of development and construction of residential buildings. The appellant is duly registered under the Goods and Service Tax Act and has been compliant with the filing of returns and payment of taxes. The appellant entered into a JDA joint development agreement dated in the year 2015 with the landowner. As per JDA, the landowner transferred development rights over a parcel of land measuring 20,000 square feet to the appellant. The consideration for the said transfer was in the form of constructed area that would be handed over to the landowner by the developer post construction. The GDA was executed in 2015, that is prior to the implementation of GST. 1st July 2017 construction was completed in 2019 and occupancy certificate was obtained only in July 23 from the competent authority. During the course of construction, the appellant sold 7,000 square feet of the constructed area to independent flat buyers. Additionally, 8,000 square feet of the build-up area was handed over to the landowner prior to the issuance of the occupancy certificate. The balance 5,000 square feet remained unsold at the time of receipt of occupancy certificate. The proper officer passed an order dated 24/2/2025 under section 74 of the CGST Act, alleging that the appellant is liable to pay GST under the reverse charge mechanism on the development rights TDR received from the landowner in 2015. The officer valued the TDR at 5,000 per square feet across the 20,000 square feet area and computed a total demand of 50 lakh of tax and 13 lakh 45,000 as interest. The order, however, did not impose a penalty, though it noted that penalty proceedings shall be initiated separately. The officer passed the order only against the appellant developer and did not examine or raise any demand against the landowner under the forward charge. The appellant filed a first appeal before the appellate authority, which was rejected. Wide order dated 30/6/2025. The present appeal is filed before the Honorable Tribunal under section 112 of the CGST Act. Details grounds of appeal. Ground 1. Non-applicability of GST on pre-GST JDA or TDR. In this ground, it is requested that because our JDA was incorporated before the GST regime, so it should not be taxed in the GST regime. No tax is leviable on TDR or floor space index received for construction services where the development agreement was entered into before 1/7/2017. The impugned order therefore violates express department guidance and must be quashed. Ground number second, sir. Lack of legislative competency of tax pre-GST transaction. The transfer of development right occurred before the advent of GST. Applying GST retrospectively to such transactions violates Article 265 of the Constitution, which mandates that no tax shall be levied or collected except by authorities of law. No such authority exists in law to tax with TDR transaction retrospectively. Ground 3. Exemption notification number 4. Fully applies notification number 4/2090 CT rate dated 29/3/2019. Read with notification number 6 2019 CT rate and relevant circulars provide that GST on TDR shall not be payable to the extent flats are sold or transferred prior to occupancy certificate. In the present case, 7,000 square feet was sold to buyer and 8,000 square feet was handed over to the landowner before receipt of the occupancy certificates. Hence, no tax is leviable on 15,000 square feet of the total 20,000 square feet under the said exemption. Next ground is arbitrarily unsupported valuation. The valuation of TDR rupees 5,000 per square feet lacked legal backing. No market valuation, independent valuation certificate or buyer side transaction evidence has been produced by the department. The adoption of this figure is arbitrarily unsupported and against the principle of natural justice and GST valuation rules. Inapplicability of section 74. The invocation of section 74 of the CGST Act is incorrect and without merit. There is no element of fraud, suppression or willful misstatement in this case. The appellant has acted in good faith, fully disclosed all transaction and maintained transparency. At best, the issue is interpretational and fall under the section 73. Next ground is non-imposition of landowner discriminatory assessment. The impugned order raised demand only against the developer without examining the taxability in the hand of landowner under forward charge. This amount to selective and discriminatory assessment, which is impermissible under law and violation of principles of equality before law. Prayer sir हमारी है, in view of the foregoing, the appellant respectfully pray that this honorable tribunal may be pleased to set aside the order dated 24/2/2025 issued by the Assistant Commissioner under Section 74 of the CGST Act, quash the demand of rupees 50 lakh as tax and 13,45,000 interest raised on the basis of reverse charge mechanism. Declared that the appellant is entitled to full exemption of the entire 20,000 square feet area as the transaction of TDR acquired pre-GST and or fall under notification number 4 2019 CT rate. Grant any other relief including consequential benefit that this honorable tribunal deem just and proper under the fact and circumstances of the case. Thank you, sir.
List of enclosures.
Ji sir. Ji sir.
Did you find all these enclosures?
Yes. Yes, sir. Yes, sir.
These are not fresh evidence.
No, just a minute, sir. इसमें से कुछ एग्रीमेंट्स के लिए हमने एडिशनल एविडेंस की एप्लीकेशन लगाई है, सर.
That is at page number?
पेज नंबर 8.
Page number 8.
Yes, sir. Additional evidence by the applicant.
These all are additional evidence.
Yes, sir.
Yes, sir.
तो ये आपने पहले फाइल नहीं की?
जी.
नहीं, सर.
तो ये तो पहले हमारे को देना पड़ेगा डिपार्टमेंट को भी.
दिए हुए हैं सर डिपार्टमेंट, हमने दे दिया. हाँ हाँ.
इसके साथ आपने कोई आईए लगाई और फीस जमा करवाई इसकी?
यस सर.
हाँ, आइए.
सर पेज नंबर 6
में दोनों
5,000 रुपये फीस जमा कराई है आपने?
सर 25,000 रुपये फीस जमा कराइए.
आईए की भी 5,000 रुपये है ना एप्लीकेशन की?
आईए की
एडिशनल एविडेंस जो फाइल किया आपने
नहीं सर, उसकी फीस नहीं जमा. सॉरी
एडिशनल एविडेंसेस कैन नॉट बी
सर. एक्चुअली ये जो एडिशनल एविडेंसेस जो अपील के अधिकारी ने, फर्स्ट अपील ने और प्रॉपर ऑफिसर ने हमसे डिमांड किया था कि आपने जवाब के साथ ये नहीं दिए थे, तो इनको हम चाहें तो एडिशनल एविडेंसेस भी कह सकते हैं और उनकी क्वेरी भी कह सकते हैं जो हम लगा रहे हैं इसमें.
आपकी ड्यूटी वहाँ देने की थी, यहाँ देने की नहीं है ये.
यस सर.
आपने वहाँ नहीं दिए, उसके बेसिस पे आपका ऑर्डर हुआ.
जी.
ना देने पे. तो ये आपने वहाँ पे नहीं दिए, अब आप यहाँ पे दे रहे हैं.
जी सर.
तो यहाँ पे दे रहे तो ये एडिशनल एविडेंस होंगे और क्या होगा?
ओके सर.
सर हम रिक्वेस्ट कर रहे हैं, हम्बल रिक्वेस्ट है सर, हम उसके लिए एक अलग से एक चालान जमा करके फाइल कर देंगे. प्लीज़ कंसीडर.
No, sir, this is a case under section 74. Opportunity should not be given in this case. They have not shown these figures in returns at all. And this 5,000 rupees, the ground they have taken, it is from their documents mentioned in the order. It's mentioned in the order itself. Now, section 74, my lords, if I take up explanation 1, you have to understand where section 74 is invoked. Now read it today. For the purposes of this section, that is section 74, the expression all proceedings in respect of the said notice shall not include proceedings under section 132. Where the notice under the same proceedings is issued, explanation 2 we can forget this is not a case here. For the purposes of this act, the expression suppression shall mean non-declaration of facts or information which a taxable person required to declare in the return, statement, report or other documents furnished under this act, the rule that they are under, or failure to furnish any information on being asked for in writing by the proper officer. So when they have not filed the returns itself, where is the question of an opportunity being given to them now? It's a huge case of suppression. And you know there is a difference. In my opinion, there is serious differences between conditional exemptions and general exemptions. Both cases you have to declare in your return. You can't decide if you are exempt. Whether TDS are payable or not. This is a conditional exemption. Now, even in the JDA file, if you see their documents, why you say why it should not be allowed? See the occupancy certificate, this fabricated document. Page number 43.
41.
43. Just see, this is how much fabrication can take place by the appellant. Certificate number, date of issue, dated 23. So when you are dealing with this kind of fabrication, there is no relief should be granted. The appeal should be dismissed at the threshold. And appeal is not even verified. So that is another suppression. Why was the appeal not verified? No. If you see the grounds of appeal, there is no verification I have seen. No, there is no verification. You have simply grounds of appeal. There is no verification. So once you are dealing with this kind of fabrication, I don't think we should show any concern to them, except they deposit the entire tax and get the opportunity we are willing. Let them deposit the whole tax. Occupancy certificates can't be fabricated.
Sir, verification is at the page number 4.
No, we're talking of grounds of appeal, sir. There's no verification.
You are talking of form.
Yes, sir.
We are talking of form. We are talking of
Appeal.
Page number starting from 10, 11, 12.
Sir, grounds of appeal is a part of appeal form.
No. So occupancy certificate itself is the absolute fabrication. There is no question. Let them deposit entire tax if they want an opportunity, or we strongly say the bill should be dismissed.
Every document, any evidence,
It should be signed as true copy.
whether it is containing 5,000 pages or 5 pages.
Ji, sir.
Each and every page needs to, it is mentioned in DGST Procedural Rules. You have to sign each and every page. ऐसा नहीं है कि first page कर दिया sign और last page कर दिया.
Every page should be signed.
Every page has to be signed. DGST Procedural Rules में बड़ा clearly mentioned. Rule number मुझे ध्यान नहीं आ रहा, बड़ा clearly mentioned.
So they have to deposit entire tax if they want opportunity. Otherwise, this appeals is absolute fabrication stuff. It should be dismissed. No indulgence can be shown to such people who file fabricated documents, who separate, who don't file returns.
Sir,
How can they decide whether it's taxable or not?
Sir,
That means all people in the country will decide that we don't have to pay tax, don't show in returns.
Sir,
We lawyers will be in a paradise.
Sir, it is my humble request that all the
No, sir, the revenue doesn't tolerate fabrication.
Just a minute, sir.
We can show indulgence, but your documents are fabricated.
The whole case is fabricated, sir.
Whole case is fabricated. Your whole case is based on occupancy certificate. Is fabricated.
It is my humble request, sir.
No, there's no request. It's,
No minor
it's a
mistakes.
fabrication I cannot support.
Actually, that verification we would have condoned. We would have given you an opportunity in the interest of actual justice that you refile those papers. But
regarding verification, we would have definitely acceded to your request, but learned DR has brought a very significant fact
that your documents are not genuine. Basic document which is,
They are fabricated, not genuine. They are 100% fabricated.
Sir,
Occupancy certificate is not.
sir, can I say something? Sir, may I?
That cannot be replaced.
सर मैं आई सर डीआर सर ने एक चीज़ बोला कि हमने रिटर्न फाइल नहीं करे हैं, जबकि प्रॉपर ऑफिसर ने एससीएन में क्लियरली मेंशन किया है फ्रॉम द रिटर्न्स फाइल्ड बाय यू इट इज़ क्लियर दैट यू हैव नाइदर पेड एनी आरसीएम नॉट डिक्लेयर्ड दिस ट्रांजैक्शन इन योर रिटर्न. तो इसका मतलब ये तो नहीं है कि मैंने रिटर्न नहीं भरे हैं.
You say have you filed the return?
जी सर.
Have you filed the return?
Yes sir.
Have you indexed
Yes.
copy there? You're picking one sentence.
सर
Have you filed returns?
सर प्रॉपर ऑफिसर
आपने लिखा है किसी अपील में आपने
सर-
रिटर्न फाइल किए हैं?
सर प्रॉपर ऑफिसर ने
Doesn't
जब
matter.
उसके-
Yes.
जब
Agreed.
यस सर यस सर एफिडेविट क्या देंगे प्रॉपर ऑफिसर ने जब उस चीज को खुद माना है कि हमने रिटर्न्स भरे हैं सर
डेफिनेटली सर दे देंगे
डेफिनेटली सर हम दे देंगे सर कॉपीज सर हमने रिटर्न सारे फाइल करे हैं और जो भी हमारे ऊपर टैक्स की लायबिलिटी सप्लाई के ऊपर आ रही थी वो सारा टैक्स हमने जमा किया है एज पर जीएसटी एक्ट लॉ एक्ट और हमारे ऊपर प्रॉपर ऑफिसर ने आरसीएम की लायबिलिटी निकाली है कि हमने जो टीडीआर ट्रांसफर किया है लैंड ओनर ने हमें उसके ऊपर उसने आरसीएम की लायबिलिटी निकाली है सर हमारे ऊपर सर ऑक्यूपेंसी सर्टिफिकेट इन जेन्युइन सर अब सर ये तो हमें डिपार्टमेंट ने प्रोवाइड किया है तो सर उनसे अगर गलती से अगर कोई डेट लिखने से रह गई है तो
You are giving a certificate, but DDA doesn't give you CC here in Delhi. It's under Delhi Municipal Act Section 68.
Sir,
this is totally fabricated.
Occupancy
DDA does not give Basant Vihar completion certificate. DDA has no authority. DDA authority for DDA flats. कानून पढ़ना चाहिए था वही तो मैंने बोला था आपको आपकी अपील के हिसाब से बोला था मैंने
Sir, any
the total fabrication.
Any competent authority has issued that certificate.
My lord, in this case, no intent can be shown. But this honorable court cannot promote fabrication.
जी सर
Then you are writing the chairman will sign the occupancy certificate.
तो इसलिए
for the first time in my life.
ये ऑक्यूपेंसी सर्टिफिकेट जो है टोटल ही जोन से सारा का सारा गलत है मतलब जिसको ऊपर से शुरू करो नीचे तक बिल्कुल लर्नर डियर ने बिल्कुल ठीक कहा कि इट इज साइंड बाय चेयरमैन ऑफ द डीडीए ऑक्यूपेंसी सर्टिफिकेट कभी डीडीए का चेयरमैन साइन करेगा ही नहीं सो हेंस योर अपील इज डिसमिस्ड विद ए कॉस्ट ऑफ अगेन 50,000 rupees to be deposited with.
Next time want to come to Moot 50,000 rupees now.
कॉस्ट ज्यादा लगाने की सोच रहे थे लेकिन 1 लाख ओके विद ए कॉस्ट ऑफ 1 लाख रुपीज टू बी डिपॉजिटेड और फेक डॉक्यूमेंट्स ला रहे हैं आपके अगेंस्ट प्रोसिक्यूशन लॉन्च नहीं करवा रहे हैं
सर फिर भी हम थोड़ा सा आपके मतलब आपसे रिक्वेस्ट करेंगे सर हमें एक बार और थोड़ा सा इसका एक नेक्स्ट हियरिंग का टाइम मिला जाए जिससे कि हम प्रॉपर डॉक्यूमेंट्स
नो
5 लाख हो जाएगा बॉस योर क्लाइंट शुड बी हैप्पी सेफ फ्रॉम प्रोसिक्यूशन
दिस
कभी रियल केस में आना वेयर आई एम द गवर्नमेंट काउंसिल
case is dismissed
I will tell you how do you
your
file
appeal is
fabricated
dismissed
documents.
and with a cost of rupees 1 lakh rupees to be deposited within 2 weeks with Delhi GST Professionals registered.
Thank you. Now the lesson of this appeal is they worked hard on a legal issue. And I told you the infrastructure related documents are document driven appeals. All documents are wrong, including JDA is wrong.
सर
किसी गूगल से कट पेस्ट किया
सर एक चीज बोलूंगा सर एक्चुअली हम लोग तो यूपी में रहते हैं तो हमें मालूम नहीं है यहाँ पर कौन सी अथॉरिटी कौन से डॉक्यूमेंट्स देती है तो सर इस चक्कर में थोड़ा सा
अगर आपको पैन इंडिया अपील करनी है तो पैन इंडिया लॉ आपको जानने हैं सर हाँ जी ऑफ द रिकॉर्ड therefore whatever documents you pick up from Google cut paste do they have to be applied to the recent law मेरा एक वीडियो था कॉन्ट्रैक्ट के ऊपर मैंने डाला था कि लोग ऐसे ऐसे कॉन्ट्रैक्ट बना रहे हैं जो कंपनियों को पूरी तरह मरवा दिया आर्बिट्रेशन में आर्बिट्रेशन जज सेज नो वी कांट गो बियॉन्ड दैट कॉन्ट्रैक्ट आप जो मर्जी बोलो अरे बैट खत्म हो गया कब का वो भी बैट लिखा है एक में दिल्ली सेल्स टैक्स एक्ट लिखा है
थैंक यू
But they made out a very good case lab legal. They even gave a Bombay High Court ruling I was talking. Well done. घबरा गए क्या? Well done. हाँ, legally अच्छा बनाया था आपने. Yes.
Thank you, judges.
So remember, this transfer of development right, it follows the real estate taxation. The default rule is, अरे सुनो, शांति शांति. The default rule is that TDR is payable only what is left immovable. If you have sold under construction, TDR applicability is governed by notification 21. If you are using only for residential purposes, there are separate rules. But something which you have kept back and you are selling after occupancy, so like there is no GST leviable, there is no TDR leviable also. Yes, so this is the basically default principles regarding TDR. ये बहुत बड़े मैटर जैसे आप आईटीसी से करते थे ना इनकम टैक्स में, ये उसका बाप लिटिगेशन है जो आने वाला है आपके पास. दिल्ली में जितने सब रजिस्ट्रार की रजिस्ट्री की गई है पिछले 5 साल में, ऑल इंफॉर्मेशन हैज बीन गैदर्ड ऑन पीडीएफ फाइल. उनको एक नोटिस दबाना है, फटाफट नोटिस फटाफट कंप्यूटर से बाहर निकलेंगे. वोटर लिस्ट नहीं है, ये एक्चुअल डॉक्यूमेंट्स हैं. हाँ, ये वोटर लिस्ट की बात नहीं कर रहे हैं हम, ये डॉक्यूमेंट निकलेंगे वहां से. राइट? So remember, whenever you're dealing with real estate issues, it is your professional job to first tell your client, give me documents. Don't jump के अपने 5-10 लेने हैं, भाड़ में जाइए. वो 10,000 पे आपको बहुत महंगे पड़ेंगे. If you are dealing with a client like me, I will see you in the court and claim from you. You gave me an opinion. So lawyers have a vicarious liability there. We are not immune from giving illegal opinions. So please remember, जब भी कोई ऐसा केस है, पहले आपको डॉक्यूमेंट कराना. अपील फाइल करने से पहले आपको डॉक्यूमेंट 10 बारी देखने हैं. अगर इन दोनों अभिषेक को निकलने देखा होता तो समझ जाते हैं कि डेट इन 23, इसने बोला होगा 23 को डेट लगा दे इसमें, और वो भी फैक्ट्स के खिलाफ है. इनका प्रोजेक्ट 1918 में कंप्लीट हो गया था, तो कंप्लीशन की भी लिमिटेशन है अप्लाई करने की. 5 साल नहीं है सर, किसी भी लॉ में, पूरे हिंदुस्तान में नहीं है. उसकी एक्सटेंशन लेनी पड़ती है आपको कंप्लीशन के लिए भी. वो लॉ आपको लागू करना था. जब मेरे पास आए थे आप अपील ट्रायल में, तब आप ठीक बोल रहे थे, मैंने आपको डॉक्यूमेंट्स नहीं देखे थे. Well done, thank you.
Friends, it's 4:40.
So don't worry about it यार, don't give us time.
सर लोग
अरे कोई नहीं जा रहा है. तेरी शादी होनी है कि घर में 6 बजे?
सर 27 साल पहले हो गई थी. आप वो लोग और सुनना चाहेंगे? चलिए एक ले लेते हैं सर.
ये करना नहीं चाहता ना, डिसमिसल का दौर है, कहता है हमारी भी डिसमिस होनी. तो उसको डर लग रहा है
सर, जिसको एक
डिसमिस होने वाली है. हाँ, लग रहा यही है. इस बिकम ए गुड लॉयर के माहौल देख के चला कि आज मिक्स में क्यों चले, कि वर्मा जी आप अपनी कर लो, मैं अपने बकवास लगवा लूं.
Thank you, judges. I request everyone to maintain silence, please. Thank you, SV sir. And thank you, Nikhil ji.
सितंबर के बाद डीआर क्यों बदल जाएंगे साहब?
Item number. I request everyone to please maintain silence. Sir, please. The next item is item number 8, represented by our convener of the group, Advocate Narendra Ahuja, sir. A semi-constructed building sold claimed as immovable outside the definition of GST law perhaps, claim for tax exemption, compensation received in post-GST regime for an action taken in pre-GST regime, taxability under GST law. A fantastic issue again to be argued by our convener Narendra Ahuja ji, a very important interpretation and applicability of notifications and its ramifications, and the evidentiary value to be produced for claiming exemption. Sir, please.
सारे उन्हीं के नहीं, एक इस गलती से एक ही आई है.
Ahuja is arguing a case on a very crucial issue today. GST law says a property to be immovable for the purpose of GST law when a completion certificate is issued or building is first occupied. Post dates of these two certificates, the building is assumed to be immovable. That is the interpretation of GST law, right? Now, if you do not have these certificates and you are selling a semi-constructed building, we have to deliberate, will this be immovable? Number one. Number two, the tax is levied on works contract service. Tax per se is not on a building. Tax is on works contract service, whichever way is defined. So whether under these circumstances, was there any works contract service? Third issue is, they received some crores of rupees based on a Supreme Court judgment on the pending litigation. Whether that could be taxed under section 142 of CGST Act. Because they are the amount received for services, nothing else, they are a builder. और तो इनको पैसे मिले नहीं, जो भी झगड़ा था 2000 GST से पहले था, बाद में था, जो भी था, पैसे आप मिले हैं इनको, जिसपे उन्होंने apparently सर्विस टैक्स नहीं दिया था. Right? These are the three issues. Yes, Mr. Ahuja.
May I proceed, sir? सर टाइम की थोड़ी सी कमी है तो सीधा मेरिट्स पे आ जाए. शायद मेरिट्स पे आ जाते हैं.
आप थोड़े से ब्रीफ फैक्ट्स.
हाँ, मेरिट्स पे आ जाते हैं सर. तो फर्स्ट, my client is a private limited company who is engaged in the business of construction of building and providing pure service to the government and government agencies for a very long period. He had filed all his returns for the tax period 23-24 for which the audit was conducted and the impugned notice was issued. There were two issues. First one was that we have sold a under construction building of 23 crore and did not show it in the GST return. And the second issue was that we have received a compensation of rupees 2.1 crore which we have claimed exemption. Against litigation, हमारा कोई MCD के साथ we were going into a litigation pre-GST. It was a pre-GST regime. Milord, the proper officer alleged that the impugned notice that the appellant has not declared the turnover of rupees 23 crore on account of sale of under construction building sold to Messrs. SV and Company. Milord, under construction building was sold by my client based on where each and as each basis. He did not provide any construction activities thereafter. We have filed the copy of the sales agreement, page number 27. Para 4 of the sales agreement on page number 27, sir, that shows that the said property is under constructed and possession of the same shall be handed over to the buyer, Messrs. SV and Company, on as each where each basis. The seller is not liable to carry out any construction activities after the execution and registration of the agreement in the name of the buyer, that is SV and Company. The Honorable Supreme Court in the case of Larsen and Torbro Limited versus Union of India 2014 held that work contract taxability arises only when there is contract with the buyer for the construction done before such an agreement is not a service, hence not taxable. Second, the Honorable Karnataka High Court in the reference case of Messrs. Rohan Corporation, मैंने आपको जजमेंट दिए कर्नाटका हाई कोर्ट की. आई एम रीडिंग माई ग्राउंड्स में ग्राउंड्स की कॉपी है सर आपके पास? ग्राउंड्स लगे? अच्छा, वो मैं अपना वन पेजर वैसे ही बोल रहा हूँ, ब्रीफ में बोल रहा हूँ. मैं आपको ग्राउंड से ही बोल देता हूँ. हाँ पेज नंबर 12 पे आ जाइए सर। हाँ जी, पॉइंट नंबर 10, द ऑनरेबल कर्नाटका हाई कोर्ट इन द रेफरेंस केस ऑफ Rohan Corporation India Private Limited versus Union of India, writ petition number 127010 dated 2023, held that when the under construction building is sold on as is where is basis and no further construction is done by the seller. Page number 12 sir.
12 of the judgment.
नहीं 12 of the ground sir. I am reading my ground sir.
जो आपका ये है पेपर बुक, इसका 12 नंबर पेज में।
Yes sir.
इसमें 12 नंबर पेज पे तो
ग्राउंड से सर मेरे
ये रहा, आइए जो शो
ग्राउंड्स देखिए सर, ग्राउंड्स The Honorable Karnataka High Court in the reference case of Rohan Corporation India Private Limited versus Union of India, writ petition number 127010 dated 2023, held that when the under construction building is sold on as is where is basis and no further construction is done by the seller, then this is clearly a sale of the built property and the same falls outside the GST net, regardless of the whether the property is under construction or whether a completion certificate is issued or not. Now we come to the judgment I have given to you. Page number 9 of the judgment. Page number 9 of the judgment says it was submitted that para number 7 sir. Page number 9, fifth line, 7th para. 9 of the judgment, Karnataka High Court. ये छोड़ दो, ये तो उसके लिए थी, तो छोड़ दो उसको। 7. May I proceed? It was submitted that if the agreement with the buyer is entered after the construction and no element of the construction is undertaken after the execution of the agreement, then there is no supply of goods or services between the parties, even if the completion certificate is not received for the said building. It was submitted that even for the supply. Next point. ठीक. Compensation of 2.1 crore received from MCD. That on the circumstances and the facts of the case, my lord, along with the appellant says and submit that he has received a compensation.
Which page you are?
Same 13 number page on my grounds.
Ground number?
Ground number 13. The appellant says and submit that he has received the compensation from the work done from MCD prior to the GST regime, for which he had already paid the tax due as per the then prevailing law of the tax. That the appellant was stopped in midway to construct the fish pond by the MCD, and the appellant has filed a suit for the compensation against the MCD, which took a long way to be settled. The legal notice and the suit is attached as page number 30 of my appeal paper book. Page number 30, legal notice to the MCD. 32, case filed by the my client, and 34 is the order of the court. Hanji, page number 33, so I think. 34. Right, the compensation is received for the work not done by me. That my client was stopped midway for doing the work. Hello. these two grounds हैं सर मेरे। तो कंपनसेशन जो रिसीव हुई है सर कि वो रिसीव हुई है कि हमने फिश पॉन्ड बनाना था, हमें मिडवे रोक दिया गया, हमने उनसे कंपनसेशन मांगी कि हमें कंपनसेशन दो क्योंकि हमारा काफ़ी लॉस हुआ है, तो उन्होंने नहीं दी, तो हमने उनके अगेंस्ट लीगल नोटिस भेजा, सूट किया और कोर्ट ने हमें 2 करोड़ 10 लाख की कंपनसेशन दी है।
You know, first again a case of 74, they did not show these turnover in returns. Had the audit not taken place, non-inspected, they would have got away with this money.
सर माइक ले लीजिए।
It's again a case of section 74 suppression of It's again a case of section 74 serious suppression of facts where they claimed exemption based on their own. Now they want to support this with a judgment which is not relevant in this matter at all to show that this was not taxable. Now this kind of tendency on the part of taxpayers who are registered with the department should be handled with a very strong hand by this honorable tribunal to give a message that this kind of indiscipline is not tolerated. Because it will be impossible for the GST authorities to go on fishing these cases and go on levying tax. They have to be dismissed as threshold. Okay, why did you suppress this turnover? Number one. Number two, he is claiming Rohan Construction. Rohan Construction was a case of refund. It was not case of taxability. Rohan Construction did go through all the Supreme Court judgments and they finally came to a conclusion that this is their opinion. Their opinion, if you are selling a semi-constructed property on which no further work is to be done, then this should also be treated as immovable. This is a High Court judgment of Karnataka, not binding in Delhi.
So this is a GST regime and I think...
Yeah, you can say so. So this is not binding in Delhi because there is no Article 141 on High Courts. And this is only one judgment which goes against the definition of immovable property in the Act itself. Act preconditions occupancy certificate or CC. Only after that property becomes immovable. Semi-constructed property in common parlance definitely is immovable. Nobody can pick it up. But if this happens, I question Rohan Construction judgment. So I sell semi-constructed property, take refund, later on I sell it and construct it again. That is, if it's 80% work done in semi-constructed property on which I have paid input tax credit and I want a refund because I claim this is not taxable. So on 80%, let's say of 80 crores at 18%, I get a refund of 14 crores. I'm a liability. I'm not coming a liability only, Joanna. I'm going to explain that. That is, if you apply the Rohan Construction analogy to this case, I will have very serious questions to ask in terms of law. That is, Rohan Construction says there was no further service to be constructed, so they have drafted that clause right in their agreement made in August 23. Cases of 23, 24. The property papers have not been annexed. When was the property purchased by whom? Nothing is annexed with the appeal. Okay, who gave them this property? What were the property papers? Who constructed it? When was it constructed? And who did they inform this is semi-constructed? There is no structural certificate annexed with this appeal. In Rohan Construction, the certificates were produced. So based on that evidentiary value, Karnataka High Court came to a conclusion that in their opinion, they did not think the definition of immovable property will come in their way of giving refund to the taxpayer who sold immovable property. Now I have a question, if this is to be followed, then this will lead to huge tax evasion. बहुत ज़्यादा इसमें tax evasion होगा. Therefore, in this particular matter, I will have a strong objection. First, they did not file the returns. Second, it's a clear case of huge suppression of facts. Third, they superimposed it's exempt. Karnataka High Court judgment came. See the folly of their argument. When did the judgment came?
2023.
No, this is of 23. When was the order passed?
10th day of September 24.
September 24, the judgment was passed. We are taking off a 23-24. 23-24, they were not even an iota of an order like this. So what they did, they refabricated their story in grounds of appeal, saying कि हमारा ये agreement था. So this agreement they drafted in August 23. The judgment came in 24. Prior to this, judgment was not known to anybody. So what I'm saying is, you suppress facts. You don't pay tax. Then you find a little favorable judgment, you construct your grounds of appeal and come to the tribunal to give us relief. If section 74 is invoked, and this is a clear case of suppression of facts, then no indulgence should be shown, number one. Number two, if at all they have to rely on a Karnataka High Court, Karnataka High Court judgment is not binding upon us. I fully say that this is not applicable to us. In Delhi, it's not binding. Anji? No, not even that. Not even that. See, there is a judgment of Supreme Court. If it is a central enactment, the interpretation given by a High Court should be accepted all over the country. But that judgment was overruled by Supreme Court itself. No, this will disturb the High Court's jurisdiction. That is, if Allahabad High Court say give relief, will all other 30 High Courts will give relief? So those judges' creativity will be blocked. That is why you see 4 or 5 High Court judgment differing, they go to Supreme Court decides. So a High Court judgment is not relevant if it's not of Delhi. I can openly say it's not relevant. It can have persuasive value. They have an interpretation of law which may favor the appellant or may not favor the appellant. Number one. Number two, this compensation received in terms of section 142. Yes. Okay, now
next is this 2 crore 20 lakh fish pound. Right? Though this was created, as per them, is pre-GST regime, the money came in 142. They have not said they paid service tax. So GST in section 142 is applicable. And it is not a liquidated damages. It's a compensation. Compensation is totally different. They have annexed a circular of liquidated damages. And those liquidated damages also have various exceptions here and then, that circular itself. And that's a circular. The law is very clear on this issue. Therefore, I would say if at all their appeal has to be admitted for entertainment, they have to proceed, the stay can carry on, then we would say that this Rohan construction is not applicable. As long as they defied the law given in the Parliament enactment, let Supreme Court decide. Till then, the appeal should be dismissed. Let them also join Supreme Court. If the matter is pending in the Supreme Court, I will say that I should get the stay.
No, but one thing is very pertinent here. That is because it was a
Supreme
supply.
Court
First of all, sir. First of all, I started my deliberation on the merits. First of all, I will say this is not the case of 74. Every case is not 74.
Every case is not 74. That is
every
okay.
Case, 74 is not case.
No, not 74.
I have given the judgment.
It is not 74, but taxability so far as concerned.
Taxability, sir, we have worked on the opinion of the consultant.
Suppress the fact they have not filed returns. What could be more than this?
We have filed the returns, sir.
Liquidated.
सर रिटर्न फाइल किया
They have filed
रिटर्न
the
के
returns.
अंदर
We have
उन्होंने
didn't
जो ये
declare.
एग्जाम्प्ट सेल है वो नहीं दिखाई है लेकिन सर देखिए ऐसा है कि मिस स्टेटमेंट और सेपरेशन में बड़ा फर्क है
बहुत फर्क है
मतलब उसके अंदर क्या है कि एक चीज जो सी है इन अंडर द इग्नोरेंस ऑफ लॉ आर अंडर द मिस इंटरप्रिटेशन ऑफ लॉ आई से नॉट इग्नोरेंस मिस इंटरप्रिटेशन ऑफ लॉ अगर उन्होंने जो उनसे अपनी रिटर्न के अंदर नहीं लिया और उसका एक्चुअली में टैक्स इफेक्ट जो उनसे है वो जीरो ही है तो फिर उस केस के अंदर देयर इज नो सेपरेशन
सर देयर आर टू मिलोड
Sorry?
It case falls strictly in explanation 2 of section 74. Absolutely, there is no doubt.
Milord, how it is it falls under 74?
Let's read this again. Explanation 2, section 74. Let me come there. For the purposes of this act, if this is not a case of section 74, then there could be no case of section 74.
Sir.
Yeah.
Where?
Explanation 2 to section 74A.
74A.
Yes, sir.
You are
Appended to that or not 74A के बाद लगाया.
हाँ जी.
सर 23-24 में 74 था, not
For
74A.
the purposes of this act, the expression suppressor shall mean non-declaration of facts or information which a taxable person is required to declare in the return. It's not declared. It doesn't say misstatement, intention or whatever.
But sir, every non-dec.
Wait, Mr. Counsel, please wait. Statement, report or any other document furnished under this act or the rules made under or failure to furnish any information or being asked for in writing by the, this is all suppression. This tribunal has no jurisdiction to go beyond this explanation.
Explicitly said.
Absolutely, it is suppression of fact litigation section 74.
Suppression.
It has no
Sir,
intention
sir,
कि वो tax
sir,
लगेगा, नहीं लगेगा,
Milord,
of adjudication.
we have.
We are talking of section 74.
We have
because
worked
notice.
on the opinion of the consultant, and we have mentioned in our
No, your
reply to
consultant
the
opinion
proper
has no
officer.
value.
Second,
Consultant can say that you don't pay tax.
second, sir, I have given you the judgment of civil appeal 2289, where the High Court said, no, so far as fraud and collusion are concerned, it is evident that the requisite intent and intent to evade duty to build into these very words. So, as for misstatement or suppression of facts are concerned, they are clearly qualified by the word willful proceedings. Sir, every misstatement is not a
You
willful
don't
statement.
declare turnover of 23
Sir,
crores.
we have worked on the.
And but you said this is not
we
suppression.
have not declared on
you
the.
do not declare of 2 crores
sir,
50 lakh
no,
compensation. This is not a case of suppression.
No.
No. No High Court judgment can be applied here.
Whereas the question of 2.1 crore is stands. We have declared, and 20 crore we did not declare on the basis of the opinion of the consultant.
No, just to sir, Karnataka High Court judgment came in September 24.
Yes.
Where is the opinion of legal? You a lawyer? Next, show me.
Opinion है
Let me see.
हमारा.
The opinion also let me see.
35.
Yes, 35?
Yes.
Okay, I have not gone through. Because normally I think I know law better than anybody else. What is the date of opinion, sir? 10th August 23.
Yes.
And what is his opinion? Based on what? Larson Tubro is not applicable to GST at all. Therefore, we are not following 46th Amendment. Ashok Kumar Jain is totally irrelevant. I know this judgment. बाकी कौन सा आपका है?
यही है, sir.
So this opinion is binding on the tribunal.
No, I didn't say this is binding on the tribunal. I said we
This
have worked on that.
10th August 23. Your case is for 23, 24,
23,
April
24,
23 to
yes.
24.
Hmm.
How did you not file the return prior to this?
Sir, we have filed the returns. Please correct me. I will like to correct you. Okay, we have filed the returns, but did not declare in the returns.
That is the suppression.
That is
Had we not
a
detected,
suppression,
you would have
sir.
gone away with it.
Then why did they go for the 74? They can scrutinize the return. They can issue the ASM
Why?
return.
Law gives me power to invoke 74, even arrest you. Even arrest you under 132. You challenge in courts. We have no objection to it. You can't say that lawyer's opinion is binding on the court. There may be a slight ground to get away from penalties, a lawyer's opinion. Lawyer's opinion don't dictate courts. ऐसे तो सारे को opinion लेके आ जाएंगे हमारे वकील ने बोला था उसने कभी जिंदगी में वकालत ना की हो हाँ जी हम तो मेरे को गवर्नमेंट को तो बनाएंगे ही नहीं ये
क्या कहना ये था अभी वही साहब कह रहे थे कि नेक्स्ट जो 6th जब हो जाएगी उसके बाद फिफ्थ के बाद कह रहे थे कि गवर्नमेंट काउंसिल इमीडिएटली चेंज करो नहीं तो हम कोर्ट नहीं
अच्छा मेरा प्रमोशन होना अच्छा मुझे प्रमोशन की जरूरत है
के बोलने के लिए हमने इसलिए रिजर्व कर दिया। मेरे बोलने के लिए एक सेंटेंस में कोई ऐसा एक मिनट बात सुनो। जब इनको मना कर दिया बीच में बोलने के लिए, उसके बाद आपने 3 बार फिर बोला, तो एक कोर्ट
that definition must be adopted by courts. Unless the Supreme Court says, we read it down to this. They did not read it down. They gave their own interpretation. So I'm not tempted to agree with Karnataka High Court at all. That means tomorrow all High Court say that we have our view is this, our view is this. A definition has been given, follow it. That is now you say, if I all semi-construction properties I sell, I made 20 flats in a building, and the semi-construction के बेच रहा हूँ, मेरा refund दे दो भैया. उसके बाद जो वो फ्लैट ओनर्स हैं वो तुम्हें एंगेज कर लेते हैं कि हमारे कंप्लीट कर दो. So that is a huge amount of money. So the judgment per se doesn't support the law.
No court can travel beyond the legislation.
And then if you are drafting appeals based on these judgments, you have to be careful that you understand the implications. Because we get tempted, High Court है, अरे बना दो appeal यार. Legal opinion ले लो, agreement बना दो, सब बना दो, then in dates you get camouflaged. फंस जाते हैं हम लोग. तो अगर आपको हाई कोर्ट जजमेंट को रिलाई करना है, उस पर और रिसर्च करें आप. आपने कानून को देखें. VKC footstep is the Bible on interpretation of law in GST. वहां जब बोला गया कि ये रिफंड मिलता है, ये कैश रिफंड होना चाहिए, they said no. Law has mandated only 2 grounds for cash refund. That's all. SCZ, 0 rated. और किसी पे कैश रिफंड आपको नहीं मिलेगा. Let us say there are high court judgments. We had one of these appeal, which says कि based on arbitration the date can be extended. अपील हमारे यहाँ वो गुंडा नाइन की फ्लाइट कैंसिल हो गई. No, you can't get refund. Go beyond Supreme Court. Delhi High Court judgment है. How will you go? How will you go there beyond Supreme Court? Delhi High Court को हमने क्या करना है? Well, friends, we have a vote of thanks coming up by Chandresh Gupta ji, and let's give a standing ovation to our 2 senior judges. Sir, no more. Sir, we all bow down before you for your hard work, and lot of learning we had from you by the questions, and we are going to learn more and more. Learn more and more.
Before I request CK Gupta ji for vote of thanks, I request both the judges to present some memento to our new appellant counsels. First one, Nikhil Agarwal and Abhishek Bansal. अरे 1 लाख कल दे देना. देखो देखो जिन जजेस ने कोर्स लगाई उन्हीं से मेमेंटो दिलवा रहे हैं हम. सर केपी सर, अभिषेक बंसल, निखिल सर, ये भी ले लो ना, इकट्ठे डालो.
थोड़ा और एक्सपीरियंस चाहिए.
आज और तो किसी का नहीं है. आज और तो किसी का नहीं है. सर आइए सर, मोमेंटो देने में. सर मोमेंटो तो आपके हाथ से अच्छा लगता है. आइए निखिल जी, केपी सर. Now I request CK Gupta ji for formal vote of thanks.
Respected guests and members, on behalf of Delhi GST Professionals Group, I, CK Gupta, extend our heartfelt greetings to all of you on the occasion of Independence Day. I wish you all a very happy Independence Day. We express our sincere gratitude to Shri Ajay Sinha ji S.C. Bhatia ji, Rajnikant Verma ji, and Shri Sudhir Bhardwaj ji for sparing their valuable time to join us for today's Moot Tribunal. Your constant support and blessings continue to guide and inspire our group. Thank you, sir. We are also thankful to our esteemed judges, Dr. Advocate Rakesh Kumar ji and CA KP Singh ji, for delivering such insightful and well-reasoned judgments in all the appeal matters presented before them. Your contributions have added immense value to this event. Thank you, sir. To all the appellants, your presentation and arguments were commendable. Winning or losing is secondary. What truly matters is the spirit of learning and the effort you put in. You have all done exceptionally well. Thank you. What we can say about SV sir? His role as government counsel was marked by powerful and well-grounded counter-arguments. His energy and passion remains high even during such long hours of intense arguments. His rigorous counter-arguments only help in betterment of the appeal cases and enhancing our learning. This time, it was also a unique experience. अच्छा वो तो हुआ ही नहीं ये केस तो आपका रह गया मैं तो बना के लाया था A special thanks to led by convener Narendra Ahuja for organizing such event with such commitment and hard work. We are also grateful to all the members who attended today's Moot Tribunal, especially those who travelled long distance from Agra, Indore, Rohtak, Karnal, Yamunanagar, Ghaziabad, and many other places. Your participation made this event a grand success and a rich learning experience for all. A big thank you to today's wonderful guests, Poonam Marwa, Mayank Ahuja, and Ankit Mittal. We are also host. We are also thankful to Rajmani Jindal for the excellent supervision for breakfast, lunch, and high tea. Now I request all of you to please join us for the high tea.